product of fraud.
No, Mr. Basu, then you, if you are challenging, then your section 8 you are not pressing.
Cannot place because
We'll record that.
yes.
We are recording that. So then it goes before us, comes before us.
Yes.
Is it ready for hearing otherwise?
For hearing.
Ready for
Any
hearing?
date, short point, whether commercial dispute or not.
Everybody is saying short points.
5 minutes. I will not take more than 5 minutes.
Very short.
I will not take more than 5 minutes.
No,
Whether
no,
it's a
no.
commercial dispute or not, my lord. Agreement for sale per se.
Learned counsel for the appellant submits that the present appeal has been preferred against an order. What was the impugned order you said?
The impugned order was one by which
Transferring the matter to the-
transferring
Yes.
by placing the
An
suit
order
before the commercial court.
transferring the suit filed by the appellant to the
Commercial
commercial court
Rajarhat.
Rajarhat. Push up next para. It is submitted that in any event, since an application is pending at the behest of the respondents in the trial court under sections 5 and 8 of the Arbitration and Conciliation Act 1996, and obviously the respondents seek a reference to arbitration, no useful purpose would be subserved by keeping the appeal or the suit pending. Push up, the appellant submits that the appellant is otherwise agreeable to the matter being relegated to arbitration, and as such, the appeal may be disposed of by appointing an arbitrator. Push up next para. Learned senior counsel appearing for the respondents, however, submits that upon a cautious perusal of the agreement itself, the respondents are now of the opinion that palpable fraud has been perpetrated even in the execution of the agreement containing the arbitration clause, and as such, the respondents do not want to press the application under sections 5 and 8 of the 1996 Act. Puts up in such view of the matter, the prayer for the appellants cannot be considered, cannot be allowed to the extent that the matter be referred to arbitration. Puts up next para. Accordingly, let the appeal be listed in due course for hearing, subject to it being otherwise ready for hearing. It's running in the list.
It was running in the list. And now it is being from the hearing board, it has come to the two mentioned.
It was running before us. The appeal be now listed under the heading for hearing.
We have some precedents.
No question. এটা আবার hearing listed দিয়ে দেবেন. Thank you.
I'm grateful.
Brother or sister? Sister. Our cousin appear করছে. Since the relative of one of us within bracket আমার নাম is appearing for one of the parties, let the matter be released from our list on personal ground with liberty to the parties to seek an assignment before a different. Yes, who is appearing for the petition? Yes, sir. What is the application for?
It is an application for
Calcutta.
restoration.
Achha.
The appeal and the application could not have been dismissed because
Yes.
that is application for substitution. Well, that is also within time, and the heirs already on record on the death of the appellant. That
This restoration application has been filed within time, Mr. Rokit?
Oh yes. No. Condonation of delay.
What is the reason for the delay?
Yes.
Why did you miss it?
Yes. Delay, my lord. Petition number 1 was suffering from various ailments, namely corona, etc., and my lord, chest infection.
Have you given a copy to the other side?
Lord, this is an application. The first time it is appearing, I can serve, my lord.
In any event, the other side was not appearing.
Let's see. But my lord, that application
Yes.
is in time. Substitution application on the date.
So unless we allow the restoration, we can only restore. No, since there is a condonation prayer also, it's have a copy on the respondent. Okay. The present application is one for restoration of the appeal and connected applications on condonation of delay in filing the same. First of the petitioner shall serve a copy of the application on the respondent stroke opposite party, indicating that the application shall be listed on March 24th, 2025 under the same heading, when the appellant stroke petitioner shall file an affidavit of service to that effect. Thanks. Mr. Anit Rokit. You are the, anybody else is appearing? Anit Rokit. Yes,
Lord, my lord,
yes.
appeal on behalf of the ministerial authority. My lord, I am for the respondent, my lord,
Respondent,
my lord, applicant respondent.
right?
Reference case,
Application.
case of compensation. My lord, in the meantime, my lord, during pendency of the appeal, my lord,
Huh?
the claimant, my lord, died. My lord, I have notice upon all the respondent or the authorities,
Uh-huh.
my lord, in 2023, indicating that, my lord, died, and I have given also name of the successors, so that they can substitute the petition.
They have not yet
Not
substituted.
yet substituted.
Therefore, the appeal has abated.
23, my lord.
We will record the abatement subject to their filing an application for substitution. At the time of call, none appears to move the application on behalf of the appellant. Full stop, next para, learned counsel appearing for the respondent submits that during pendency of the appeal, comma, the sole respondent died. Full stop, a communication dated.
Respondent one, my lord.
Acha.
Claimant respondent.
Acha, very well. The claimant respondent number 1 died. Full stop, learned counsel for the said respondent hands over a copy of a communication dated July 26, 2023, which indicates that the respondent number 1 died intestate on June 5, 2023. Full stop, by the said communication, comma, the factum of demise of respondent number 1, comma, the date of death and the particulars of the heirs were supplied to the appellant. Full stop, next para. However, comma, till date, no steps have been taken for substitution of the heirs of the said deceased respondent number 1. Full stop, next para. He was the sole claimant.
I will full claimant.
Very well. Accordingly, for all practical purposes, comma, nothing, for all practical purposes, comma, the appeal has abated. Full stop. Accordingly, comma, FAT 1016 of 2024
No, 2004.
of 2004 is recorded to have abated. Full stop. Consequentially, comma, can 4 of 2020 is rendered infructuous. Full stop. It is made clear, comma, however, comma, that this order recording abatement and disposal of the appeal on such count is subject to any application, comma, if filed subsequently by the appellants, comma, for substitution after setting aside abatement on condonation of delay.
Lord,
The appeal along with the connected application be treated to be disposed of accordingly.
Lord, I may permitted, my lord, to take effect of the, my lord, because to withdraw the amount which, my lord, lying in the, my lord, before the.
Very well. But you have not been substituted. Who are you?
Lord, my successors are there, successors, my lord. I have given the name. They will, my lord,
The successors of the claimant stroke respondent number 1 are permitted to withdraw the amount deposited with the registrar,
register.
with the learned registrar general in connection with the appeal, comma, subject to the satisfaction of the registrar general as to the heirship of such persons. Full stop. Next para. However, comma, it is clarified that this order will be subject to any order, comma, which may subsequently be passed in any application for substitution after setting aside abatement on condonation of delay, comma, if filed on behalf of the appellant. অ্যাপিলটা ডিসপোজাল হিসেবে দেখাবেন, তাহলে এটা পেন্ডিং লিখে দেবে কম্পিউটারে। প্লিজ গিভেন ইয়েস 5 who is appearing
For the respondent number 1 and 2.
1 and 2 respond who is for the appellant. The application is section 5. এই অ্যাপ্লিকেশন
Copy which
কোনগুলো
has been served upon my
অ্যাপ্লিকেশন
client.
গুলো বার করে দিন। ক্যান 1 কোনটা 2 কোনটা 3 কোনটা, আচ্ছা ক্যান 1 2 3 এগুলো লেখা নেই কেন উপরে পেন্সিল unless,
Well, I'm not aware of one. The copy which has been served upon my client is Can 3, an application for appropriate order.
what is that? Appropriate?
Millard, they have prayed for Millard. This appeal was filed in Millard 2017-2024 Millard. They have come up with an application Millard for injunction restraining them, restraining my clients from not to disturb them for repairing work. There is no application for repairing.
There's an application for section 5, under section 5 for delay in presentation of the
Millard,
appeal.
my client has not been served. Only
This is
Can
appearing for the first time today before us. None appears for the appellants stroke petitioners at the time of call, full stop. As a last chance to the appellants to move the applications, the same is adjourned for the day.
No, Lord, I am for the petition.
Application department.
Response 3A one.
Yes. What is the application for?
My lord, restoration 991 days delay.
991. Only 991 days delay.
No copy has been served.
You shouldn't even given any reasons for such a small
I
delay.
have annexed the all.
What is the reason?
No, firstly, after COVID, the matter appeared in the 19th August suddenly. Thereafter, no one attended. And matter.
You have not got a copy?
No. Restoration section 5 application. I have served them all. Restoration application. 4 have come back. I have filed the affidavit of service. Let me be kept with the record.
You are for respondent C. Only 3. The others have been served. All have been served.
Yes. No.
What is the endorsement on the envelopes?
Section 5 has already served. Restoration application served.
Oh,
There is one application.
one application only.
No. No. Can 3 only.
Only one application.
I got it.
Got it. What is the reason for the delay?
My lord, firstly, very unfortunate. Well, no reason left, my lord. My lord,
Let them move the
kindly-
matter.
Kindly point to paragraph 6.
Yes.
If I appeared in the daily cause list on 19th August and no one appeared on behalf of the appellant when the matter was called on Justice Ordinamshina and was directed, mandated of God or lost interest. Matter was rejected. Thereafter, was the complete lockdown from 2020 March. Then no one, their matter dismissed on 19th August. Learned advocates of College Mukherjee didn't take any necessary steps. Thereafter, he fell ill and he was diagnosed and he was operated. Annexure P2 is the certificate I have annexed. Thereafter, on 16th May, a fire broke out in the office of learned advocate located at the ground floor of the premises 4/1 Red Cross. Thereafter, it was filed because admission was restricted.
No, you applied for the certified copy first on 16 September 2022.
Yeah.
The appeal was dismissed on 19th August 2021.
My lord.
It's more than 1 year before. What
Yes.
was the reason? 19th August 2021, COVID pandemic restrictions had ended.
Yes. Thereafter.
So what is the explanation for this 1 year?
Yes, yes. Thereafter, fire broke out in the office of the learned advocate.
Fire broke out much later.
No.
You had taken out the certified copy on 16th of September, 22nd September.
None was aware that the matter has been dismissed for.
What certified copy did you apply for? Come to para 10
Applied for certificate on 16th September 2022.
and got it on 22nd September 2022.
Yes.
Then your father, the petitioner's father, fell ill and had an operation on 3rd of January 2023.
My lord.
No, no.
He was operated.
Your wife gave birth to a child on 3rd of January 2023. How does it matter? 22nd September 2022, you have obtained the certified copy. What was the reason till 3rd January?
After the father of Polish Mukherjee fell ill, after diagnosis, he was operated for remaining scalp cyst, and then his wife in advanced stage of pregnancy in 2023.
Advanced stage of pregnancy came much later. You got the certificate copy on 22nd September. Why do you take
Thereafter-
advantage of your son's birth? No reason has been given. This is not a reason. Quality of the reason should be sound. 991 days, there is no explanation at all. There has to be a limit to everything.
Basically, not the learned advocate,
Give a copy to the learned advocate, erstwhile advocate.
Australian advocate.
Yes. Since allegations have been leveled against the erstwhile advocate of the petitioner, comma, which has substantial bearing on the explanation for the delay in filing the restoration application, comma, for the ends of justice, comma, the petitioner shall serve a copy of this application on the said learned erstwhile advocate of the petitioner, indicating that the matter shall be listed on March 24, 2025, when a fresh affidavit of service shall be filed to that effect. Pushta, the affidavit of service filed today, along with the connected envelopes, be kept on record. Serve a copy on him. Thank you.
I'm for the respondent.
I'm for the appellant, my lord.
What is the application for?
My lord, last occasion, my lord, your lordship were pleased to direct me to serve upon the non-apparent respondents, my lord.
You have served.
Unfortunately, my lord, I have lost my brief, my lord. That is why, my lord, I could not serve, my lord.
We will dismiss the application for default.
My lord,
If you can't move the
Well,
application, no.
due
You
to
have
my
lost your
fault,
brief,
my
you
lord,
suffer. Your client will suffer. There's a limit to everything. Let us see your past conduct. You sought for an adjournment on 6th of January 2025. You did not appear on 24th of December 2025, 2024. You have been consistently absent. When did you lose the brief? Immediately after you passed the direction
my
for
lord,
service
that
of
is
copy.
my
Immediately after that, you lost the brief.
lord,
We directed you to serve copy on 7th of January.
January, my lord.
If you have lost your brief, don't move the matter, then we'll dismiss it for default. If you're not ready to move the matter, what steps did you take in the meantime? Did you apply for a certified copy of that application from the records or mention it before us?
File lying in this court, my lord. That is why, my lord.
Your application before this court will lie before this court. Have you applied for a certified copy of that order? Have you tried even? It's a part of the record. If it was not given to you, if you applied for a certified copy of that application not given, you could have mentioned to us. 7th January you have directed. Today we are sometime in March. 2 months back. So what can be done? Give us solution. Your application, not our headache, nor his.
My lord, it's my fault, my lord.
Your fault, then your client will suffer.
Kindly, my lord, urgent 3 weeks, my lord.
What will you do in these 3 weeks? You
Immediately
haven't even served a copy.
first my land plan to, my lord.
When did you lose the brief?
My lord, immediately after, my lord, direction was given, my lord.
Mr. Rahman, there's a limit to everything.
Sorry, my lord.
Immediately after that lost, that precious file was stolen by somebody, must have been kept in a safe custody. Where did you lose the file from? From this court must be.
Court, my lord.
No steps have been taken, will dismiss for default. He also does not have a copy because he never served a copy.
I have served, my lord. Before hearing, my lord, I have served, my lord.
I am appearing for the sum of the respondent.
Yes.
So this application was served 2 and 3. Can 2 and 3? You said you lost immediately, then how could you serve?
He served prior.
Prior, my lord, hearing, my lord.
On 7th of January 2025, we directed you to serve. You had a previous service.
My lord.
Give a copy to him. Why didn't you ask for a copy to him? He is now asking, give him a copy of both the applications. We will adjourn for a day. Learned counsel for the petitioner submits that he has lost his brief. Full stop. Learned counsel for the appearing respondents is requested to serve copies of Can 2 of 2024 and Can 3 of 2024, as well as the other connected documents which are available with the said respondents to his counterpart appearing for the appellant during the course of the day. Full stop. The matter is adjourned till tomorrow. Whatever is with you, give it to him. Mr. Rahman, pay for the photocopies at least. Ensure that you don't lose the client also. আমার হারিয়ে গেলে আমি থানায় ডায়েরি আমার মনে হচ্ছে হারিয়ে গেছে থানায় ডায়েরি করে পাগল হয়ে Yes. Yes, Mr. Chattopadhyay, what is the matter?
My lord, it is that matter, my lord. Visitation, in terms of lawsuits,
Yes,
my
yes.
lord, is continuing. Only one thing today, my lord, I am praying, my lord, a stay application in respect of their appeal, my lord, has been served, my lord. I want to use an affidavit. Now, only one thing, my lord, 7th, my lord, Friday, my lord, Saturday and Sunday, my lord, the 2 visitation days. 7th, my lord, Friday is her birthday. And my lord, late, my lord, her enjoy, my lord, or the entire day, my lord, for 2 hours in the evening, my lord, I want to take, my lord, my daughter, my lord, and I will take, my lord, I am return back, my lord. Only for this.
No, we have given you visitation for Saturdays and Sundays.
Yes.
Instead of this Saturday, you will get the child for those 2 hours this
From my lord,
Friday.
Saturday, Sunday, only my lord, had,
No, no, you cannot have a pound of
Then,
flesh.
my lord, Friday and Saturday.
But so far as the Friday is concerned, my lord, it's a school day, my lord. My lord, she will be returning to home, my lord. My lord, there is a small program organized, my lord, birthday program, my lord. Father can attend on the
You
last.
participate there.
But on the last
Participate.
year, my lord, they participate.
Yes, yes, you participate. You
Well,
participate. You
My
participate.
lord, they are in, my lord.
You participate there. What is that application which can?
But that is not
No,
an
that I'm just
Oh, application has been disposed of.
an application
application.
is
My lord
pending.
can dispose of all the applications, my lord, directing that this
What are
arrangement
the applications?
applications for visitation.
All are visited.
No. One thing, my lord, is there, my lord. In the order, my lord, that is under challenge, the learned trial judge, my lord, has specifically stated, my lord, that
No, not the appeal, the applications.
No, application, my lord. In the appeal, my lord, subsequently this order, my lord, subsequent order, my lord, by this coordination, my lord, same order has been passed.
No, we'll maintain this arrangement. Otherwise, dispose of the applications. We direct you to prepare paper books and hear out the
Yes,
appeal.
lordship, only one thing, my lord, that is there, my lord. During the visitation, my lord, one third of, my lord, the vacation, my lord, was the direction of this court also to be spent at the house of, my lord, the father. That was the direction. So, in that score, my lord, if your lordship, my lord, dispose of this application, my lord, I have no issue, my lord. Because next vacation, my lord, is summer vacation.
My lord, so far that.
Which is that can?
That, my lord, that is.
My lord, that can is the can one in the father's appeal, my lord, husband's appeal, my lord. My lord will kindly consider the order number, first order, my lord, order dated 1st of August 2023. My lord, that was an ex parte order, my lord, passed by the division bench. It says the appeal is admitted. The 5th paragraph is says, we feel that without prejudice to the rights and contention of the parties, the arrangement with regard to the visitation right of the father of our daughter, as mentioned in the impugned order, shall continue till the matter is taken up.
But then we have taken up the matter and we have passed
But
arrangement.
it's marched with the
No.
subsequent orders.
No, not 1/3 of the vacation. During the vacation also, this arrangement will continue Saturday, Sunday. Saturday, Sunday, every week, 2 days is sufficient. That is sufficient disturbance for the mother.
Well, I do not want to
And the
disturb, my lord.
child also.
I can take my,
Same
that is-
arrangement will continue during the vacations also. No 1/3 during vacation at the present moment. Before you hear out the appeal. No. We are disposing of the appeal applications. Make
All
it
4 applications.
1, 2, 3.
In father's appeal and mother's appeal, another application. That is also stay application. That is also listed now.
and
What is your application?
Stay of the impugned order. Well, I have also preferred an appeal. He has also preferred an appeal.
So we'll. There is a question of. Achha,
Well, this arrangement to continue.
very well. All will be disposed of, keeping this arrangement alive. All the applications are taken up for hearing. Full stop. The matter arises of a dispute regarding custody of a minor child who is residing with the mother Srimati Ishani Ghosh. Full stop. Learned counsel for the father Soumyojoy Mujumdar submits that the coming 7th of this month is the birthday of the child and the father wants to have the child exclusively for a few hours. Full stop. Next para. Learned counsel for the mother submits that the same is a school day for the child and a small program has been arranged in the evening uh, for the birthday of the child in the house of the mother. Full stop. Next para. Accordingly, we permit the father Soumyojoy Mujumdar to attend such birthday ceremony of the minor daughter of the parties
one thing I interrupt, my lord.
at the place of the mother.
Let it be
Full
an
stop.
independent place, my lord. I will be at the house.
No. In the events the father so visits, he will be welcomed in all manner and his access to the child would not be affected in any manner by any action of the mother or her family members. Full stop. Next para. Can 1 of 2023, can 2 of 2024, can 3 of 2024 in connection with FMAT 277 of 2023 as well as can 1 of 2023 in respect of FMA 798 of 2023 are disposed of by making the arrangement of visitation as already granted previously by the order dated 20th January.
Yes.
January 2025, which arrangement is made absolute till disposal of the appeals, full stop. The appellant in FMAT 277 of 2023 shall prepare and file joint the requisite number of joint paper books, composite paper books for both the appeals, and serve an advance copy of the same on the learned advocate for the respondent in FMAT 277 of 2023. Full stop. Next para. Records are before this court. The appellant in FMAT 277 of 2023 shall deposit special messenger costs within a week from date upon which the trial court records be called for by such special messenger. Full stop. Next para. যেখানে পেপার বুকস বলছে ওখানে ইনফর্মাল করে দিও, ইনফর্মাল পেপার বুকস উইদাউট কম্পেয়ারিং উইথ দ্য রেকর্ডস. Next para. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
My lord, only one thing, my lord, can it be added, my lord? My lord, lordship has definitely protected, my lord. My lord, husband may not be, my lord, the father may not be, my lord, may not face, my lord, some untoward, my lord.
We have put that in. We have put that in. Not be obstructed in any manner or whatever.
My lord, because item number 7, my lordship was that my land had to give the copy, my lord, but
Is refusing.
no, my lord, he's
But
happy to give me, my lord, but my lord, 3 weeks time.
My lord,
could be-
7th January, my lord directed them to
Yes,
serve
my
the non-appearing respondent. There are 27 non-appearing respondents, they are not served. If, my lord, I am giving him copy by tomorrow, he cannot serve about 27 parties.
We have kept it tomorrow. Tomorrow we'll consider. An order has been passed in open court. We cannot. Yes. 10. Yes.
I appear for the appellant, my lord.
Respondent.
My lord, the deficit court fees has since been paid, my lord, on,
Yes, you have recorded that.
yes, my lord, deficit court fee has been.
Chalans you had to produce.
Yes, my lord, on 25th of February it has been paid. The website shows it, my lord. Now what is, I'm told that
So we have to take a report from the office. No, this is at what stage? What is the can for?
the can is for stay. For the present, I will not be pressing the application for stay for the present. my lord.
So what is the impugned order?
Impugned
It's a
order is, my lord,
eviction decree.
declare eviction, my lord.
You'll not be pressing because you will have to pay.
No, there's one more issue. My lord, there are two owners. I claim to be a tenant under number 2. The suit has been filed by number 1, in which, my lord, the number 2, the
We are sorry. Please repeat. You are
the property.
two tenants.
No, the property
Two
is
owners.
owned by two owners. The two owners. I claim to be a tenant under, say, owner number 2. Owner number 1 files a suit against me for eviction on the ground of me being a licensee on the expired license. In that suit, my lord, the other owner deposes and says he is inducted me as a tenant. And my lord, after this decree, my lord, he has filed an application under Order 21 Rule 102. That is pending along with the application for stay. So since that is pending, my lord, I will not be pressing this for the time being.
You will not press it for the time being.
On the time being, the stay application, my lord.
We'll record the director and office. The office, since he's not, we'll record his submission.
Yes, yes.
For the present, I'm not pressing.
Well, the bailiff could not take physical possession of the
Whose
suit
right is pending?
premises. The bailiff faced resistance. We had to apply for police help. Now, my lord, the application is pending for orders. My lord, his written statement case before the
also
Does not
2197.
press this stay application for the present. We'll give him liberty. We'll let it go out of the list. Give him liberty to present mention. Learned counsel appearing for the appellant submits that one of the co-owners of the property filed an eviction suit and obtained the impugned eviction decree against the appellant in the capacity of a licensee, whereas the appellant is a tenant in respect of the other co-tenant who has filed,
Co-owner.
of the other co-owner, the latter having filed an application under Order 21
Rule
Rule 101 of the Code of Civil Procedure in connection with the execution case of the respondent. First up, next para. Since a prayer for stay at the behest of the said other co-owner is now pending before the executing court, for the present, the appellant does not wish to press the stay application. First up, next para. While controverting the contentions of the appellant on merits, learned counsel for the respondent that the application for stay before the executing court is pending orders by the court.
Is my application for police help to take possession.
Acha, that the application for stay na, that the application for police help uh, filed by the respondent in connection with the execution case is now pending for orders. First up, be that as it may, comma, since the appellant does not, comma, for the present, comma, wish to press the stay application in view of the reasons as given above, comma, let the matter go out of the list for the present with liberty to the parties for to mention for inclusion in the list as and when so deemed fit by the parties. Puts up next para.
To pass directions for preparation paper books.
Since the appellant submits that deficit court fees have already been deposited, comma, let us just check up whether that report has been.
Now this shows in the website 25 to 25.
Comma, which is reflected in the official website of this court. Full stop next para. The office shall furnish a report in that regard. Full stop next para. The in view of the appearance of the respondent in the appeal, comma, service of notice of the appeal on the respondent is dispensed with. The trial court records be called for by special.
Alright,
It
there's
has
a
already come.
previous order passed by.
You have to prepare the paper books now.
I'll prepare the paper.
Acha, you have prepared.
I will.
Very well. Since the trial court records are already before this court, comma, the appellant is directed to prepare and file the requisite number of paper books within 8 weeks from date. Full stop. Liberty to the parties to mention for inclusion in the list as and when the appeal is ready for hearing.
My lordship will kindly provide the execution case may proceed on its own since there is no order of stay.
Stay, he is not pressing. We have recorded. We won't give you further relief in his application. Stay, he is not pressing for the present. So, what remember?
Grateful.
Wait, please, my lords.
Yes, please.
My lords, Mr. Adil Nasir is the advocate on record in this matter. Due to
Yes.
ill health, he couldn't attend court today, my lords.
You are his chamber junior.
No, my lord. He instructed me over the phone. as to what he should do.
How are you related to him?
My lord, he's my college senior.
He's a college senior.
Yes, my lord.
Have you got the file brief before you?
No,
the
my
file.
lords.
On the it will be urgent till
My lords, I have also been asked, would I be accommodated with a couple of weeks, my lord? Actually, the supplementary affidavit that is to be filed in connection to the CAN application, CAN 2. My lord, the affirming individual, he has been transferred to Jalpaiguri. As such, he couldn't come to affirm it. Yes, my lord, would kindly.
so you want an extension of the time for filing supplementary affidavit. On the prayer of you give your name. On the prayer of the appellant, comma, the time for filing supplementary affidavit is extended for 2 weeks from date, full stop, as prayed for by the prayed for on behalf of the appellant, comma, let the matter stand adjourned till March 19, 2025, when it will be listed under the same heading. 2 weeks. Give your name, please, sir. Yes.
I'm for the appellant, my lord.
Yes.
The earlier order, my lord. A report has to be sent before this honorable court in regard to the inclusion of my name.
You have not filed any no objection Vakalatnama?
Yes, I have filed, my lord. Filed.
Yeah.
In earlier order, your lordship has passed an order in regard to the filing of a report, my lord.
না ও আমাদের কি অর্ডার ছিল দেখি অফিসকে ফ্রেশ রিপোর্ট দিতে বলেছিলাম আমরা অফিস আমরা বলেছিলাম হচ্ছে 24/2 no till 3rd of March today we are on 4th of March till yesterday that Vakalatnama has no such Vakalatnama has been filed that you satisfy the department we'll send it back to the
No
department.
report has been sent.
Report has been sent. Yesterday only it has been authored by the Assistant Registrar SR section. It says that no Vakalatnama has been filed. You please meet the SR and satisfy him. Give the numbers.
Department, মানে যেখানে
Give the number, give the entry number to the SR section.
Xerox copy of the Vakalatnama.
Although learned counsel for the appellant submits, you are for the appellant,
Yes, my lord.
submits that a no objection Vakalatnama has already been filed, comma, the report of the Assistant Registrar SR section dated March 3, 2025 indicates that no such report, no such Vakalatnama has yet been filed. Full stop. Let the matter go down to the department for issuing a fresh report in that regard. Full stop. The learned advocate currently appearing for the appellant on no objection is requested to cooperate in the matter. Full stop. Next para. Upon a fresh report being filed, comma, the matter shall next be listed on March 17, 2025 under the same heading. Department পাঠিয়ে দেখে নিতে বলবেন. Please contact the department and just give them the number so that they can give a fresh report and it will appear on 70. Come back, Mr. Grateful. Yeah.
Item number 13, madam, appearing for the wife, madam, petitioner hearing, madam, being the appellant, madam. This is my application for enhancement of the maintenance amount, madam.
Yes. Reply was to be filed.
Yes, it's my reply,
You
madam.
have given a copy to Mr. Gupta. Why are you giving now? How will he prepare himself?
Madam, only reply, madam, I have taken a only one valid point,
Just to
madam.
go through it. If Mr. Gupta, you are agreeable on that reply to argue now, then we will take up the matter. Otherwise, not.
Madam, only one technical point I have taken, madam, the affidavit of
He has to go through it at least.
Kindly allow me some.
Affidavit of reply is affidavit in reply filed today be kept on record. Full stop. However, comma, since a copy thereof is served on the learned advocate for the respondent here and now, comma, when should he keep it, Mr. Gupta, tomorrow? Comma, in order to enable learned counsel for the respondent to prepare himself on the same, comma, the matter is adjourned for the day. Peculiar practice.
Item number 14, my lord, I am for the appellant. A restoration application on behalf of my learned junior.
You are for the other side?
Responded one. My cousin brother died.
Sorry. Dismiss or default. Within time, you said. Yes, seriously opposed, Mr. Halda.
Not over, no copy has been served.
I'll
serve a copy right now. You go through it, Mr. Halda.
All but I am not opposing, my lord. Kindly let it appear under the heading order for 2-1.
Second appeal.
Second.
In view of sufficient reasons having been given in the application for the absence of the appellant on the relevant date, comma, can 2 of 2025 is allowed without any orders to cost, comma, thereby recalling the order dated January 16, 2025, whereby SAT 254 of 2024 was dismissed for default and restoring the said appeal to its original file and number. Full stop. Let the appeal be listed under the heading Order 41 Rule 11 tomorrow. Come prepared tomorrow. That is your cost. Defect আছে? কি defect? Wait, there are some defect. Certified copy of trial court has not been filed.
I'm looking into the matter, my lord. If not filed, I'll check.
Check up if you have it with you, we will take it on record tomorrow. Or if it is with your counterpart in the court, we will just ask for. Should you keep it sometime after next week? Will be
kindly.
We'll put it in our order also. Adjourn for the day na kore, adjourn till March 11, 2025. Full stop. The learned advocate for the appellant shall furnish the certified copies of the judgment and degree of the trial court on the returnable date.
এটা তো তোমার জুনিয়র ডিভিশন
ওটাই দিতে হচ্ছে ট্রায়াল করে যাবেন
আর কিছু defect তো নেই। Please check up whatever other defects are there.
Yes, yes, I shall.
Point out to us on the next occasion. We'll direct permit you to cure.
Deeply obliged.
15 Mr. Ghosh, you are appealing. Yes. Yes.
Respondent, my lord, I have not yet
14
received
হয়নি
the
না?
call of my lord. Just my lord, the client contacted. Nevertheless, I know the
Lordship
matter.
kindly pass the usual order, lord, partition suit. Delivery has been passed.
No, there's an office report that there's a delay. Let us just.
Yeah, that is 15, 16 was it? No, 15, 16 lord against the same judgment. 15 is lord, 16 is within time. 15 is there is some delay. Analogous, both the suits were heard analogously and by
This is against an order passed by. What is the valuation of the suit?
25 rupees. That is a declarative suit. And lord, the other suit is partition.
So is an appeal maintainable before
Lord,
this court?
Because lord, the analogous, both the appeals have been filed before your lordship. Analogous judgment is analogous.
No, separate decrees you have to file appeal before different court.
Before the district judge.
Yes.
Either your lordship kindly appellate side rules provide that paper book if the to
Appellate side rules provide what?
that if the
It amends the Bengal Agrasam Civil
Organization.
Codes. Forum cannot be changed by appellate side rules. Bengal Agrasam Civil Codes Act.
it should be
This appeal is not maintainable before this court.
I'm gone through everything. Lord, it is 25 rupees. But Lord, kindly see the judgment, Lord. 2 suits have been decreed. Our suit was for declaration at Lord valued at 25 rupees. That has been declared, Lord, partly. And so far the partition.
You have to present it before the appropriate court. Then we can only take up. Mr. Ghosh, you know the law. If you file it before the appropriate court, we can take up under our powers under latest patent or section 24,
and
even
it can be transferred
227.
under section 24, I know, Lord.
Even 227,
Yes.
we can exercise so motu.
But
But you have to file an application formally then.
What I suggest, my lord, instead of my lord, today and tomorrow, my lord.
No, we'll hold that this appeal,
This appeal was not given to me. I was only given my lord item number 16.
Mr. Chatterjee,
therefore-
we'll observe that this appeal is not maintainable before this court. Let it be applied, filed before the appropriate forum. With liberty to the appellant after filing. No, we won't give that liberty right now because that will be premature. It will be section 14, section 5.
Lord, then
It transpires that the present appeal is not maintainable before this court in view of the valuation of the suit from which the same arises being rupees 25 only. Push up next para. Accordingly, FAT 322 of 2024 along with CAN 1 of 2024 are dismissed as not maintainable with liberty to the appellant to present the appeal before the appropriate forum having jurisdiction. Push up, it is made clear that the merits of the case have not been gone into at all. Next matter to call. You'll get the copy then when it is fine.
Lord, yes.
16. This is maintainable.
This is maintainable and your lordship kindly pass the usual order.
Partition should preliminary degree. You have got a copy in this.
I have got copy, my lord. Only the power is to be filed, my lord, in course of this.
Oh,
day, my lord.
in course of this day you can do it.
Yes. Power is with me.
Learned, আচ্ছা এটা যখন মিস্টার চ্যাটার্জি নামটা লিখবেন না মেঘনাথ ভিতর চ্যাটার্জি তখন ওটা having instruction to appear for the advocate having instruction. Learned counsel, Mr. Chatterjee, learned counsel having instruction to appear. You will appear through some junior. Learned, whoever. Mr. Chatterjee, learned counsel having instruction to appear for the respondent through his learned junior, seeks leave to file his vakalatnama during the course of the day, which leave is granted. For sub next para, the present appeal arises out of a preliminary decree of partition. Full stop. Upon hearing learned counsel for the parties, CAN 1 of 2024 is disposed of by directing the learned trial judge to continue with the final degree proceedings, subject, however, to the rider that no final degree shall be drawn up without prior leave of this court. Full stop. Such order shall continue till disposal of the present appeal. Full stop. Next para. In view of appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with. Full stop. The trial court records be brought by special messenger, subject to retention of a skeletal record for the final degree proceedings, by special messenger at the cost of the appellant, which shall be deposited within a week from date. For sub next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Original certificate আচ্ছা আগের যেটা 15 হলো না তাতে একটা লাইন অ্যাড করে দেবেন ইওরে leave is granted to the learned advocate appearing for the appellant to take back the certified copies of the impugned judgment and decree upon furnishing photocopies thereof for the record.
I appear for the appellant.
You are for the appellant.
I'm for the appellant, plaintiff appellant against an order.
Appearing for the first time. She's other side or you with you?
No, I'm the appellant.
Not with you at all. Appearing for the first time, no
my
caveat.
lord, admitted and there's a direction for service. I've completed service, effective.
Affidavit service. All have been served.
There are 3, one developer and two of the directors.
All of them have been served.
All of them.
Yes. What is the appeal against?
My lord, my suit for declaration their application under Order 7 Rule 10, my plaint was returned, directed to be returned and to be filed before the commercial court.
Why shouldn't it go before the commercial court? What is a private?
My lord kindly comes to the plaint,
Yes.
page 11. The prayers are at page 18. The parties entered into a development agreement with regard to property, with regard to certain property which is still lying vacant. After 3 years, they have not obtained a sanction plan. They have not initiated any construction work. What had happened, my lord? After that, I served a notice.
This is a commercial transaction.
No, not unless the property is used in exclusively in commerce or trade, actually used. It cannot be, because my plaint states there's no construction yet.
In view of a prima facie, despite service, none appears for the respondents at the time of call. Affidavit of service filed to be kept on record. Full stop.
If it goes, if it goes before the commercial court, I understand I'll be in a good position to get the suit disposed of in a certain. But since the declaration, suit for declaration of rescission of the contract, whether lies before a commercial court, that
no, it's debatable. It's arguable. It's arguable. কোনখানটা ছাড়লাম? Affidavit of service filed to be kept on record তো বলেছি। In view of a prima facie case having been made out for hearing of the appeal and the appeal having been admitted, appeal is already admitted, can 1 of 2024 is disposed of by granting stay of operation of the impugned order, being order number 22 dated May 17, 2024, passed by the learned civil judge, senior division, 3rd court at Barasat, district North 24 Parganas, in title suit number 58 of 2020, till disposal of the appeal. Full stop. The appellant shall deposit requisites for service of notice of appeal on the respondents within a week from date. Full stop. The trial court records be brought by special messenger at the cost of the appellant, also to be deposited within a week. So next para, the appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 8 weeks from the date of service of notice of arrival of the trial court record on the learned advocate for the appellant, which of liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
it's a rejection of appeal, manner whether paper book will be necessary.
Pardon?
Rejection of return of my plaint, whether paper book will be necessary or not.
Paper book is always necessary. That's why informal without comparing with the record. Outer limit is 8 weeks. You can file within 2 weeks also.
I can.
No difficulty. Deposit the special messenger cost. If notice is served, records come, the paper books are prepared, mention it.
Next matter, my lord, arising out
Let
of
it be called, yes.
No,
yes, what is this?
Same order, different suit. That was title suit number 58.
Ground is similar.
Identical.
Same order, copy paste.
Title suit number.
Title suit, yes, sorry. Order date is different also.
No, order date is same.
Order date is also same. Application. Yes. Right. Title suit number টা শুধু 57 of 2020 হবে। আর বাকি সব same.
I'm grateful, my lord.
Affidavit of service here also all have been served.
All have been served. Same parties, ma'am. I'm grateful, ma'am. Thank you.
19, my lord, I appear for the appellant, my lord, my application under order 39 rule.
You are for the respondent, sir. Application under order 41.
Order 39 rule 4.
Rejected.
Rejected. My lord can dispose of the appeal along with the application. The application is essentially one for vacating the order. So the appeal cannot be disposed of along with this.
If Mr. Samant is agreeable to that. Shanta, can we decide? Because 39-4. Thank you very much. Yes. Suit for Mr. Bardhan?
My lord, suit for partition. My lord, that kindly takes up the plaint, my lord. The plaint is, my lord, at page, my lord, 16 of this application. My lord.
Yes.
Now, my lord, now there are two schedules, my lord, Schedule A and Schedule B. My lord, we are concerned with Schedule A because that, on that, my lord, the injunction.
Concerned with Schedule?
Schedule A and Schedule B.
You are concerned with?
Schedule A.
That is the entire property. No, different properties.
They say there are two properties. They say this property at Schedule A is liable to be partitioned in its entirety. My case is this: vide a duly executed gift. My mother had gifted me 8 katas and odd, which was to their knowledge.
8 katas, mother was the sole owner,
Yes, mother was owner. So sole owner, mother gifted 8 katas to me.
demarcated.
Demarcated. There's a gift deed. Demarcated gift deed.
Ah.
This was within their knowledge. Now they bring the suit with respect to the entire property of 1 bigger, which I say could not have been done. Now kindly seize the ad interim order.
Your 8 kata should be excluded according.
Yes.
So you are agreed with injunction regarding that 8 kata only.
Absolutely, because I cannot have a claim as far the other portion is concerned. But to kindly seize Annex to see at page 78, which is the ad interim order.
It was ex parte?
Ex parte. Ad interim injunction.
Yes.
Let's see. Plaintiff in the plaint has asserted herself to be one of the co-owners in the scheduled property along with the defendants. The properties previously belonged to Kollani Datta and Sharaj Kumar Datta. They had constructed a 2-story residential house and started residing therein with 6 children. The
You need not read the entire thing. The gift deed has not been mentioned at all.
Kindly seize in the year 2011, Milord.
Yes.
Plaintiff came to know that the defendant number 2 of the suit had filed a suit in respect of A and B scheduled property, and on inquiry, plaintiff came to know title suit being such and such was filed by defendant number 1 and 2 before Learned Civil Judge Senior Division, First Court, Barashat, seeking declaration, partition, and for permanent injunction, claiming to have acquired title in the A schedule A property.
Not the entire.
No.
8
now,
kata.
so this is the earlier suit.
So defendant number 1 and 2 became joint owners of that 8.
No. Defendant 1 and 2 filed a suit for partition.
Different suit.
Different suit. That's the earlier suit.
Regarding a different property.
No, the same property, claiming exclusive title insofar as this 8 katas was concerned. A declaration to the effect. That plaint is annexed. So this was the fact.
But that suit is sub judice.
No, withdrawn. That was a suit at our instance. We withdrew it. The defendant number 2, the appellant here.
You withdrew, nothing hinges on that. You made a claim, you withdrew it.
No, but in that suit,
you pleaded that 8 katas belongs to you.
Yes, and the deed of gift was disclosed.
It was your suit against the defendant number 1.
Yes. The plaintiff out here.
You withdrew it, but that has no effect.
No, but it was to their knowledge.
So it was to their knowledge that you had filed a suit claiming exclusive 8 katas, but then you withdrew the suit.
Yes.
So how does it matter?
It was within their knowledge that there was deed of gift. Now, in this suit, they plead ignorance over the deed of gift is concerned.
But they have mentioned about that suit.
Kindly seize, mention the suit. But kindly seize, kindly, I'll show the plaint, but kindly seize the order. So this was the ad interim order, Now, my 39-4 was disposed of by the impugned order.
Main injunction is still kept pending.
Still kept pending.
So they might have been aware of the suit, but
no,
how does it make a difference?
In the suit itself, the deed of gift was annexed. It was mentioned that the deed of gift was there.
Yes, they say on the strength of a deed of gift. The court was aware of that.
Yes, kindly seize. Plaintiff has filed an objection. Seize this order dated 17th of May. Impugned order, Annex to G,
Yes, 17th of May.
Kindly seize the fourth paragraph. Plaintiff has filed an objection to the application and asseverated that the plaintiff was not acquainted with any deed of gift executed by their mother, Kollani Datta, since deceased, in favor of the applicant, defendant number 2, at the time of instruction of the suit. So this is the case, Therefore, it cannot be stated that the plaintiff's prayer for ad interim order of injunction was actuated by any false or misleading statement in relation to material particular. The plaintiff had iterated that the deed of gift purportedly executed by Kollani Datta is invalid and illegal. So they were aware of the deed of gift. And
this is not a mutually contradictory case. They say we were aware that a suit was filed by you regarding
as well as the gift
on the strength of a gift deed.
Yes.
Then they say they are not acquainted of any such gift deed. You filed a suit, you withdrew it, you asserted that.
In that suit,
but they are not acquainted with that, and that deed of gift, purported deed of gift, even if any, purported means maybe fictitious, may not exist also. Purported, claimed, alleged deed of gift, that is invalid and illegal. There is no contradiction.
Page 58 is the earlier plaint. Page 50
That
is earlier
plaint was
page.
disclosed by them. No, Mr. Bardhan,
The
we are not
plaint-
saying
The plaint might be disclosed, but deed of gift.
was annexed to that.
Yes.
They say they are not acquainted with any deed of gift.
How could they? How could they not? They had appeared, my lord, in the
They are
matter.
acquainted that there was a suit filed by you where you annexed a purported deed of gift. But they deny that this deed of gift. They say they are not acquainted in the actual deed of gift executed. It's not a suppression. No, not a suppression. They disclosed the suit. It was before the court, and in that present plaint, they have stated on the strength of a gift deed.
My lord, but in
No.
the plaint, my lord, in this present plaint, my lord, they have not challenged the deed of gift either. In the present suit, my lord, they have not challenged the deed of gift either. Kindly
If that is your contention, Mr. Bardhan, you might challenge prima facie case for grant of injunction on the ground of maintainability. But that is not a valid ground under Order 39 Rule 4. Then you go and file a misappeal or fight out the injunction application. We'll keep this question open.
What I am on is very simple, my lord. Today, my lord, they say they are not aware of any deed of gift. My lord, that is the categorical case they are running, my lord.
Not acquainted.
Yes, my lord.
Not acquainted.
Not acquainted with any deed of gift. My lord, if the earlier
I may
plaint-
be aware of the existence of,
Yes, my lord.
say, the American president,
Yes.
but I'm not acquainted with the president.
No, my lord. But the
They know that they are aware that you have claimed a deed of gift.
But no, the issue is
But they are not acquainted with that gift deed.
But
And
that
that
was-
purported gift deed is invalid, they're saying.
my lord,
It's not a case of suppression.
My lord, what I say, my lord, what I say is, my lord,
39(4) is
earlier-
not a suppression.
the earlier deed of gift, my lord, was annexed to the plaint. So they had knowledge of the deed of gift. So if they had knowledge of the deed of gift, my lord, without making a specific prayer for cancellation of deed of gift.
As we said, that's a very good question for maintainability of the suit. But Order 39 Rule 4 does not contemplate maintainability or prima facie case. It's only on suppression
Yes, my lord.
or undue hardship.
But it's undue hardship on me, my lord, because this is the portion, my lord, in which a development agreement has already been entered into way back.
It's a sub judice matter, and
No, that is correct, my lord. What I say is, my lord,
you can take this point in your injunction. We'll keep this question open for being taken in at the final hearing of the injunction application also.
they have
With the prima facie
pleadings
case.
are complete injunction application. So, my lord,
Maybe it's a legal argument.
No, the pleadings are complete. So my lord might direct the injunction application. to be
We
disposed.
will.
No, that does it, my lord. My lord, within a specific time frame, my lord.
By the end of December 31, 2025.
Kindly, my lord, I'll tell you. my lord.
Nowadays, it's really difficult, my lord.
No, it's
I
not
got
difficult.
such orders, effect is dangerous.
Not dangerous.
Court
my lord.
says I am
Not
unable.
dangerous, my lord. My lord, this is a short point I'll be canvassing, my lord.
We get so annoyed when the Supreme Court directs us to dispose of an appeal within 3 months because of our roster. They have worse roster than us.
Sir, this is one application, my lord. Order 39 Rule 4.
There are not one application before that court, Mr. Roth. We cannot direct it. Time limit will give, but it will be a liberal time limit.
Kindly, my lord. Well, the entire development is stalled, my lord. The entire development is stalled. my lord.
We are in March 2025. The impugned order was of 17th of May 2024. If you could wait so long, we'll give 2 months. 2 months. Could you wait for 1 year? You can wait.
No, before the vacation, my lord, if that could be.
Calcutta does not have a vacation. It has a strike during the vacation. So we cannot recognize that vacation,
Then, my lord,
which is illegal in the eye of the Supreme Court judgments.
It's better, my lord.
It cannot be before vacation,
It's
after
better, it's better. I
There's
don't-
no vacation of the time.
It's better I don't open my mouth any further.
No, we'll give 2 months. 2 months. On consent of parties, the appeal itself is taken up for hearing along with the application. First of the present challenge has been preferred against an order whereby the application of the defendant stroke appellant under Order 39 Rule 4 of the Code of Civil Procedure for vacating an ex parte ad interim injunction order dated February 22, 2023 passed in a declaratory suit was dismissed, was refused. Full stop, next para. It is contended by learned counsel for the appellant that it will be evident from the ex parte ad interim order dated February 22, 2023, as well as the plaint of the plaintiff stroke respondent, that the plaintiff was well aware of the filing of a previous suit by the defendant number 2 stroke appellant bearing title suit number 256 of 2008, which was filed on the strength of a deed of gift full stop, it is submitted that the Schedule A property mentioned in the plaint of the present partition suit is not joint in its entirety, inasmuch as the original exclusive owner, comma, being the mother of the appellant, comma, gifted 8 cutters of demarcated portion out of the said Schedule A property of the present suit in favor of the defendant number 2, and as such, comma, the same could not form a part of the hotspot of the present suit. Full stop. It is submitted further that in the written objection to the vacating application of the appellant, comma, the plaintiff stroke respondent took a plea that the plaintiff is not acquainted with any such deed of gift executed by their mother Kalyani Datta, and in the same breath stated that such gift is invalid and illegal. Full stop. Next para. It is contended that since a copy of the deed of gift was annexed to the plaint of the previous suit, comma, the acquaintance of which has been categorically admitted by the plaintiff stroke respondent herein, comma, there was a material suppression of relevant fact inasmuch as the plaintiff herein feigned ignorance of the gift deed. Full stop. Hence, comma, the learned trial judge, comma, it is argued, comma, ought to have vacated the interim or ad interim order on the ground of suppression of material facts as contemplated under Order 39, Rule 4 of the Code. Full stop. Next para. Learned counsel appearing for the plaintiff respondent opposes such contention and points out that the fact of the previous plaint on the strength of a deed of gift was disclosed at the time of obtaining the injunction application. Full stop. However, comma, since the plaintiff respondent opposes the validity and legality of the deed, comma, the same, comma, acquainted with the same has been denied. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that the statement of the plaintiff respondent to the effect that the plaintiff is not acquainted with any deed of gift executed by their mother was made only in the written objection to the vacating application, and as such, comma, such statement could not have been germane in ascertaining whether there was a material suppression at the point of time when the ex parte ad interim order was passed on February 22, 2023. Full stop. For ascertaining the suppression or non-suppression of material facts, comma, we have to relate back to the date of passing of the said ex parte ad interim order, when it was the plaint and the injunction application of the plaintiff which were before the trial court. Full stop. It is reflected in the ex parte ad interim order dated February 22, 2023 itself that the plaintiff categorically disclosed the filing of a previous suit on the strength of a gift deed allegedly executed in favor of the defendant number 2 stroke appellant. Full stop. Next para. As such, comma, we do not find any suppression of material fact at that juncture. Full stop. Next para. In fact, comma, we also do not find any mutually exclusive patent contradiction between the statement that a previous suit was filed in connection on the strength of the purported gift deed and the allegation that the plaintiff is not acquainted with such deed of gift and claims that such purported deed of gift is invalid and illegal. Full stop. It may very well be that the defendant number 2 stroke appellant had filed a suit on the strength of a purported gift deed, comma, which filing was within the knowledge of the plaintiff. Full stop. Even if the plaintiff was acquainted with a copy of such purported deed being annexed to the plaint of the previous suit, comma, that does not necessarily mean that the plaintiff would be acquainted with the actual gift deed or would admit the validity or legality of the same. full stop, hence, comma, we do not find any suppression worth the name which would hit at the root of the matter and be considered material suppression for the purpose of Order 39, Rule 4 of the Code of Civil Procedure. Full stop. Next para. Insofar as the other question raised by the defendant number 2 stroke appellant, that the present partition suit is not maintainable in its present form in the absence of a challenge to the validity or the binding effect of the gift deed by which a demarcated portion of Schedule A property of the present suit was donated to the defendant number 2, comma, such question at best would hit at the maintainability of the suit and would comprise a part of the prima facie consideration for grant of injunction. Full stop. However, comma, it would be open to the defendant number 2 stroke appellant to raise such issue at the time of final disposal of the temporary injunction application as well as at further stages of the suit. Full stop. However, comma, such issue, comma, pertaining to the prima facie case and maintainability, comma, is not a valid consideration within the four corners of Order 39, Rule 4 of the Code of Civil Procedure, and as such, comma, we cannot enter into such question while deciding an appeal against an order passed under Order 39, Rule 4 of the Code. Full stop. It is well settled that there are three remedies open to a defendant who is aggrieved by an ex parte ad interim order, hyphen, first, comma, an appeal being preferred against such order, comma, secondly, comma, to file an application under Order 39, Rule 4 of the Code, and thirdly, comma, to fight out and contest the injunction application on merits by filing a written objection to the same. Full stop. Having purposefully chosen the second remedy, comma, we have to the defendant number 2 stroke appellant has to be confined within the parameters of the said remedy, comma, which does not include the questioning of the prima facie case made out at the time of grant of ex parte ad interim injunction, comma, although the same might have been a relevant consideration in an appeal against the ad interim order, comma, which has not been filed, and also at the final hearing of the injunction application. Full stop. Next para. In such view of the matter, comma, we are not inclined to interfere with the impugned order and are of the opinion that the same is not tainted by any illegality in any manner. Full stop. Hence, comma, FMAT 316 of 2024 is dismissed on contest without any order as to cost, thereby affirming order number 12 dated May 17, 2024, passed by the learned civil judge senior division, third court at Barasat, district North 24 Parganas, in title suit number 182 of 2023, comma, with the liberty to the appellant to raise the issue of maintainability of the suit as well as prima facie case for grant of injunction at the final hearing of the injunction application as well as at further stages of the suit. Full stop. Next para. In view of the pendency of the appeal for some time now, comma, we request the learned trial judge to dispose of the temporary injunction application upon giving opportunity of hearing to all parties, but without granting unnecessary adjournments as expeditiously as possible, comma, positively within 2 months from the date of communication of this order to the learned trial judge.
And the observations made here, Mullah,
We have stated that. Acha, we will state another line. At line at the আচ্ছা এটা এফএমএটিটা এফএমএ হয়ে গেছে এফএমএ 1094 of 2024 একটা লাইন রাখছে আদ করে দিও needless to say comma we have not entered into the merits of the contentions of either of the parties at further stages of the injunction application and the suit.
Thank you.
Yes. Respondent. Yes, Mr. Chakraborty.
I'm filing the reply to the opposition in connection.
Mr. Chakraborty, please use the microphone. Either of them, whichever is working. We don't know which is working.
Reply to the minor opposition I am filing,
Yes.
my lord, in connection with the stay application. In the opposition, the respondent has prayed for occupation charges at a rate of 9,500 per month. My lord, I am disputing the same, my lord, that in connection with the opposition.
Eviction degree on the ground of?
Yes, according to him, my lord.
Achha, let us see the opposition and your reply. What proof they have?
My lord, and my lord.
Report by chartered engineer, valuer.
Valuer, a report has been given.
Yes.
My lord, in the report, it has been admitted by the valuer
Yes.
that the landlord could not produce any sanction plan. And my lord, the suit room was inspected, not from the inside, it was my lord, closed. So on basis of guess, it has been given. And no, my lord, there are other tenants of the same premises, though none of the rate of the other tenants have been mentioned, nor the nearby.
Sir Chakraborty, where is it admitted that he could not inspect the room?
My lord, then the report, my lord, annexed to the opposition, stated that
But the surrounding area and the location has been ascertained.
Surrounding area, my lord, and from outside it has been stated, seen, and my lord, no building plan could be shown from their own report. And
So
my
the
lord,
room could not be inspected. What is the area location, Mr.
Goranhata, my lord.
Bortala.
Yeah, North Calcutta.
Right.
North Calcutta, and my lord.
Photographs have been given.
It is measuring about 80 square feet according to us, my lord.
80.
80 square feet, and last.
You are using it for residential or commercial purpose?
No, commercial, my lord.
Commercial. It's a shop.
It is a shop. My lord, it was lastly, my lord, rent was 421 per month. With my lord.
What was the rent? 421.
421.
You
So
paid the 1 rupee?
Yes, my lord, he was. I was paying depositing the same.
Anyway, not material. Yes. So, so you say 421 and they say 8,000 something.
Yes, 9,500.
9,000. No, there are two reports.
No, not one.
Page 13 says, oh, acha, 9.
Continue.
Total is yes. What is reasonable outgoings? Let us hear Mr. Bhattacharya first, then you will reply. It will be easier. Mr. Chakraborty, take your seat because it is on occupation charges now.
Yes, kindly takes up their affidavit in reply, my lord.
No, first your explain this. What is page 13? Add 10% for reasonable outgoings.
13. It's 13, my lord. Yes.
8,600.
8,000.
Reasonable outgoings has not been explained.
Very well. Let it be, my lord, fixed at 8,600.
Acha. Their reply?
Yes, kindly comes to.
And you have not annexed any surrounding rent receipt, anything. What is the basis? He could not inspect the room.
No, inspect the room, my lord. No tenant, my lord, will let the, my lord, our valuer to get into the room and inspect. My lord, it's never happens. Kindly see their affidavit in reply.
80 square feet area is admitted.
No.
You say it's.
No, that's why, my lord, affidavit in reply. I'm going by their statement.
What is that?
Kindly see, my lord, paragraph 8.
100. So increase by 20.
This is their statement. This is their statement. Now, my lord, kindly comes to their affidavit in.
They say may not be higher than 2,000.
Yes, kindly comes to page 7 of their reply, annexure A.
They say much less than 100 square feet.
No,
Very small measuring. Much less than 100 meter. 80 হবে না, much less than 100 তাহলে much less than 80 বলতে। আসলে 100 কত হবে? 98, 95, 94. Anyway.
This is there. Now, my lord, kindly comes to, my lord, this page 7 of that reply. My lord, rent receipt has been produced.
Yes.
My lord, this suit has, my lord, 2 parts. One, my lord.
This is of the same premises. Yes, 40. Same
Premises. Now, my lord, kindly see, my lord, this is totally manufactured. Why? My lord, this suit, my lord, my suit was for, my lord, eviction on the ground of, my lord, expiry of lease. Now, my lord, they entered appearance, filed written statement along with a counter claim for declaration of their tenancy right. Their counter claim was dismissed only on the ground for non-production of the rent receipt. Therefore, this was never produced before the learned trial court. For that, my lord,
that and even otherwise rent receipt for a tenancy granted earlier cannot be valid. But you have also not produced any rent receipt of any surrounding area. Only a valuer's report, your appointed valuer.
Yes, appointed a valuer, my lord, that is, my lord, there.
Why shouldn't it be 2,000 as said by
1,000, my lord, commercial premises, my lord, that is the.
Ask your learned junior to deduct 2,000 from 8,600 and what is that amount?
6,000, 5,800.
6,000?
Something about 6,000.
Around about 5,000. We'll make it 5,000, Mr. Chakraborty. 5,000 crores. Third, learned counsel for the parties. Full stop. The present appeal arises out of an eviction decree passed on the expiry of lease. On the expiry of lease under the Transfer of Property Act. Full stop. Next para. Learned counsel appearing for the appellant files his affidavit in reply, which is kept on record. Full stop. Relying on such affidavit in reply, comma, it is contended by the appellant that the occupation charges cannot be higher than rupees 2,000. Full stop. Learned counsel also places reliance on the annexure to the affidavit in reply, annexures to the affidavit in reply, which respectively show that rent was being paid at the rate of rupees 314 per month initially, in support of which a photocopy of a purported rent receipt has been annexed, and that subsequently rent was being paid at the rate of rupees 421 per month, being deposited with the rent controller, comma, in support of which a challan has been produced. Full stop. Next para. Learned counsel for the respondent, plaintiff/respondent places reliance on the valuer's report annexed to the affidavit in opposition of the respondent. Full stop. It is submitted that the rent receipt annexed, the purported rent receipt annexed to the reply must be manufactured, since the counterclaim of the appellant in the court below seeking declaration of tenancy right was dismissed primarily on the ground that no rent receipt could be produced for the premises. Full stop. Next para. Learned counsel for the appellant, comma, in his rejoinder, comma, submits that the valuer appointed by the respondent could not even have an inspection of the premises in question, and the premises is much less than 100 square feet, comma, roundabout 80 square feet. Full stop. Next para. We find from the records that the rent receipt, the purported rent receipt and challan, purported rent receipt cannot be relied on, since no such rent receipt was produced in original in the code below. Full stop. Next para. That apart, comma, the challan showing deposit by the appellant cannot be a good indicator of the current rent, comma, for two reasons, comma. First, that the same is a unilateral deposit by the appellant on his own assessment, and secondly, comma, that since the suit is governed under the Transfer of Property Act as per the impugned decree, comma, there was no scope for deposit of rent before the rent controller appointed under the Rent Control Act of West Bengal. Full stop. Next para.
Civil deposit according to
Under which provision? Next para. That apart, comma, the rent paid for a tenancy which was granted much earlier cannot be a valid indicator of the current market rent, which can be fetched by the respondent if the property is let out at present. Full stop. Next para. Based on such index, comma, we find that a balance has to be struck between the valuation of the independent valuer appointed by the respondent, comma, which fixes the monthly rent at rupees 9460 by adding 10% for within double inverted reasonable outgoings, double inverted close, without explaining what reasonable outgoings are. Full stop. Even apart from the same, comma, the monthly rent assessed by the valuer would be rupees 8,600, comma, which has to be assessed on a balance with the self-assessed market rent of rupees 2,000, which is the maximum at which the said amount has been put by the appellant. Full stop. Considering the location of the premises in the northern portion of Calcutta, Kolkata, comma, and that the place is not extremely posh or so commercially viable that a rent of rupees 8,600 would be imposed, comma, we are of the opinion that that an amount of rupees 5,000 per month would be a reasonable assessment of the market rent, which can be fetched for the suit property, which is a little less than 100 square feet. Full stop. Next para. Hence, Can 1 of 2024 is disposed of by granting stay of operation of the impugned decree as well as all further proceedings in the connected execution case till disposal of the appeal, subject to the appellant going on paying occupation charges at the rate of rupees 5,000 per month directly to the respondent, to the give an account, give a bank account.
By Friday, we will supply the bank.
Directly by online transfer to the bank account furnished. The particulars of which shall be furnished by the plaintiff respondents within March 7, 2025 to the learned advocate on record for the appellant in writing. Full stop. Next para. The current monthly occupation charges starting from the month of March 2025 shall be paid by the 15th day of March 2025 and thereafter current occupation charges shall be paid for each month by the 15th of the said month by the mode as indicated above. Full stop. The area occupation charges at the same rate, that is at the rate of rupees 5,000 per month, shall be paid by 4 equal monthly installments from the date of passing of the impugned decree, from the month of passing of the impugned decree till February 2025. 4 equal monthly installments. Full stop. The first of such installments shall be paid by the 15th day of March 2025 and thereafter the rest of the installments by the 15th day of each succeeding month, rounding off the rounding of the balance to the last rupee with the last installment. Full stop. Next para. In default of payment of any of the said amounts, the stay order hereby granted shall stand automatically vacated without further reference to the court. Full stop. In view of the appearance of the respondents through their learned advocate, service of notice of appeal on the respondents is dispensed with. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who shall have liberty to the parties to mention the appeal for inclusion in the list before the appropriate bench as and when the appeal is ready for hearing.
There is another appeal.
Another appeal, my lord, against the counter claim, no appeal was preferred. My learned took the point and that was pointed on 15 January.
Which is item number?
The next item.
21.
Petty 58.
21.
Lord,
21 filed over.
Immediately after the order on
Is a section 5 must be then.
Section 5. That is, I am immediately after the order was passed on 15th of January, I applied for certified copy on the next date, that 16 January.
What is the ignorance of law?
Yes, I have stated that I was not properly advised, my lord.
Allegation against me.
No.
You?
Yes.
No.
Where is that?
Yes.
Which para?
No. I have came to know from you.
No. Kindly see page.
Let us see whether that is credible. There are certain allegations against you which may be credible.
That they have
Let us see the paragraph.
Yes, page 5 para 14 that the said application came up for hearing before the court of Honorable Justice Shobhashachi Bhattacharya and Honorable Justice Uday Kumar on 15th January 2025, and at the time of hearing, learned advocate of the respondent appeared and took a plea that since no appeal has been preferred against the dismissal of the counterclaim.
This is not an allegation. You took the
appreciate it is their matter. They
cannot. Where is the
prove
question
it
of allegation? Don't be super sensitive.
Well, I'm taking it back.
You took this point.
Yes, definitely. Kindly see my
What is the
submission.
allegation?
Kindly, Millard, appreciate one thing. It's
You took
their
the
matter.
point, yes.
Yes, definitely. That is my submission is recorded in the entire order. And one thing, Millard, they cannot put it on me as a ground.
They're not putting it on you. They're thanking you. They're saying you took the point. Therefore, they understood their mistake and have filed.
Kindly see, Millard, page 20, para 20 at page 6.
Kindly see para 17. That immediately thereafter the appellant understood the mistake on his part.
Millard,
So you are the savior.
Millard, he was represented by a very senior advocate here and also the same advocate in the trial court.
Hearing
have Millard given proper advice.
At the time of hearing, I was engaged. I'm not.
In the trial court also there, in high court also there.
Trial court, I'm sure.
Kindly see Millard, page para 20.
But Mr. Chakraborty, ignorance of law is not a ground.
No,
But ignorance of lawyer is a ground.
Ignorance of fact as well, because
my point is, if they think
What
that
fact?
they are this appeal they can maintain without them, let them withdraw the appeal.
No.
By putting it on me, but I have taken.
I am not putting it. I'm not putting it.
Can 1 of 2025 is an application for condonation of delay of about 220 days in filing the appeal. Full stop. The brief facts are that an eviction suit was filed by the respondents, comma, in connection with a counterclaim claiming tenancy rights was filed by the present appellant. Full stop. Whereas the eviction suit was decreed against the appellant, comma, the counterclaim was dismissed. Full stop. Against both, comma, a single appeal was preferred. Full stop. Next para. Upon an application in connection with the said appeal being moved before this court, comma, the learned advocate for the respondents took a plea that the present appeal is not maintainable in view of the plinth of the that the said appeal is not maintainable in view of the plinth of the arguments in the other appeal is that the appellant is a tenant, whereas the counterclaim in that regard has been dismissed. Full stop. Next para. Upon learning of the mistake in that regard, comma, the appellant immediately instructed counsel to file the present appeal, and thereafter the same has been filed. Full stop. Next para. Learned counsel for the respondent submits that that aspersion has been cast on the respondent inasmuch as he took the maintainability point in respect of the other appeal. Full stop. Next para. However, comma, we do not find any such aspersion. Full stop. Rather, comma, the appellant has claimed that only upon the maintainability of the other appeal being taken by the respondent's counsel where did they become aware of their mistake, and as such, comma, they have rather gave credit to the learned counsel for the respondents rather than making allegations against him. Full stop. Be that as it may, comma, although strictly speaking ignorance of law is not a ground, comma, since the appellant was assisted by counsel and there was some communication gap apparently regarding the subsistence of a decree dismissing the counterclaim at the time of drafting the previous appeal, comma, taking a liberal approach befitting a condonation of delay application, comma, we grant the benefit of doubt to the appellant. Full stop. Accordingly, can 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FAT 58 of 2025. Full stop. Next para. Since the present appeal, what is the other appeal?
58.
Since the present appeal arises in connection of the same suit as FA 1 of 2025, comma, we are of the opinion that the two appeals shall be heard analogously. Full stop. Accordingly, since we have already directed the appellant to file paper books in connection with FA 1 of 2025, comma, we add the rider that such paper books filed in connection with the said appeal shall be a composite paper book incorporating the relevant papers in respect of the present appeal as well. Full stop. In view of directions having already been passed regarding analogous hearing of the appeal with FA 1 of 2025 and records having already directed to be brought by special messenger, comma, we do not pass any further order in that regard. Full stop. In view of appearance of the respondents to their learned advocate, comma, service of notice with regard to the present appeal is also dispensed with. We'll come back for the next one.
This is Mr. Gupta's appeal. Lordship had directed us to take instructions as to whether we can settle the disputes.
Acha.
My Lord, it's pertaining to the ground floor of a particular property where Mr. Gupta's client claims to be the owner of a shop room. I am in occupation and I own one more shop room. I obtained an order of status quo on the entire ground floor.
Oh, right.
My Lord, we have taken instructions, but my Lord, we'll have to clarify certain aspects. I have indicated to my learned friend's advocate record. May we come back next week, my Lord?
Absolutely. So when should you keep it? Give us a date.
Uh,
We are on 4th today.
Next Tuesday or
Next Tuesday.
Wednesday?
Next Tuesday we are keeping the
Right.
Fair. It is submitted by learned counsel for the parties that the talks of settlement are at an advanced stage. In order to enable the parties to come to a solution, let the matter be adjourned till March 11, 2025, when it will be listed under the same heading.
Great.
Well, I am for the appellant petition.
Yes, Mr. Rohit, what is the
An
application?
application for stay of all further proceeding of title suit number, well, after the preliminary degree was passed and also prayed for including.
You have challenged the preliminary partition degree. So we'll pass the usual order, Mr. Rohit.
Yes.
No final degree will be done.
Yes, commissioner work would go on,
Yes.
but no final degree will be done.
So you'll have to also serve copy on the other side.
We have already served the caveat.
Where is the receipt or something?
Yes, this is the receipt, but they have received on the application. Mallosi Maiti.
Mallosi Maiti is a regular in this.
That's I could not find her out. She has accepted.
Yes, yes.
Usual order is passed, Lord.
Yes, usual. No, not for that. We dispense with the notice of the appeal also then, if she was present. But
And
then we
Lord,
have to keep this receipt, this entire copy on record then.
I would file the Xerox copy of the.
Mr. Rokit, can you please just give a notice to Ms. Maiti that we'll keep it tomorrow and we'll dispose of the application and pass directions dispensing with service of notice of appeal and all this.
I have sent my clerk to inform her.
So we are adjourning it till adjourning it till 2 p.m. We'll take it up to 2 p.m.
If in the meantime,
if you can get her,
she is available.
Yes, yes,
yes.
She sits in her father's room. I mean,
Yes.
2.
Number 2.
Mr. Rokit, send somebody.
Yes, I have sent my clerk.
So we are adjourning it. We are just adjourning it, not be fixing it at 2. We are just adjourning it. Whenever she comes, after the matter going on matter is over, then just mention. We'll take up the matter. Just pass over.
Just pass.
It a pass over tha. Whenever Ms. Maiti comes, just mention. Next. Pass over side code.
Before the response.
Yes. Right.
Lordship, this is our reply. The affidavit in opposition filed by the respondent. We have served on that.
Yes, yes. What is the matter about?
Again, I'm praying for time since my senior has undergone a surgery and he's not present at court, Lordship.
Are you enjoying any interim order in this? Yes. No, then we won't grant it. You have to move. What is the appeal against?
Lord, eviction of trespasser. Lord, they have appealed against, and my lord, today is the date, my lord, for fixing the occupational charge.
He is undergoing surgery today.
Lordship, 2-3 days before.
So when can she come to court?
Advocate Mola Bhattacharya, Lordship, he will.
He
will come on 10th of March, Lordship. He is on bed rest, Lordship.
Keep it after that. Surgery. An adjournment, the affidavit in reply filed today be kept on record. Since an adjournment is sought on the ground of the ailment of the learned counsel for the appellant, let the matter stand adjourned till March 11, 2025. Yes.
My application ballot.
Yes.
Yeah, my lord, your lordship has granted us a interim protection, my lord. Now today, my
This
lord,
is the matter about Mr.
my lord, eviction, my lord, of a tenant, my lord.
My lord, this
And
is
my lord,
our affidavit in opposition.
So for occupation charges now.
occupation charges.
My lord, there are another appeal also in respect of the subject
It is
matter.
not appearing here.
No, it is not appearing because because my learned friend has not mentioned this matter.
No, no,
before
mentioned
lordship.
both, my lord, one scheme, my lord.
Acha, this is Mr. Arifin. This is against eviction on the ground of what?
Ground of my lord, reasonable requirement.
Of Premises Tenancy Act. What is the other appeal?
No, my lord, this appeal is against the dismissal of the suit filed by my learned friends.
The suit was for declaration.
Declaration.
Of what?
Tenancy right, my lord.
Declaration of tenancy right, where the father is.
But that has been dismissed.
Yes, that has been dismissed.
And
And your counterclaim was for?
Counterclaim.
Your counterclaim was on the basis?
And we got the deal.
No, your counterclaim was you admitted him to be a premises tenant.
No, no.
2G.
2G.
That appeal has to be heard along with it then.
Yes, yes.
But there is no application in that, obviously.
No, there is also application. There is also.
Oh, no. There has to be an application for stay in that only.
That only.
That is
Yes,
also there.
Yes, because that is the eviction degree.
That is also there, my lord. That application is there, my lord.
No. This application is relating to the dismissal of the suit.
On the stay application also filed in that application also, my lord, or stay.
No, 1 minute, Mr. Arifin. If this appeal is against the dismissal of the suit, there cannot be any scope of stay.
No, they prayed for operation of the degree. Operation of the degree.
Even if the operation of the decree is stayed, then the eviction degree counterclaim remains.
Passed by your lordship.
That's why that day I asked my lord
Stay
to
order is-
analogously hear both the appeal, my lord. If your lordship wants to hear my lord, analogously hear.
Eviction degree was passed in my counterclaim.
No, give the numbers of the other application.
292 of 2000.
No, they'll give you on a slip of paper. Please give on a slip of paper. Your application, you give the numbers.
292 to second appeal. Another appeal.
This one is 290. This is 291, my lord. Another is 292, my lord. Along with can 1.
We preferred we condoned the delay only. You have not granted it any stay. Did you grant stay?
Yes.
On which date?
My lord, 10th February.
No. এটাতে 291 291 যেটা এখন আজকে উঠেছে এখানে স্টে দেওয়া হয়েছে
292 of 2020. 292 of 2023.
The affidavit in opposition and reply filed to be kept on record. Push of learned counsel for the respondent points out that the present appeal arises out of the dismissal of a suit filed by the appellants for declaration of their tenancy rights and consequential remedy of injunction. Push of next para, it is submitted that as such, there is no scope of grant of any stay. Push up, it is further pointed out by learned counsel for the respondent that in a parallel counterclaim filed by the respondent in connection with the self-same suit for eviction of the appellant on the ground of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997, the said counterclaim has been decreed against which also another appeal has been filed. Full stop. Next para, we find upon hearing parties that in view of the circumstances of the case, there is no scope for grant of stay of the dismissal decree in respect of the suit for declaration filed by the appellant. Full stop. Next para. Rather, it would be for the appellant to choose as to whether an application for stay should be moved in connection with the eviction decree passed in respect of the counterclaim of the respondent. Full stop. Since it is submitted that an appeal in that regard and connected applications are also pending, the said applications be listed along with the present application on March 10, 2025 for being heard together. You have given the numbers? ওই application এর সঙ্গে আসবে. We can treat, because if you have stated about the occupation charges in these affidavits, we'll treat these as pleadings for that also. Yes.
Next one is 292.
Grateful.
Please tally the number, whether the correct number has been given. Just check up. পরের সপ্তাহে আগেরটা কিন্তু ওইগুলোর সঙ্গে আসবে এক সপ্তাহ।
My lord, I am appearing for the
Yes,
Right.
Section 5 এর পরেরটা 27 এর counter claim এর।
oh, one section 5 application is there in counterclaim. Now, my lordship kindly see, my lords, it is for partition.
So it is
my
for
lord-
partition. You have challenged what? Preliminary degree or final degree?
My lord, preliminary.
Preliminary.
My lord, kindly look at page 37.
Of can 1?
No, my, oh, sorry, of the stay application. Oh, I see, my lord, the limitation has, my lord, that I have,
Limitation is there first, yes, that
yes. That, my lord, 30,
7 days delay.
no, it is, my lord, 52 days delay.
52. What is the reason given, Mr.
The
Bachchu?
reason, my lord, I have stated.
কোনটায় বলছেন?
Counter
Well,
claim. Counter
Can want.
Can 2 is section 5.
claim.
Yes. Well, actually, well, learned advocate.
Possibly your lordship is looking, there are two appeal. Your lordship is
This
looking
is FAT 344.
First, 26th.
at 345. এটা second.
Oh. It is 45.
You are not assessing properly.
কোনটা আমি দিলাম?
এরপরেরটা প্রথম অ্যাপিলটা এটা
344 is the second one.
No,
No,
344,
ফার্স্ট ওয়ান।
first one.
FAT 344 is now FA 115.
Yes,
So the first one.
first one.
So the,
My lord,
yes, Mr. Mukherjee, we are allowing the section 5.
Section 5, মানে possibly your lordship has already grant interim order and everything. মানে
So you are allowing the section 5 formally.
এটা কি section 5 লাগবে না? Within time it is sir.
ডিগ্রিটা তো দেরিতে স্যার দিয়েছে করে।
Possibly it is within time. If you lordship see the stamp reporter's report.
Stamp report, one report is for 52 days.
As a certified copy of the impugned degree has not been filed.
File letter in
The later on, my lord,
Later on filed.
because my lord, that was not
90 rupee deficit court fee already paid.
Yes.
Right.
but that was not actually supplied by the learned advocate in the code below.
So, but there is no stamp reporter's report as to delay. He's
Delay.
right.
My lord, but my lord, I am
But,
telling you,
only-
lordship, my
only
lord,
one thing, my lord, although it is on oath, page 5, paragraph 5 of the stay section 5
We'll
application.
look into that.
Section
First, let
কোনটা
us check up whether it's actually time bound.
কোনটা বলছো?
প্রথমটা বলছি স্যার 344টা
Can one?
এটা হচ্ছে
344
can 2 স্যার
পরেরটার দিকে জাজমেন্ট হচ্ছে 9 সেপ্টেম্বর অ্যাপ্লাই করলো 30 4 দিন ওখানে নষ্ট করলো
344 can
সব দিনে হয়ে গেল 19th পেয়ে গেল আর তার মানে ওর বাকি রইলো 84 ডেজ
কত বলছো?
84 ডেজ ফাইল করেছে কবে 84 ডেজ from সেপ্টেম্বর
তোরা তো দেখো
সেপ্টেম্বর
তোরা
অক্টোবর নভেম্বর ডিসেম্বর
নেই আমার তো দেখো
টাইম কি আপিলটা কবে থাকলো দেখে নেবো
90 days possibly within time.
হ্যাঁ আপিলটা
within time.
yes
Therefore section 5 is not required, although but in page
Can 2 of 2025 in connection with FA 115 of 2025 is an application for condonation of delay in preferring the appeal, full stop. However, comma, upon ascertaining the dates of obtaining the certified copy and application for the same, comma, we find that there is no delay in preferring the appeal, full stop. Accordingly, Can 2 of 2025 is dismissed as infructuous. Full stop, next para. Stay we are disposing of.
yes, your lordship has already passed an order, my lord. Kindly
We are
check.
final. We are making that absolute.
Yes, yes. Your lordship has passed an order on
well,
10 December 2024.
No, Can 2 was kept pending. We decided that substitution or something expunging on him.
yes,
that,
expunging has been done.
that we have decided.
Expunging my lord, that has been done.
Achha, Can 1 of 2024 filed in connection with FA 115 of 2025 is now taken up for hearing. Full stop. The present appeal arises against a preliminary degree of partition. Full stop. Since questions of both fact and law are involved in the appeal, comma, we find prima facie case for hearing the appeal on merits. Full stop. Accordingly, can 1 of 2024 is disposed of by directing the learned trial judge to continue with the final degree proceedings. Semicolon, however, comma, the learned trial judge shall not draw up the final decree without prior leave of this court, comma, till disposal of the appeal.
Therefore, 10 December 2024 order is made absolute.
Whatever, we have decided. Push up next para. In view of the appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with. Pushed up. The trial court records be called for by special messenger at the cost of the appellant to be deposited within a week from date. Stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Stop. Liberty to mention the appeal for inclusion in the list for hearing as and when the same is made ready for hearing. What is the other appeal?
Your Lordship is
That is
disposing
for a
of can
counter
1.
claim against can.
Your Lordship has disposed of can 1.
Can 2, can 1. Can 2 dispose of as infractuous, can 1 also.
Can 2 is one at section 5, kindly that become infractuous.
Yeah.
That we have disposed of first.
And to expunge over it.
Will you dispose of the appeal also by allowing it?
There are number is not matching,
No.
that's why.
Now, my lord,
Section 5, stay both. In our number is relevant because that is what is in the record.
my lord,
Liberty to mention it.
my lord, that is
early.
your appeal.
Given.
Appeal against.
Not
counter.
early. Yes, Mr. Muthu, you are sorry. The other appeal is?
My lord, against my lord, counter claim.
Counter claim was for?
In the same order.
Same order it has been.
No, you are the defendant, your counter claim.
Yes. I am the plaintiff there.
You are the plaintiff, preliminary degree you are dissatisfied, you have challenged the other appeal against it.
My lord.
Mr. Roy, you are all right? There was a sound? Achha. Anyway, what was your counter claim? What was your counter claim?
My counter claim is for eviction as well declaring 50% share. Now, my lord, second part has been turned down. First part 50% share has been declared.
So, there is a section 5 in that also.
Yes.
This is a real section 5.
Yes.
Yes.
52 days delay.
52 days.
52.
My lord, I have given the.
এখানে বলছে 37. You have explained 37 days.
Yes. But, page.
If the entire period has been explained, the number. What is the explanation?
Para 4 and 5.
If that be considered, my lord, then my lord, that person has to be given notice. Allegation against lawyer.
Provide with a single copy, not an allegation exactly.
No. It is stated that after prolonged period of time, Mr. Shama Prasad Das, learned advocate of the appellant, only provided with a single copy of the judgment.
Did
But
not,
as if my lord, the advocate did not provide the 2 copy of the judgment.
why do you read that into it? He provided
Ignore.
1 copy.
I say ignore, subject to correction.
Before we get Sham anyway, in view of sufficient reason, এটা হচ্ছে can 1 of 2025 in connection with FAT 45 of 2025. In view of sufficient, hard learned counsel for the parties. Full stop. In view of sufficient cause for the delay having been explained, can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT 45 of 2025. Full stop. There will be no orders to cost. The appeal be deemed to stand registered and admitted. Full stop. Next paragraph. Can 2 is an application for stay of operation.
That I am opposing. Because my lord, only 50% share has been declared.
Now, my lord, I tell you, lordship, there is one clinic in front of the house. Now, my lord, learned trial judge decided that no existence of clinic.
Mr. Moitro, this counterclaim is in the nature of a defense to the partition suit, basically. He sought declaration of 50% share, but he could resist your partition decree also on the same ground. So virtually, if you have directed the suit to continue, if we stay the operation of this, it will continue without that 50%, which will be interfering before hearing the appeal.
My lord, I tell you, lordship, my lord, how 50% will be.
That will be decided in the appeal. That is sub judice.
That's why, my lord, your lordship will.
Let the commissioner work proceed on the basis of that 50%, but we'll keep it obvious. It will.
Yes.
We'll record something.
But
Can
my lord,
2 of
I am telling you, lordship, I am submitting one thing.
yes, yes,
to
Mr.
lordship's
Moitro, yes.
approval. My lord, the clinic which is in existence for a long time, because mother of the plaintiff was doctor. Father was also doctor. Now, my lord, trial judge, my lord, denied that. My lord,
Denied the what?
But
That they were doctors
no. There is no existence of
of the clinic.
My lord, that is.
No, these will be sub judice in the appeal. Mr. Moody.
My lord,
All questions are open. We are
During
not
this period, nobody will disturb that.
If you pray for an injunction, we could have granted that. That is the difficulty. You have prayed for stay of operation of the preliminary. That is what we cannot grant stay of operation of that counter claim.
In the court below, injunction order was
Count,
different.
counter claim, my lord, I am.
But in this appeal also, this appeal, if FAT 45 of 2025 is against a counter claim, then you should have asked for a stay of operation of the count. Oh, you have done that. You have done that. This, if you grant this stay, that will be prejudicing that will be virtually allowing your appeal.
No, my lord, till the disposal, I tell you, Lord Shiva.
Then the commission work will proceed without that 50%, although the trial court has held their 50%.
Yes, but let them proceed. But my lord, my business
will give you a liberty to file an appropriate application for injunction if you want. This is for stay. This is not an injunction application. Can 2 of 2025 has been filed for stay of operation of the preliminary decree where passed in a counterclaim in connection with a partition suit, whereby the respondent's counterclaim seeking declaration of his 50% share in the property was decreed. Whose of next para? In the event a stay of operation of the same is granted at this stage, the same would tantamount to allowing the appeal before the final hearing of the same, since the declaration of such share has a direct effect on the allocation of shares, which will be the subject matter of the final degree proceedings. Since we have already granted an order, we have already passed an order in the connected appeal against the decree passed in the suit, that is FA 115 of 2025, whereby we have permitted the learned trial judge to proceed with the final degree proceedings, but not to draw up a final degree without the leave of court, there is no scope of grant of any further stay in connection with the present appeal. Accordingly, Can 2 of 2025 is disposed of by observing that the outcome of the present appeal will be subject to the interim order passed in connection with FA 115 of 2025. Push up next para. Since learned senior counsel appearing for the appellant submits that there is scope of disturbance of the running of a clinic at the suit premises by the respondent, but the present application is not one for injunction, nor have any specific averments in support of injunction been pleaded herein, leave is granted to the appellant to file an appropriate order of injunction in connection with the appeal, if so filed, the same will be decided upon hearing both sides by this court independently without being prejudiced by, without being influenced by any of the observations made here. Paper book directions we have given in the other matter.
And record as the appeal is arising out of appealship.
Acha.
In the second matter also, my junior has filed the vocalatnama, therefore no question of service of appeal.
In view, I have to add, continue. In view of appearance of the respondent through his learned advocate, service of notice of appeal is dispensed with. First of next para. In view of the direction passed in connection with FA 115 of 2025 for preparation of paper books and ancillary directions for bringing the trial court records, such further directions need not be passed in the present appeal, which arises out of a counterclaim in the same suit. Full stop. However, the direction for filing of paper books passed in connection with FA 115 of 2025 shall be deemed to connote, connote that such paper books shall be composite paper books for the purpose of both the appeals, incorporating the relevant papers in respect of both the appeals. Full stop. Anything else remains? No, nothing further. আরেকটা লাইন অ্যাড করে দাও FAT 45 of 2025 shall be heard analogously with
Order
FA
has
11
already been passed.
already passed.
Earlier, okay, earlier day, my lord, last day.
Last time. However, this time-
Analogously along with FA 115 2025 as per our previous order.
Okay.
Next.
Item 23. Yes, almost similar.
We'll take that up first. 23 target. Miss Chatterjee, wait. Yes.
Today's accommodation, my
Why
lord.
today's account?
No brief, nothing else. My lord, the caveat was served long before and
23 টা একবার বোর্ডে দেখান on the prayer of learned counsel for the respondent the matter is adjourned till March 10 2025 come back on Monday sir about 28 টা
that day I will be.
item number write Ms. Maiti please write the item number also with you. Okay, sorry. Yes, Mr. Chatterjee.
Yes, my lord, I'm appealing for the appellant.
Mr. Rai for the other side.
Right for the other side, my lord, but my lord, fairly submitting supporting me.
He has broken in the courtroom into the courtroom
Lord, I ensured Mr. Roy is safe.
because you took the brunt of the attack. What is the application for?
My lord, this application, my lord, is my lord, I tell your lordship, the impugn order is challenging, my lord, where my lord, my application under the Guardian and Wards Act seeking appointment of guardian in favor of the appellant, my lord, has been dismissed on the ground of being non-maintainable.
No, minor daughter.
No, my lord, what happened here, my lord, is my lord, the appellant is my lord, a person, my lord, who was traveling, my lord, out from his work to his home, where in the midst of the road, my lord,
That.
yes. Now, my lord,
Who is the respondent? Mother.
the grandmother.
Grandmother.
But his mother is, my lord.
Do you agree that she's
That is why, my lord, and declaration has been filed by.
why not maintainable? Why here?
Yes. Now, my lord, the court says that the under the Juvenile Justice Care Act, my lord, since the child, my lord, is abandoned child, therefore directed the authority committee under the act, my lord, the child to be sent there and dismissed, my lord, this suit. Now, my lord, may I just take, my lord, through the impugn order once, my lord, I would be, my lord, submitting, my lord, today, my lord, the Juvenile Justice Act, my lord, doesn't come into picture.
Why?
My lord, that's why, my lord, kindly takes up the impugn order once.
We would be very happy to pass an order in your favor. But give us the handle.
Yes. Now, my lord, I would read, my lord, kindly read from, my lord, this part kindly turns to internal page 3. Internal page 3, the second paragraph.
You saw the child being the child was
No, my
it's
lord,
it's a girl.
it's a two boys.
Two boys, twin.
Twin.
The twins you see custody of both.
A custody
The
of
twins were born on the footpath.
No, my lord, the mother was, my lord, the amino fluid was flowing. At that time, the appellant took the lady, my lord, to the hospital.
Oh, right. You took her from the
Street
footpath
to
to the
hospital.
and
my lord,
there
in
she gave
hospital,
birth.
She gave birth.
And you
my
took
lord,
the
in from hospital, my lord, the grandmother, my lord, said that you take the custody and nourish them well and bring
But
bring them
apparently
up.
that flouts the JJ Act.
My lord, I tell your lordship, my lord, here, my lord, here's the question, my lord, I say, my lord, hospital is under the JJ Act, my lord, the authority is given to the hospital, nursing home or any organization when they come to and finding that the child is not in care or
How long are the children with you?
For now they are, my lord, almost 2.5 years, 3 years, my lord, they are going to school.
Almost 3 years.
3 years, they are going to school. 21 born, 2021, 4 years, 2021 born.
Date?
My lord, date of birth is 28th of August 2021. So, my lord, now my lord takes up the impugn orders.
Yes.
Now, my lord, I read from here, my lord, page 3, the respondent number 2. Or, my lord, the first paragraph, upon by the petitioner as annexure F, internal page 3. Upon by the petitioner as annexure F, the petitioner submitted that the said two newborn children were then continued to be nourished and being brought up in the care and custody
Have
of
you
the
got a copy of the JJ Act?
Yes.
Just hand over.
And I have a photocopy as well of that.
Give the photocopy because both of us require.
একটা কপি আছে তোমাদের
হ্যাঁ একটা ফটোকপি আছে একটা বই
বইটা ওনাকে দিয়ে দিন, ফটোকপিটা আমাকে।
কি হয়েছে?
আমার একটা জিজ্ঞাক লাগবে তো
শেষ হয়ে গেল?
হ্যাঁ
আমি তো
Yes.
বুঝলাম।
Yes, let
দেন
us
আমার
know.
জিনিস
Yes, Mr.
Yes, Sona. The petitioner submitted that the said two newborn children were then continued to be nourished and being brought up in the care and custody of the present petitioner without any intimation to appropriate authority, entrusted with the proper care and custody of any unattended minor under the existing law in this regard, where the natural guardian is not in a position to exercise the proper care and protection of the newborn minor in the circumstances of the knowledge of the fact that the said Farida Bibi, the biological mother and the only natural guardian, is again missing from her parental
Farida
house.
Bibi, you say, is the grandmother?
No, Farida Bibi is mother, Ohela Bibi is the grandmother, who is respondent number 2.
Oh. She's represented by the next friend. Right.
The biological mother and the only natural guardian is again missing from
When
her
at present she is missing.
Yes.
Yes, mentally disabled.
Mentally
That was the case where
She should also have been.
She was in
put
my custody, my lord. She is mentally
She should
schizophrenic.
have
She
been
went out of
put
the
in a
door.
mental hospital.
She was there, released from the hospital, from Pavlo.
Huh.
Then, my lord, she was found on road. I took took her in my house. From there, she again went missing.
You have lodged a missing diary.
Missing diary to that.
Anyway,
For
yes,
which
GD number is there.
yes, for which his brother Kokonali reported the matter before the Narayan PS, white such and such. The copy of the same is relied upon by the petitioner and annexed to G. Respondent number 2, Viz. Ohela Bibi, the mother of the said Farida Bibi, only filed her consent stating that due to her poor financial condition, she is not in a position to take care and protection of the said minor wards, and as such has no objection if the custody of the said two minor babies of the tender age may be handed over in favor of the petitioner. Peruse the documents relied upon by the parties, wherefrom in terms of the discharge certificate of the said respondent number 1, being the mother of the said two children, is referred to Pavlov Hospital as the patient was found mentally violent and aggressive in terms of the discharge certificate dated 30th October 2021. The petitioner was also filed the photocopy of the birth certificate of the said two minor children, namely Vidush and Vedant, issued by the sub-register birth and death, Arjikor Medical College and Hospital dated 30th October 2021, wherefrom the name of the mother transpired to be Farida Bibi. On perusal of the other document, it also appears that the brother of the said Farida Bibi also made an application before the Superintendent Arjikor Medical College and Hospital dated 28/9/2021 for ligation of the said Farida Bibi, and one discharge certificate of new Monobikash Kendra dated 18th July 2017, confirming the name of the patient Farida Bibi, reveals that the said respondent number 1, Ms. Farida Bibi, was suffering from schizophrenia. The petitioner also filed the photocopy of a letter as Annexure F dated such and such, addressed to the officer in charge Narayanpur PS with the request to get the said Farida Bibi along with two minor children to be admitted in mental hospital. The petitioner also filed other medical certificates regarding the treatment undergone by the said minor children from time to time considered. Then, my lord, on perusal of the entire materials made available on record from the factual aspect, the petitioner is no way connected with the said minor wards, either by family relation or by any valid instrument of adoption, but admittedly is having the custody of the said two minors of tender age. It is also admitted that in fact, the maternal grandmother of the said two minor wards of absolutely tender age, approximately 2 years, who are also not in a position to express their preference of choice, has stated and expressed unequivocally her incapacity to take proper care and protection of the said minors and not willing to take the custody of them. In the admitted context of having natural only guardian and mother with Farida Bibi is found missing and considered to be unfit and or incapacitated by the admitted fact of suffering mental illness, leaving the said minor sons of her in the state abandoned child, which comes within the sweep of the definition of the CNCP as defined under 14V and 14(6) of JJ Juvenile Justice Care and Protection Act. Therefore, in view of the observation, the petition under Section 7 read with Section 25 of the Guardian Ward Act becomes itself non-maintainable, along with petition filed under 12 of the said Act, with a prayer of interim custody having no jurisdiction of this court to entertain the same under the provisions of the Guardian and Wards Act. Hence, my lord, ordered. Now, my lord, here, my lord kindly visualizes the court says that the minors were in my custody, they were nourished, they were having, my lord, the care, my lord, from my end. But, my lord, the court went on to say that today, as I have no blood relation with the minors, court says the child is abandoned and, my lord, attracts the, my lord, act. My lord, in my respectful humble submission, this is something putting the horse behind the cart.
Act is fully attracted.
No, my lord,
Even if you forget that you have blood relation or whatever. 4, 5, 5 and 6
my lord,
both are applicable.
I shall. My
How
lord,
do you overcome that?
yes. My lord, both
Blood relation, those things were not. And in Mohammedan law, probably there is adoption concept is not there.
No, my lord, I shall under the Guardian and Wards Act and the definition of guardian under this act, my lord, is similar and is harmoniously, my lord, written down, so that, my lord, under the Guardian and Wards Act, also a guardian, my lord, can be anybody who is having the custody. He need not be by blood. So, my lord, if I have a custody of minor, my lord, and under the act itself, if my lord looks into the definition, anybody can be a guardian. My lord, it's not that.
But there's a non-obstante clause in this act, JJ Act.
Yes.
Then
My lord,
everybody will avoid this act, and there would be cases where this is misused.
that's why I say, my lord.
That is the larger picture. That
Yes.
is where we are having a, because
But
your
even-
case is obviously our full sympathies are with you, rather the children. They have grown an attachment to you. Obviously, for 3 years, it would be very cruel for us to take it. But the difficulty is this will be used. Anybody will come up, any third party. There may be sale of children also. The purchaser will
I
come up.
understand
The
what is-
so-called
what is
purchaser
going
will
through my
come,
lord's
file a
mind.
section 7, and it will be said conveniently.
No, my lord, that's why.
That is the larger
That is why,
picture
my
which
lord,
we are.
even in case of adoption through this act, my lord, the authority which is given, my lord, is to the district magistrate who will ensure the well-being of the child. My lord, court under the Guardian and Wards Act, my lord, acts as a ward, acts as a parent, my lord, parent to the children, my lord, who will look after whether the children, my lord, is having the well-being. My lord, therefore, my lord, both the acts, my lord, finally goes to a court, says that I am giving an eruption to this person and order is passed by a court. My lord, it's not that the under the act, the committee, my lord, is giving an adoption to somebody out of its full discretion.
Child has to be free for adoption. Those formalities have to be given, and then the CARA provides certain formalities for that. You have to put it for adoption, up for adoption. You don't have a right. Intestate adoption can be there. You don't have a prior right.
My lord, suppose
That is the difficulty, Mr. Chatterjee. You don't have a prior right then.
My lord, if my lord takes up the my lord act, my lord, both the copies have been handed up, my lord. May I have one copy? My lord?
Juvenile Justice Act, এটা দিন। ওটা দিয়ে দিন।
My lord, kindly.
Yes.
Takes up, my lord, section 3 of the act first, section 4. Subsection 1, subsection 4. When the act comes into play.
Yes.
Notwithstanding anything contained in any other law for the time being enforced, my lord has gotten, my lord. The provisions of this act shall apply to all matters concerning children in need of care and protection and the children in conflict with law, including apprehension, detention, prosecution, penalty or imprisonment, rehabilitation and social reintegration of the children in conflict with law. Procedures and decisions or orders relating to rehabilitation, adoption, reintegration and restoration of children in the need of care and protection. So, my lord, first is, my lord, whether the child is in need in care of protection. My lord,
Comes within the definition
yes.
here.
Now, my lord, quote, the impugned order says the child is abandoned, attracts JJ Act. Doesn't say or whisper the child is in, my lord, a condition where he needs care and protection. Now, my lord, apropos this, my lord, kindly sees.
Child in need in care and protection is defined in the Act.
Yes, yes. My lord, there are several definitions. I will read through those.
2.4 is there,
My lord,
2.14 is there.
I will show, my lord, I do not fall under any of the conditions.
5 and 6.
My lord, yes. Kindly takes
Let
up,
us
my lord,
focus on 5 and 6.
14, my lord, kindly takes up 14.
14, 5 and 6. Roman 5 and Roman 6.
Abandoned.
Satisfy us on these. And the court correctly quoted these provisions.
Yes, yes. My lord, first kindly takes up definition of abandoned child. 2.1. 1.
Yes.
Abandoned child means a child deserted by his biological or adoptive parent or guardians who has been declared as abandoned by the committee and after due inquiry. So, my lord, guardian is there. And, my lord, who is a guardian, my lord? Kindly takes up, my lord, 31. Guardian and Wards Act order. Now, my lord, these two definitions can be
31
read
of this Act.
of this act.
My lord, see, my lord's got that 31.
31.
231.
230. 230 বলতে হবে।
হ্যাঁ, two.
Yes.
Guardian in relation to a child means his natural guardian or any other person having,
In the opinion
in
of the
the
committee.
opinion of the committee, or as the case may be, the board, the actual charge of the child and recognized by the committee, or as the case may be, the board as a guardian in course of proceeding.
The moment this act is applicable, committee has the
Now, my lord,
authority.
yes, my lord, committee has the authority to see, my lord, whether I am a fit person to be a guardian. My lord, committee has no authority. If my lord sees, my lord, the chapter, my lord, which deals with this, says the committee will see whether the guardian who is in having the custody is a fit person. Now, my lord, if I am a fit person to be a guardian, my lord, I can be anybody. I am having the actual custody of the child.
Fit person is not linked with guardian.
Now, my lord, I tell your lordship, my lord, why?
Guardian definition is different. 31 is guardian, 28 is fit person. Fit person is for the purpose of this acting as a PAP or for foster care for those persons.
My lord, for that, my lord,
31 is not relatable to 28. 31 is independent. Guardian in relation to a child means the natural guardian or any other person having, in the opinion of the committee or the board, the actual charge of the child. You have actual charge,
I have actual
but
charge.
not in the opinion of the committee as yet.
So there is no opinion of the committee as of date.
The moment opinion of the committee or board comes into play,
Yes.
you will be governed by this act that is admitted by you.
Now, my lord,
Even
kindly
without your
takes up
admission.
now, my lord, apropos this, keeping this definition in mind, kindly takes up 214 subclause 3.
Yes, 3.
Who resides with a person, whether a guardian of the child or not, and such person.
This is not applicable to you.
Now, my lord, why? My lord, I read this definition. My lord, the committee, my lord, has to see whether the child has been subject to these tortures under a guardian. My lord, this is not, my lord, something.
You are not a guardian at all now. You have applied for being a guardian.
No, my lord, under the Guardian and Wards Act, I am a guardian, as well as under this act, as I am having the actual custody, my lord, I am a guardian. Now, my lord, it's of the committee whether I can be a guardian.
5 and 6, Mr. Chatterjee.
My lord, I read 5.
Why are you
I
reading
read 5.
four?
I will read 5.
4 is not, 14 is 1, 3 is not applicable at all.
Now, my lord, who has
Child has not been injured by anybody or.
No. Now, my lord,
5 and 6.
Very well. Who has a parent or guardian, and such parent or guardian is found to be unfit. Now, my lord, here is the question.
Typically, your case, parent is unfit.
Unfit. My lord, guardian is also unfit or incapacitated by the committee or the board to care for and protect the safety and well-being of the child. Now, my lord, 6. Who does not have parents and no one is willing to take care and protect, or who is abandoned or surrendered. Now, my lord, abandoned definition is, my lord, looked into. Now, my lord, therefore, my lord, 5 and 6 and 3, my lord, and guardian definition, if read together with abandoned definition, my lord, my lord, will see the object of the act is, my lord, to see the minor, my lord, who is in custody of somebody who is a guardian, having a custody actual charge, whether he is subject to some torture. If not, if the guardian is fit. Now, my lord, second is, my lord,
under this act, you are not a guardian. Under this act, for being a guardian, you have to be appointed so by the or held so by the committee.
Now, my lord, kindly takes up, my lord.
So once there's a non-obstante clause, that clause is inclusive, and that also takes care of child in need of care and protection, right?
Yes.
Now, child in need of care of protection includes 5 and 6. Your children, these 2 children, are covered by 5 and 6 squarely, either by both or at least by one. So if that is so, then if he's a child, if they are children in need of care and protection, then as per section 1(4), act applies. The moment the rigors of the act apply, you cannot bypass that by section 7.
No, my lord.
By a different act. There is a non-obstante clause here.
Now, my lord, this clause which my lord is saying, my lord, kindly takes up chapter 6, which deals with child need of child and care and protection. Chapter 6 of this act, section 31 onwards.
Yes.
My lord, kindly takes up 35 first.
35.
Surrender of children. A parent or guardian who, for physical, emotional, and social factors beyond their control, wishes to surrender a child shall produce the child before the committee. If after prescribed process of inquiry and counseling, the committee is satisfied, a surrender deed shall be executed by the parent or guardian, as the case may be before the committee.
You cannot constitute yourself to be a guardian.
Now, my lord, I take
because you have not been deemed to be a guardian under the by the committee as per the definition of subclause 31 of 3.
Now, my lord, this surrender, my lord, happens. My lord, suppose, my lord, a child, my lord, whose both parents have died in accident or somewhere or somewhat.
No, may not be.
My lord,
A parent may voluntarily, because she is not able to bring up the child, they may surrender.
They may surrender.
There are several cases, mostly that.
Yes.
Due to poverty or some other reason, or there are too many children, or maybe illegitimate child, she'll have some social problem. All these are reasons brought out by reports. These are reasons for surrendering a child. Whatever may be the surrender period, after a period, the child is fit for being given in adoption, free for adoption, that is the language used. Once that is done as per this act, we saw that provision. Then it is put up for adoption.
Yeah.
You don't have a special right in that. The difficulty is that the person who found, who nurtured, who has developed a bond, that is one of the fallacies of this act, which have been brought up before various forums. There is no provision for that in the statute, although there is a non-obstante clause. That is one of the great lacunae of the typical case of yours, this case. Typical case. Children have grown a bond. We cannot even imagine about you. What will happen to you if the children are taken away from? Even from the children's viewpoint. 3 years they have developed a bond with you. So it will not be for the welfare of the child, definitely. But even then, this act does not provide for any such gap.
Now, my lord, only one thing, my lord. I shall read, my lord, the provision to bring my argument to the level that the guardian, my lord, when
See, Mr. Chatterjee, you are being very candid.
Yes.
We could, on consultation with my learned friend, pass an illegal order if it's equitable. If it's for the ends of justice, we could pass an illegal order. We don't have, if it's, we are strongly satisfied that it is for equitable purposes. But in case of this act, there have been the purpose of the act, the judgment of the Supreme Court, thereafter so many judgments, the landmark judgment which brought this act into force. There were cases of gross abuse. Children were being trafficked. One order by us, neither of you challenge. That becomes binding at least on the courts in West Bengal. So then tomorrow, if a trafficker comes up and takes out a Section 7 application, and for poverty a street person hands over, there will be no protection, Sir Chatterjee.
No, my lord,
Because
only-
neither of
only-
you will challenge this order.
Only, my lord, I was also thinking aloud in this fashion, my lord. My lord, in that case, my lord, can keep a surveillance, my lord, by the authority to have a watch on me. My lord,
The order would be bad at the inception, because we would have to hold, despite our putting a surveillance, the binding effect of our order will become a precedent on that. Section 7 can override this act. That will be the precedentiary value of that, not the surveillance part. That is where we are in difficulty. Surveillance, the next court may or may not give a surveillance. And surveillance, Mr. Chatterjee, there cannot be a 24-hour round-the-clock surveillance. Cannot be. Cannot be. Even when children are given in adoption to homes properly, in accordance with law, even then there is a home visit for several months, years, reporting. But suppose somebody does not report, there is a lacuna there also. You cannot track the child. It's very difficult. And here we are opening up a floodgate of illegalities also. It will give succor to so many people who are in your position.
Now,
how can we bypass this act?
Only,
We'll have to hold then that this act can be overridden by Section 7 under certain circumstances, whatever may be the circumstance. Is that a correct position of law?
my lord, kindly takes up, my lord. 36, may I place 36 of this act? Because this act, 36 Juvenile Justice Act, Section 36, gives a power to the committee, my lord, to hold an inquiry. My lord, inquiry as to what? My lord, inquiry as to see, my lord, whether the child.
We are not the committee, Mr. Chatterjee. Then it goes back to the committee. We have to relegate it to the
my lord,
committee.
what I am submitting is, my lord.
The moment it is before the committee, you know what will happen.
My lord, exactly, my lord. That's why I'm saying, my lord, to what is falling from it, to give an handle. My lord, this committee, my lord, why this inquiry power is given? my lord, to see if he is with the guardian, the minors are with the guardian, then if it sees, my lord, the guardians are not taking proper care, then a fit person comes into picture.
Mr. Chatterjee, we cannot assume the purpose of the legislation and arrogate to ourselves the jurisdiction of the committee because the legislature is voted by people. We are not. The legislature is the representative of the people and they decide the policy of legislation. We don't have 142. That's the difficulty. Article 142 is not available with high courts or district courts. So legislature, whatever may be the purpose, we cannot look into the purpose and arrogate to ourselves, yes, very well, that is the purpose for appointing a committee. We are better than a committee. We act as a committee. No. Because whatever may be the purpose of the legislation, there is a legislation in place. And this has been legislated by the parliament, which is a body elected by the people.
Today, my lord, grandmother is available.
Everybody is available. We are also extending our hands. But this is not. This law is not.
My lord, if my lord takes the definition.
And there is, we have explored it like anything. There were other cases also on juvenile justice. While sitting singly, I also got. I mean, we explored all the provisions. We could not find any space for us to include. Very difficult to include in this. No space to include. If it's a child in care of, because these sort of people are regularly I mean, this is happening regularly before the district courts also. This is not a one-off situation. Happening regularly. We don't have any way out as yet.
No, my lord,
this order cannot be said to be bad.
My lord,
or what we can do, can we afford Supreme Court? No, why you are telling you? You can clarify in your order. If you, we will try still to find out any chink if you can do something. Because if you pass an illegal order in your favor, nobody will challenge, that will become the law. And that will give a handle to many illegal traffickers also. You are being very candid. Whereas it will be giving protection to many people, but we have to see even if one child is trafficked, that would be crucial. Or we can dismiss your appeal by giving reasons. And if you have the means to go to the Supreme Court, go up. 142 is available to the Supreme Court if the Supreme Court can do anything. But they cannot, because as per Supreme Court guidelines, we know the Juvenile Justice Committee and the other committees are there. Supreme Court is regularly giving strict guidelines on CARA to adhere to this strictly. We don't know what to do.
But,
or we can do this, we can keep the appeal, adjourn the appeal, sign it
till the age of
till the age of majority.
না বার্থ সার্টিফিকেট তো আরজি কোড থেকে দিয়ে দিয়েছে, সেটা দিয়ে স্কুলে অ্যাডমিশন হয়ে গেছে। বোর্ড সাপোর্টসে গেলে সই করবে।
Any other handle you can give to us? So you referred to.
I refer to, my lord.
Give your references.
My lord, I am not completing today. I will come back and develop if possible, because I want to give an handle. My lord, what?
File a very short written notes of arguments. Very short written notes of arguments.
My lord,
just give the sections, nothing else. Need not give anything else. Don't put in your flowery language. Flowery language is the court's prerogative. Just put in the sections. Mr. Chatterjee will definitely look into it, and Mr. Rai, you also help him.
Yes, yes.
And we'll record now today that we are fixing it on next Wednesday for filing of written notes of arguments. We have heard you, and we'll also record a line that this is not an adversarial litigation in view of the circumstances. Or are you opposing?
No.
You're not in a position to oppose.
My lord, the grandmother only says, my lord, I should be very fair, my lord. Today, my lord, the grandmother, the childs are nourished in such a fashion they are going to big schools, my lord. The grandmother says any event, if the committee comes in, my lord, then, my lord, the school will also be a problem.
School, everything will be a problem. Everything will be a problem.
That somehow we
can assure you that.
Somehow admission can be
we
done.
don't know where the children will be placed in adoption. And it's cross country now. You don't have an option. You don't have an option on anything. 3 options are given to you. If you choose, if you fail to pick one, then it goes back. You go back to the bottom of the list.
Bottom of the list.
My lord, if I
bottom of the list means you will get the adoption after you die. Posthumously, it may be given to you.
My lord, only handle, my lord, one more. If I say,
and you have not even applied.
No,
if you apply, you will be immediately your case will be in practice.
My lord, if my lord borrows the definition from Guardian and Wards Act to me to be a guardian under this act, and they say
I will surrender, and if the authority thinks fit, within 2 months they will give back the child. Look, that's the provision under this act.
Difficulties, Mr. Chatterjee, you are telling. We were thinking in that line while hearing you. But parent or guardian in this act has to be decided by the committee. Because the definition of that has been given, as you rightly placed. The guardian definition that is there in the act. Now, 31. 31 gives the definition of a guardian and puts a prerogative 100% on the committee to decide. In the opinion of the committee means it's a committee. Now, court does not have any role to play there. When does this come in? Whenever a child is in need of care and protection. 5 and 6 are applicable, Roman 5 and 6. Whatever you argue, whatever we say. 5 and 6, either both or one of those would apply. The moment that applies, it's they are children in care of need of care and protection, and this act applies. And then for guardian, we cannot look at Guardians and Wards Act or any other act. But I'll look into this. That's why the court said that you are not biologically connected, because otherwise other adoption Guardians and Ward Act could come in if you are if the parent was giving or you are a relative blood relation. There are certain grandmother is not taking in adoption. Then grandmother taking in adoption, all right. After that, you cannot give it to her.
No, the guardian, I being the
yes,
I can give adoption.
Mohammedan-law.
On the Mohammedan-law, I cannot.
No.
I cannot.
No.
There is a decision.
And they are unrelated. She is unrelated. He or she.
He is
she.
Now, my lord, a decision has been found by me under Mohammedan's law even. My lord, if my grandmother applies for guardianship, my lord, then she can be also given in guardianship despite my lord father being living.
She'll become the guardian then.
My lord, if she becomes the guardian, my lord, at least my lord, I will give the support. The child is having an ostensible support from my
foster care. You can still have.
I can have. I can give that ostensible support to these minors, my lord, which I have been doing for these 4 years.
Because once it's gone to the committee, my lord, everything will go. I had a talk with you.
My lord, they are having a support from my end. I was taking, my lord, care, keeping the child with me. It was not that the grandmother was not coming and seeing the minor.
For us, we have to adjudicate. We cannot avoid adjudication.
No.
Give us some time. We will not decide it immediately.
Maybe come back with a written notes of argument also.
No, we will not decide on that day also. We'll have to devote some time. It may take some weeks. We'll try to find out something.
Pressure, my lord, whether the grandmother can also apply for the guardianship.
No court would grant you guardianship in your financial means. Anyway, heard learned counsel for the parties. Full stop. It may be noted here that the appeal arises out of peculiar circumstances, by virtue of the impugned order, the learned trial judge has refused the petitioner's, the appellant's application under Section 7 of the Guardians and Wards Act for having guardianship of 2 minor children of about 3.5 years who are twins. Full stop. The short backdrop of the case is that the appellant found the mother of the said children. What was the condition you said?
Amino fluid was coming out in the street.
On the street, where she was on the verge of giving birth and amino fluids were flowing. Full stop. Next para. The appellant, like a good Samaritan, took the mother of the said children to a hospital where she gave birth to the 2 minor children in question. Full stop. Thereafter, throughout the period of 3.5 years from their birth, the children have been taken care of by the appellant with motherly affection. Full stop. Learned counsel for the appellant submits that in such a scenario, the rejection of the application under Section 7 of the Guardians and Wards Act would not only be in contravention with the spirit of the said act, read in conjunction with the Juvenile Justice Act, but also be against the interest of the children, comma, which is the paramount consideration in case of custody and guardianship, comma, since a bonding has developed an irretrievable and an unbreakable bonding has developed between the appellant and the two children. Push up next para. The present litigation, comma, it may further be noted, comma, is not adversarial in nature, comma, since the respondent, comma, who is the mother of the children, comma, is a proclaimed schizophrenic and has fled, and after being discharged from the mental hospital, comma, has again fled and is not being traced. Full stop. The said respondent is, comma, thus, comma, represented by her next friend, stroke mother, comma, that is, namely Farida Bibi. One Farida Bibi.
Ohila Bibi. Ohila Bibi.
Ohila. OILA.
OHILA.
OHILA, comma, who is the maternal grandmother of the children as well. Full stop. Learned counsel for the respondent submits that the respondent has no objection if the children are brought up by the appellant, comma, since it would inure to the benefit of the appellant, comma, particularly in view of the financial condition of the respondent as well. Full stop. Although we are fully aware of the sensitivity of the issue, comma, the matter cannot be disposed of without adverting to the facts and law of the case. Full stop. We have concluded oral arguments. Parties have concluded oral arguments. Full stop. Learned counsel for the appellant. Should you direct the parties or the appellant? Learned counsel for the parties are requested to file their respective written notes of arguments on March 11, 2025, when the matter shall be placed under the heading to be mentioned.
This is the declaration.
Just see that you can file joint written notes also. That will be easier because otherwise we'll have to go through both.
This is the declaration by the grandmother on behalf of the mother regarding the no objection. Because similar declaration is also given because the code below indicating no objections over the.
The note পরে করবেন. The learned counsel, the learned advocate for the respondent mother, comma, represented by her own mother, comma, files an affidavit of declaration giving consent for the minors to remain in the custody of the appellant, comma, expressing her full faith on the appellant that she will look after and will ensure that the minors will get all sort of facilities inclusive of health, hygiene, environment, moral upbringing, etc. Full stop. The said affidavit be treated to be a part of the record. আপনি juvenile justice
I'm praying for not this week.
No, when we sit after recess, then mention. When it is called, not like that.
the decree passed in our favor, and the appeal court, my lord,
What was the suit for? What is the decree?
suit for declaration and permanent injunctions.
Declaration of title?
Is not that.
All right.
My lord, the 34 of Specific Relief Act, my lord. My lord,
Yes.
the suit court, my lord, passed decree in our favor, my lord, where the appeal court passed the order, upset the order of the suit court, my lord, which has been passed in denying the prayer in the plaint, my lord. In the prayer in the plaint, there is no.
No, in the declaration, you also, not only title, you also sought for a decree regarding
I am the defendant, my lord. The plaintiff here, the plaintiff here in defendant, respondents.
Oh, it was decreed by the trial.
Yes.
No, plaintiff got a decree in the trial court. You
No,
say
we got the decree in the trial court. Their suit
how
was
could you
held.
be a defendant then? If you got a degree in the trial court, you could not be the defendant.
Their suit failed, my lord. I started.
Say there.
Yes, sir.
It will not close in your favor.
All kindly.
Suit was just simply a declaration of title.
Title and declaration of title and permanent injunction.
No decree, no deed was challenged.
No deed was challenged. Yes, sir.
As well. Then the appellate court reversed it on what ground?
The appellate court reversed that on the ground that the registration of the deed, what happened, my lord, the deed was executed, gift deed was executed in his second wife. The Ratan Mondal is the original owner. He purchased the land from Sukumar Sarkar and Sudhir Sarkar. Then my lord, Ratan Mondal, my lord, had two wives. First wife died and the second wife. During his lifetime, my lord, on 2nd February 2027, my lord, he executed a gift deed in favor of his second wife, Chadmani Mondal, he appellant hearing. And my lord, then on 16th February 2007, the Ratan Mondal died. It was registered on 2008, my lord. And during the registration, there is a averment of the register that he has satisfied. In presence of two witnesses, it was registered. Then, my lord, my lord, the son, the first wife son of the Ratan Mondal filed a suit for declaration with permanent injunction under section 34 of Specific Relief Act. Well, issue number 5 of the suit, my lord, it has been settled, my lord. Kindly see the issue number 5 of the decision in the suit court, my lord. Case 2.
Yes.
The plaintiff have filed the instant suit under section 34 of the Specific Relief Act. From the evidence of PW1 and PW3, it appears that the defendant number 1 is in possession over the whole suit property. In absence of possession, the suit for declaration of title under section 34 of Specific Relief Act is not maintainable. Hence, the issue is decided against the plaintiff. Then, my lord, it has been reason has been given in the next page.
Yes.
My lord, may I read it?
Yes.
These issue number 6, 7, 8. These issues being interconnected are taken up together for the sake of brevity and to avoid repetition. The plaintiffs have prayed for declaration of title on the basis of succession. PW1 has stated that Sudhir Kumar Sarkar and Sukumar Sarkar were the original owner of the suit scheduled property. This fact has been admitted by the defendant in their written statement, and hence no proof is required for establishment of this fact. PW1 has further stated that on 15th April 1995, original owner transferred the suit scheduled property in favor of Ratan Mondal, the father of the plaintiff. This fact has also been admitted by the defendant in their written statement and hence calls for no proof. The plaintiffs have further challenged a deed allegedly executed by Ratan Mondal in favor of the defendants. PW1 has stated in his cross-examination that she came to know after one and a half months from the date of making deed, the deed is not correct. PW2 came to prove the deed of purchase of Ratan Mondal being number such and such. This deed has not been challenged by the defendant and hence no proof is required. Thus, PW2 is not much help of the plaintiff. But this deed means 195, which is purchased from the Sudhir Sarkar and Sukumar Sarkar.
Everybody admits it.
PW3, in his cross-examination, admitted that whatever plaintiff told him about suit property is only known to him. The only fact that this witness stated is that he heard from Ratan that he did not execute any deed. This evidence of this witness is not reliable since no evidence that Ratan's LTI was forged has come before this court, and further that it is in contradiction to the evidence of PW1 that the C came to know of the incorrectness of deed about 1.5 months after making the deed. It appears from the Exhibit B that Ratan Mondal died on 16 February 2007, that is after 13 days of execution of the deed. One fact that cannot be ignored is that the suit property is admittedly the purchase property of the original owner, that is Ratan Mondal, thus making the chance of succession by the plaintiffs bleak, given the fact that it is not a family ancestral property. The plaintiff made no attempt to establish that the LTI of the deed was not of Ratan Mondal, though they expressly stated the deed was executed after the death of Ratan Mondal, thus bringing in the point of false personification. Another option open before the plaintiff was to establish by circumstantial evidence that there was some irregularity in the execution of deed. From the facts and circumstances as well as evidence on record, I find nothing to raise a question of doubt in my mind, in my judicial mind, regarding the execution of the deed. No evidence has come before the court to conclude that the challenged deed was never executed. Now, let me see what defendants have done to prove the deed. DW1 came to prove the execution of deed. The defendant also produced one of the attesting witness of the deed, who was examined as DW5. Hence, I can rely upon the execution of said deed. Thereafter,
Registration Act.
the owner shifts upon the plaintiff to prove that the said execution was not proper or was done by false personification. The defendant produced DW4 to prove registration of deed. However, the execution of deed is itself under challenge and not its registration. Now coming to point of possession, it appears from the cross-examination of PW1 and PW3 that defendant number 1 is in possession over scheduled property by ousting the plaintiffs. Learned advocate on behalf of the defendant argued that the plaintiff ought to pray for recovery of possession. I consider the same. I find that the plaintiff have filed the suit under section 34 of Specific Relief Act, so they must definitely prove their possession over the suit scheduled property on the direction and portion over which they pray for declaration in order to get a
Appellate court reversed. We have seen the appeal court. Appeal court has reversed on 2 grounds: that it was registered after the demise, although it was executed during his lifetime. Secondly, that common possession, joint possession of the parties, therefore no recovery possession was required. Was joint possession admitted, approved by at any point of time?
We have not.
They have not proved joint possession.
No, but they have said that
they are grounded. Retrospective effect of other. The present second appeal will be heard on the following 2 questions, substantial questions of law. Roman 1, whether the learned appellate judge, first appellate judge, substantially erred in law in holding that there was no valid gift deed by the admitted owner Ratan Mondal in favor of the appellant, merely because the registration of the document took place after the demise of the donor, by overlooking the effect of section 47 of the Registration Act, which provides that a registered document shall operate from the time which it would have commenced to operate if no registration thereof had been required or made, and not from the time of its registration. Roman 2, whether the learned first appellate judge substantially erred in law in reversing the finding of the learned trial judge that the suit was barred by the proviso to section 34 of the Specific Relief Act in view of the evidence unerringly indicating that the appellant is in exclusive possession of the property, which would debar the suit in view of not claiming the further relief of recovery of possession, by making out a third case of joint possession of the parties. Next paragraph. Any connected application?
No, I have to file that stay application.
What is CAN 1?
CAN 1 restoration. Yesterday it was restored.
Very good. This is all.
Grateful.
Thank you.
Deeply obliged.
Thank you.
This is generous and
Pardon?
This is generation, my lord, because your lordship is coming from this branch. That's why, my lord. Grateful.
Item number 30 to 31.
I am for the appellant, Lordship. I am praying for not this way.
Excuse, move the matter. What is the matter about?
I laid by Amitabh Mukherjee, sir.
What is the case about? You have to start the matter. Defective. You were absent on the last occasion also. Have you, you are appearing, Mr. Kormakar? Have you checked up the defect? What is the defect?
Lord, perhaps on the last occasion there was a direction not to clear the defects. There was a section 5 also, Lord, perhaps that was allowed. Section 5 was allowed.
Section 5 was allowed. Delay condoned. Defects have been removed. Yes. It's a judgment of affirmance. Why 2 appeals?
Lord, 2 appeals, Lord, 2 defendants have.
Have you got the papers before you?
No, Lordship.
Why is he not here?
Side is infected.
You'll come back. Come tomorrow.
No, because
When?
conjunctivitis.
When will he come?
Next week, next Monday.
On the prayer of the appellant, the matter is adjourned till March 11, 2025.
Much
Please give your name, ma'am.
State of 48.
Conjunctivitis very clear.
This is my application, my lord.
I have some humble submission.
You are?
But because I'm the respondent.
In this matter? In this matter?
Huh?
In this matter, 32?
No, sir. Actually, my problem is that my case, one ex parte stay order was issued on 16.
Come forward, come forward.
Ex parte.
Your matter has been heard today?
FMAT, no, sir. It is not coming up in the list.
Yes.
Although the time has already been over, actually. And our ex parte or stay order was imposed. FMAT 17.
Why are you mentioning the matter? For inclusion in the list?
For inclusion I have filed yesterday week, I have filed a CAN application.
Are you represented by any counsel?
No. I am a defendant pleading for myself.
You will be pleading for yourself. You have not filed it through some counsel.
No, sir.
So if you want to get the matter enlisted, you have to mention at the first sitting of the court, which is the mentioning hour.
Okay, sir.
So you cannot just
okay,
like this
sir,
come up.
what is the time?
Tomorrow we will be taking up appellate side matters from 2 p.m.
Okay, sir.
It will be better if you come back on Thursday when you take up appellate side matters from the morning. Thursday, 10:30 we sit. Come then and mention it for inclusion. We'll include the matter. It's an application.
It's an application, a simple application, just appeal
mention
for
it.
hearing.
Come back on Thursday at the mentioning hour, which is 10:30 when we sit at first.
Okay.
Mention the matter, bring a slip, writing application at the top and giving the number.
Okay.
We'll include it and it will be appealed.
Okay, sir. Okay, sir.
Thank you. Yes, who is appealing 32? You.
This is my application.
Yes. No caveat.
No caveat, my lord.
Right.
We have served. Section 5 has been allowed.
Now it is appealing for admission here.
Yes, my lord. This is an application for injunction and perpetual injunction.
One second.
Declaration.
At the section 5 point of time also they did not.
They did not appear.
Yes. It is against injunction, refusal or?
Refusal. Ad interim refuse on the ground of misjoinder of parties. And what happens? My mother gives a property.
Misjoinder or non-joinder?
Misjoinder.
Achha, yes.
Misjoinder. My mother gives a property to 3 brothers, 3 sons. I am appearing for the 2 sons with the plaintiffs and the other defendant. 3 sons in year 2015 from Mr. X. My mother purchases from Mr. X. My mother gives by a gift deed. Defendant is a present there. 3 sons.
Your mother gives to all the 3 sons?
All the 3 sons.
Joint.
Joint share. In the year 2013. Now, in the year 2015, we found that the defendant, the younger son, has purchased from the erstwhile developer.
Purchase after the gift deed?
After the gift deed. We challenged that. The lower court below has refused on
He
the ground-
purchased from the same person,
Same
X,
person.
X.
X, same person.
But after X transferred the property.
Yes, my lord.
So why has it been refused?
Refused, stating that misjoinder of party, Mr. X has to be a party.
Non-joinder, not
No,
misjoinder.
no, my lord. Kindly see the order.
Misjoinder is a misnomer.
Yes, my lord. It has categorically
Meant
mentioned-
non-joinder, obviously.
Yes, my lord. But I say, my lord, he is not a necessary party because he
You are challenging a sale deed in which he was one of the parties. Why is it not a necessary party?
because my lord, neither
If the sale
rights
deed
will
is
be affected.
no, if the sale deed is cancelled, if the sale deed is cancelled,
It will affect my brother, the defendant. It anyway does not goes back to that Mr. X.
let us see the impugned order.
Yes. It's in the memo, Lordship. The record is put up today and taken up for hearing on application preferred in terms of Order 13, Rule 1 and 2. Issue notice calling upon the defendant show cause within 20 days from the receipt of thereof as to why order of temporary injunction shall not be granted. As per the office report, caveat has not been filed with respect of the claim. The crux of the plaintiff's case is that plaintiffs as well as defendants are joint owners of the property mentioned in Schedule A of the plaint. The said property was conveyed by them, registered gift deed on 15th March 2013 by their mother, Srimati Jyotsna Pal. Subsequently, on 20th September 2023, plaintiff discovered that defendant has purchased the entire property mentioned in the Schedule A of the plaint by a registered deed of sale in 14th August 2015. So, the first
Why have you asked for a stay of operation?
that is, my lord,
That is there. Injunction you should have asked.
I should have asked for the.
How can you grant injunction on this application even if you admit? Tell us.
If Lordship may set aside the order and remand back.
Expertise.
No.
Splendid. What else? Decide the suit in your favor. There is not a single abatement in your application also.
Yes, my lord. In the stay application there is.
Where is the that they are disturbing your person? What injunction you sought?
I sought for, my lord, not to transfer the property.
Where is the abatement in the stay application? Show us. That they're trying to
Para
transfer.
16, 17 and 19 of the stay application. Now, why the learned court below has failed to.
That is the ground of the appeal.
Para 19, my lord.
17 something is there. This is the court has failed to appreciate. Where is this abatement?
The 19, my lord, the appellate who shall be denied of exercise of their due ownership of rights.
That is
Para
nothing.
19.
That is not cause of action for injunction. Para 22 maybe.
Yes, my lord. Para 22. It's a general prayer.
The appellants in a suit, the appellants are the plaintiffs in a suit for declaration and cancellation of a purported deed of sale effected in favor of the defendant by the vendor of the mother of the parties. It is alleged by the appellant that the said vendor sold the suit property by virtue of a registered deed of conveyance, and thereafter a deed of gift was executed by the mother of the parties on the strength of such purchase, on March 15, 2023, jointly donating the property to all the parties. Despite the defendant being a signatory to the gift deed in the capacity of a donee, it is alleged that the defendant is now seeking to rely on a sale deed, which was allegedly executed by the vendor of the party's mother, subsequent to the sale deed executed by the self-same vendor in respect of the same property to the mother. Pushed up next para. The learned trial judge refused ad interim injunction apparently on the ground of misjoinder of necessary parties, comma, which is obviously a misnomer, since the trial court was of the opinion that the vendor in the sale deed, impugned sale deed, ought to have been imputed as a party. Pushed up, even construing the order to mean that the relief of ad interim injunction was refused on the ground of non-joinder, comma, an arguable tribal issue has been made out by the plaintiffs inasmuch as whether the vendors would be affected in any manner by the reliefs claimed in the suit, and since the plaintiffs are otherwise entitled to injunction on the face of the allegations made in the plaint and the injunction application, comma, whether the learned trial judge acted without jurisdiction and erred in law in refusing ad interim injunction. Pushed up. Accordingly, the appeal is admitted and will be heard on the above questions as well as the other grounds taken in the memorandum of appeal. Pushed up. Since we find that a prima facie case for grant of injunction has been made out, comma, although Can 2 of 2024 has been couched as a stay application, comma, and we find that sufficient averments to constitute the basis of a prayer for injunction are existent in the application, comma, we mold the relief and direct the appellants through their learned advocate and record to correct the prayer portion and the cause title of the application by incorporating a prayer for injunction. Push up next para. The respondent and his men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, or encumbering the suit property in favor of third parties during the pendency of the present application. Regarding possession, you have not made any prayer. Full stop. Next para. The necessary correction, amendment to the cause title and the prayer portion shall be carried out by the learned advocate on record for the appellant during the course of the day. Full stop. Next para. The appellants shall serve copies of Can 2 of 2024 shall serve amended copies of Can 2 of 2024 on the respondent, indicating that the application shall be listed in the monthly list of April 2025 under the same heading, when an affidavit of service to that effect shall be filed by the appellants. Carry out the correction, application for injunction,
Yes, my lord.
and injunction, whatever injunction we have granted, put that in.
Grateful, my lord.
From selling, transferring, alienating, encumbering in favor of third party. Do it in both the judges' copies. And serve amended copy. You take down in your own copy. Don't forget to do that. You copy that in your own copy and serve that copy. Yes,
my application, is it?
Yes,
on
please.
the last occasion, an application for adjournment was handed up before your lordship by my learned friend that I had acquiesced in the preliminary decree. And that is not the case. The application.
Can you please give us half a minute? Just we'll go through our previous order and immediately thereafter. No, the challenge is against an affirmance against a preliminary degree of partition.
Yes, yes.
And they have said that you will cooperate.
Yes, I have just said that I'll cooperate with the
and abide by the preliminary degree.
No, that is not the amendment. I've just said that there is no necessity of a police assistance because we are old people. We can't resist. We've just said that. And that is what the learned judge is also, he's also passed the order that way. We've said that we are senior citizens and we don't want any police here. So we
this was an objection against police help.
Yes, yes.
You resisted the police help by saying that
we
we'll cooperate.
We said we'll cooperate, that's all. If there is a final decree, we'll We've not even said that. We in fact said that we're not
ready and willing to assist the learned commissioner for holding.
That's all. And we said that there's no need of a police assistance because we don't want the police here.
Yes, Mr. Mahato, it's that.
What I am submitting, my lord.
They
These
have not-
statements amounts to, my lord, acceptance of preliminary degree.
No, we'll disbelieve that and hear the appeal under order 41.
No, my lord, this cannot be disbelieved. It is their statement.
Yes, we
on
will give
affidavit.
our reasons. Learned counsel for the respondent,
occasion,
comma, as
my lord,
recorded.
last occasion I produced this before your lordship. This objection. And my
Learned
confidence was-
counsel for the respondents by placing reliance on a written objection filed by the appellants in the trial court, comma, as referred to in our order dated February 26, 2025, comma, submits and reiterates that in view of the admission of the defendant appellants in such objection, that they would assist the learned commissioner for holding the commission work and abide by the preliminary decree, comma, which is the subject matter of challenge before this court, comma, the present appeal is not maintainable, full stop. Next para. A copy of the said written objection was handed over to us on the last occasion, which of learned counsel for the appellant rightly contends that the appellants, comma, in the said objection, comma, merely stated that they were always ready and willing to assist the learned commissioner for holding the commission work, though they have never disturbed and or put up resistance to the commission work on earlier occasions. Full stop. As also rightly contended by learned counsel for the appellants, comma, we find that the said within double inverted admission was made in the context of a police self application, whose of learned counsel for the appellant submits that the appellants, being aged persons, comma, wanted to avoid the ignominy of police at the premises, and as such merely stated that they would assist the commission work and no police was required to be deployed. Full stop. Next para. We do not find within the four corners of the said written objection, comma, which is a part of which is kept on record, comma, that at any point of time the appellants conceded to the preliminary decree which is in challenge before this court. Full stop. Rather, comma, the statements made in the objection was only to the effect that no resistance to the commission work would be offered by the appellants, on which ground they sought to avoid police being deployed at the premises. So thus, comma, the said written objection per se does not tantamount to an admission of the correctness of the impugned judgment and decree, and as such cannot be a bar to the present appeal. Full stop. Next para. Hence, comma, the second appeal is taken up for hearing under order 41 rule 11 of the Code of Civil Procedure. Yes.
The only point
Judgment of affirmance or reversal?
Affirmance.
Affirmance, yes.
Now, the only point here is that this is a Tika tenanted property. Now, there is a suit for partition. Now, what happens here is that there is a discrepancy in the measurement of the land. Now, Your Lordship, we are looking at a vested property. The controller has the power to determine how much, what is the vested, the quantum of vested land. That the civil court does not have. Because Your Lordship sees, they ask for a partition of 5.15
They sought for declaration of their shares.
Yes, shares.
So can the controller, Tika controller, grant that relief?
No, but the controller has to determine preliminary as to how much of land is. How much of land. That is only with the Tika controller and nobody else. Because under the Your Lordship will kindly see, and he concurs, he says that the measurement of land is in dispute. While passing the order, if Your Lordship kindly comes to page 100. Now, if after this, I'll be showing Your Lordship 5.3.
Page 100?
Page 100 would be internal page 29 of the appeal court.
This is the appeal court or the trial court?
This is the appeal court.
Right.
The trial court has said nothing. Now, towards the end, about 6 lines from the bottom. Except the measurement of suit land, the other description of suit premises has not been challenged, so there is no identification problem in the suit premises view of this discussion. Now, before that, what he says is, if your lordship kindly turns over to page 25, internal, page 96. Now, towards the bottom, towards the bottom. But this is a suit for partition, accounts and permanent injunction. This is not a suit for declaration of Tika tenancy. Section 5(3) of the West Bengal Tika Acquisition and Regulation Act 2011 provides that if any question arises as to whether a person is a Tika tenant or not, or whether the land in question is Tika land or not, the controller, either on his own motion or upon receiving information. Now, if the quantum of land is not determined,
here both parties agree that it's a Tika property.
They are agreeing. No, we have not agreed. We have said that there is no such. In fact, there was no such thing also produced. There was no such receipt produced.
You have raised the objection that this is a Tika property.
We have said that. We have said in our.
So both parties say that it's a Tika property.
We have not said that. We are the defendants. We have not said.
What have you said? It's not a Tika property.
We have not said that also, because they could not produce the receipts.
Have you disputed that it's a Tika property?
Yes, actually,
in statement.
We've done that.
But how is it relevant? Even if it's a Tika property or not a Tika property, if you have not disputed, the question is not whether it's a Tika property or not. If that dispute arises, then the Tika controller would have the power.
Quantum of land also has to be determined by the Tika controller, because this is vested land. This is not private land. It goes into his records.
Quantum of land here, it's
4.10 or 5.215.
Quantum, the declared
what evidence they have produced is 4.10, and what they are claiming is 5.25. Now, if this is what is to be, therefore the ratio of the division itself will be
it will go
problematic.
To the Tika controller only if there is a dispute regarding ascertainment.
Because he has to ascertain. The Tika controller has to ascertain in his records.
If there's a dispute as to the identity of the property as a Tika property, only then.
And also the quantity of the land.
So as the
quantum of land.
So as the provision where if there's a standalone issue on measurement also, then also he'll have duty.
Yes, because he has to determine, whether it's 5.25 or whether it's 4.10. Because this is vested land. One kata or even a half a kata can't just go away.
How does the court deal with that?
The court has said that there is a, and your lordship will then after that, before that also, he has also dealt with 3H. If your lordship kindly comes to page 26.
Yes,
internal.
End of that.
Yes. Rule 3H states that the land boundaries shall be kept intact and well defined. So this is absolutely in the province of the Tika controller.
The boundaries will be kept intact.
Yes, boundaries, but then there is a dispute about the boundary.
Boundary
would be either is 4.10 or 5.15. That the Tika controller has to decide. Which is the boundary? How does anybody keep that intact? Because this is vested land.
Here, boundary has already been given in the suit property.
Boundary has been given in the suit property, but they have also produced a document saying that is 4.10.
Whatever it will be.
That is why the court comes
in aid of the preliminary degree. You have challenged the preliminary degree. Preliminary degree only declares the shares of the party.
Shares of the half-half.
Whatever.
50-50.
Yes.
Yes.
So that has been done. What is the wrong in the preliminary degree?
Because of the fact.
The Tika controller could not grant a preliminary degree regarding shares.
No, he could not, but he could have also been made a party. He is not a party house.
Need not be.
Otherwise, if your lordship sees, suppose if it's 5 katas of land, it's 2.5.
But can you please produce a provision which says
because
that it's a Tika controller who can only measure the property?
He has to.
Show us that.
Because he has to have his own measurement. He has to also, this 5.3. 5.3.
Show us that please from the provision.
5.3. 5.3.
5.3 says if there is a question whether a person is a Tika tenant or whether the land in question is
Land in question is a Tika tenant or not.
There is no such question in the suit.
And then after that, if your lordship reads the boundaries, when it comes to the boundaries, read with that, the rule that the boundary has to be kept intact, then it is in the province of the Tika controller. It goes to the root of the question. And under 21, the civil courts.
The rule comes in only if section
somebody
5
has to determine.
Rule comes in only if section 5.3 is invoked.
Yes.
Here 5.3 is not applicable at all because there is no dispute as to whether it's a Tika property or not.
But we have disputed about the quantum of land.
No. Only quantum dispute doesn't.
No, that has to be, your lordship will see, the records have to be kept intact. He has to determine. The Tika controller has to determine as to the quantum of land as well.
If there is a dispute under 5.3.
That there is a dispute. We are disputing that.
No dispute
Because
regarding whether
he
it's
said that there is the measurement of land at page 100. He says that the measurement is not proper.
Sorry.
But that is the question.
Learned counsel for the appellant in the present second appeal has been preferred against a judgment of affirmance whereby both the trial court and the first appellate court passed a preliminary decree of partition declaring the shares of the parties. Full stop, next para. Learned counsel for the appellant submits that according to the plaintiff case, the property is a Tika tenancy. Full stop, next para. It is contended that in terms of section 5 within bracket 3 of the West Bengal Tika tenancy within bracket acquisition and regulation bracket close act, 2001, read with rule 3 capital H within bracket of the corresponding rules, it is for the Tika controller to measure the properties, Tika property, as well as to ensure that the land boundaries are kept intact. Full stop. Hence, it is contended that the suit was barred by the provisions of the 2001 Act and the corresponding rules. Full stop. Next para. We find from the judgments of both the courts below, particularly the first appellate court, that the said contentions have been dealt with by the court. Full stop. The learned appellate judge as well as the trial court proceeded on the premise that the suit is not barred under the provisions of the 2001 Act. Full stop. We agree with such concurrent findings, since the corresponding rules under the framed under the 2001 Act come into play only if the jurisdiction of the Tika controller is invoked, which can only happen if there is a dispute as to whether a person is a Tika tenant or whether the land in question is a Tika land or not within the contemplation of section 5 within bracket 3 of the 2001 Act. Full stop. In the present case, the scope of adjudication in the partition suit is merely to declare the respective title and shares of the parties and to ensure partition within the periphery of the boundaries of the suit property. Full stop. Thus, in the first place, the jurisdiction of the Tika controller is not invoked, since the dispute does not pertain to a question as to whether the suit property is a Tika land or not. Full stop. The plaintiff has claimed the suit property to be a Tika land, regarding which there is no specific dispute which is required to be adjudicated. Full stop. As such, the suit cannot be said to be barred by any of the provisions of the West Bengal Tika tenancy within bracket acquisition and regulation bracket closed act, 2001 and or the rules framed thereunder. Full stop. Accordingly, we find that no substantial question of law is involved. Full stop. Hence, SAT 245 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, IA number CAN 1 of 2024 also stands dismissed. Short. Next.
Formula term for the defendant respondent's caveator.
Respondent.
Yes, my lord. Defendant respondent.
Last chance was given. In our order dated March, in our order dated March 3, 2025, we had recorded that none appeared for the appellant, although the respondent number 2 was represented before us. No, we recorded 2, so we are repeating that. Respondent number 2 was represented before us. Full stop. Learned counsel for the respondent number 2 submits today that she is representing the respondent number 1 as well. So be that as it may, comma, we recorded in the order dated March 3, 2025 that on a previous occasion on January 30, 2025 as well, comma, an adjournment was sought on behalf of the appellant, whereas the appellant remained unrepresented on March 3, 2025 also. Full stop. Accordingly, a last chance was given to the appellant to argue the matter, and the matter was adjourned for such purpose for the day till today. Full stop. Next para. Even today, since none appears for the appellant to move the matter, comma, FMA to 84 of 2024 along with Can 1 of 2023 are dismissed for default without, however, any orders to cost. Appeal was not admitted, so there is no scope of an interim order being done.
Not I am for the appellant.
Deficit court fee has been paid. That is the defect pointed out. Let us see.
In course of today, I paid.
But unless you do that, we cannot take up.
Very well.
Do it, we will keep it tomorrow. Learned counsel for the appellant submits that the deficit court fees shall be deposited during the course of the day. Full stop. Accordingly, we adjourn the matter for the day. Come back tomorrow, we'll take it.
They cannot record.
But please bring some document to show that you have put in the deficit code.
Yes,
tomorrow, when you did
yes,
the receipt or something.
এটুকু রেকর্ডটা দিন না কত টাকা বাকি আছে দেখেন
কত deficit code fee আছে দেখেন
appearance could be
yes, Mr. Jain.
Mr. Respondent number 5.
You have finished. Yes.
I am appearing on behalf of restaurant for I am being led by Mr. Rohitnath Mitra. He's on his leg before court room number 2.
Yes, what do you say?
I'm
What
seeking
do
for
you say?
not today.
Very well.
My lord, may I?
May you what? May you do nothing? An adjournment is sought on the ground of absence of learned senior counsel appearing for the respondent 1. Full stop. Accordingly, let the matter stand adjourned for the day.
My lord, may I just make one submission?
No submission.
One
You have made enough submission. Come back tomorrow. You have any difficulty tomorrow?
No, it's not about it tomorrow.
Then no submission. And we will give you 5 minutes to reply.
No, my lord, I'll take 10 minutes.
No, achha, 10.
10 minutes.
Let us bargain on that.
My lord, I am in no position to bargain with the lord.
And I am a very bad bargainer. So,
my lord, I am the worst, my lord, in my life. In fact, I have in
no,
my
I
life,
have an
I've
instance where I went to bargain on a product and I increased the price in the process. I heard wrong. Suppose 10 rupee was the price was offered. I said I won't give a penny more than 15 rupees.
And my lord, in fact, I was just telling my learned juniors, my lord, that ever means in my life, I have only bargained once, my lord. That was in Egypt when I had been to Egypt.
That was in
Egypt. I had gone to Egypt. That's the only time when I had ever bargained. Otherwise, my
Succeeded,
lord,
no?
I succeeded big time, my lord. A thing which was being
Good
sold
to know that there are people worse than me.
25,000. I bought it 1,000.
Oh,
that kind of bargaining, my lord.
but don't do that in court.
Never.
For the respondent.
Yes.
Should I appear on behalf of
Yes,
the
yes.
appellant?
You
Look,
have
Mr.
finished.
Mitra will be joining very soon. He's in
Mr.
a Mr. Anindu Mitra was making
Yes, yes, he was
submissions
there, yes.
yesterday, my lord, at part heard matter.
So how soon will he join? If he joins very soon, then we'll let you start. Otherwise, we won't hold us.
Yes,
I mean,
Lord,
we'll,
I understand.
we'll then take up the next matter.
No, Mr. Huck is more than he
No,
conducted arbitration.
He is very competent,
Yes.
but he'll be in an
Yes, we all
utterly
don't know
embarrassed
what he's
position if he finishes before Mr. Mitra.
Yes, my lord.
Of which there is every opportunity.
We never know what Mr. Mitra will argue.
No. And if Mr. Huck starts, we are assured that he will finish within 10 minutes. So that is a risk he will be
I will
running.
insist he will start. He should start.
He cannot continue. He has my problem. When I was at the bar, I assured people that I would be continuing, but I could not. I finished within a. He'll be coming. Time.
Lord, Mr. Mitra is praying for a not today. Lord, he's just.
You're granted.
Day after tomorrow, my lord.
Yes.
I have some difficulty tomorrow.
An adjournment is sought on behalf of the appellant. Let the matter stand over till March 6, 2025, which is in any event the hearing day.
Lord, it's a hearing day, part of matters.
Grateful. Thank you.
In 38 whereas.
Yes, Mr. Pal, you were there. Sorry.
Whereas my learned friend has not completed.
38, Your Lordship, on the last occasion, Mr. Chaudhary had completed his argument. The only thing remaining was we cited few judgments. The physical copies were not present on the last occasion.
Yes, yes.
Yes. I'm carrying the physical copies.
You can hand over the judgments. We can conclude.
Should copy them. Similarly, we are also supposed to give the copies of the judgment.
Yes, yes.
We are not.
Yes, yes. The books you.
Chucked it.
তোমার কপি আছে?
Oh, that male air conundrum.
Yes.
Oh, yes.
Only difficulty is that Mr. Moitra is appearing, leading me. I cannot assist your lordship regarding the paragraph of the judgment because he has given this. Earlier occasion, last day.
We will then conclude arguments and permit you to put in the
written notes.
Written notes also you can file very brief written notes. We have our own notes, but just brief written notes and your judgments. You are ready with all the judgments.
Yes, I've handed over.
We are taking up your judgments and refer to these in your written or keep the judgment. Annex to the written notes. That will be easier for us. One judgment was handed over by the appellant, that is Ram Gopal's case. Ram Gopal, you need not annex. The other judgments, please annex to your written notes.
I'm not giving it now. I will give it now.
You have the copy?
I have the copy.
Then you can take over. You cannot assist us on the paragraphs only.
Paragraph only. Because Mr. Moitra has thought about the matter. I am not. He is engaged in court number 28. That is the difficult.
আপনাদের সাইটেশন গুলো বলুন না
আমি দিয়ে দিচ্ছি আপনাকে কপি
No, then we'll adjourn it till tomorrow. We have to conclude it in a proper fashion. You have concluded.
Yeah,
the scope is very limited. The interpretation of that.
Mr. Chaudhary had already completed. If it was the understanding on the last day, if some clarifications are required by your lordship, he will come.
So then we can conclude arguments. So you can hand over your judgment. And hand over your judgment.
I've already given.
But the citations you had already referred to these. Hand over the copies, yes. So you have handed over Mr. and all of you. You are also Mr. Bhattacharya. You are also Bhattacharya. Three Bamuns will be very difficult. Then it would be three. Yes.
I have relied upon AIR 64 Supreme Court 1323.
Wait.
First title is Ramchandra Shenoy.
In that order, we'll keep it in that order, whatever. So 64 Supreme Court, yes.
Then Milord, 1995 Volume 5 SCC 444.
Yes.
Kaivalikal Amhoni.
Any particular paragraph you want to?
Milord, this is paragraph 3 and 4.
64.
64. Paragraph.
If you have the paragraphs, give me the paragraph.
11.
64 para 11.
Para 11, Milord, because the clause was to enjoy. Lordship would kindly recollect the clause of that deed. It's a enjoy, beneficial enjoyment. Paragraph 11 is what does to enjoy mean?
Very difficult to define.
Very difficult to define. Depends on
in respect of property, maybe yes. 1995 5 SCC. What is the paragraph?
444. That is paragraph 3 and 4.
3 and 4.
Yes.
Now, Mr. Pal, you get your paragraphs.
Then next, my lord, is 1997.
Yes. 7 to
SCC 255.
Paragraphs.
Paragraph 3, my lord. Prominent intention of the statute has to be given effect. Of the deed has to be paragraph 3. And the last one is, my lord, 24 SCC online 3379. এটা হচ্ছে বলো প্যারাগ্রাফ I'm giving a lot to that.
Yes, yes.
ওদের বলা হয়ে গেছে
14.1.
14.1.
They won't add anything. They won't add anything. They're just handing over the.
It is, my lord, paragraph 12 onwards, my lord, interpretation of section 14(1) of the Hindu Succession Act. 14(2), 14(1) and 14(2).
42, obviously. Go hand in. And Mr. Chaudhary is also there.
এগুলো reliable paragraph গুলো বলে দিন।
We took the paragraphs, Mr. Chaudhary, and the judgment. So fair of you that won't continue further.
Yes.
Thank you. So, Mr. Mitra, he has made his stand clear on the last occasion. If you want to add anything in reply, you can.
My lord.
Please take your seat, Mr. Chaudhary and company.
First thing I will submit, my lord.
Yes.
Your lordship has gone through particularly instrument. Now, my learned friend said, my lord, this is a deed of trust. Let us assume to be so. My lord, this instrument was created.
Yes.
In respect to a dwelling. Not the other properties of the settler, but only in respect of the dwelling house. We do not know whether he had any other properties or not. We are not going to that. Now, but this instrument further was created after the dwelling house being partitioned in 2 equal shares. That your lordship will find from the schedule annexed to this deed of my lord instrument.
So you say the male heirs have to go to the respective.
My lord has got my. So, my lord,
Yes.
there is no oneness of the property.
It's not interchangeable. If they don't have an heir, it goes to you, or vice versa.
Yeah.
That is your point.
But first thing your lordship sees, first part of the deed.
Because that was one of the questions we also put to Mr. Chaudhary. He answered that also. Yes.
But first part of this deed, my lord, refers the daughters of the settler. Well,
daughters have been excluded.
Excluded.
Yes.
Daughters of the settler were excluded.
Yes, yes.
And why daughters were excluded, that was also, my lord, very much recited in the deed itself.
Yes.
And thereafter, my lord, the recital is that property was given to 2 sons. So, my lord, whole purpose or object of this deed, my lord, not to have any disturbance in respect to the property which was given to 2 sons by the heirs of the daughters of the settler.
So the pivot was not so-called male chauvinistic approach, that the daughters would be excluded and males would come in.
Yes.
But daughters were deprived for valid reasons. They are married and they are happy with their husbands and whatever.
Happy with their husband and
they are provided for.
My lord.
So therefore they were excluded, not to give.
Yes.
Primacy.
Precisely, my lord, my submission is that when my lord settler has given definite explanation why the daughters were excluded for interference with the homestead property.
But at the same time, Mr. Muthu, it's specifically stated, whereas the settler is desirous of the said premises being enjoyed by the male heirs of the respective.
My lord, it should be read in my humble submission, subject to what your lordship hold,
yes,
in the context of the previous recital.
We'll take brief written notes on this, Mr. Chaudhary. We'll take brief written notes on this, because we may miss out certain points. We have taken our notes, but very brief.
Well, had it been so, the daughters, lock, stock, barrel, or in general way excluded.
I don't like daughters. Not that.
Then why, my lord, daughters-in-law were chosen?
Because they had law in their favor.
Yes. So not, my lord, it is, what should I say, my lord, the discrimination with the gender discrimination.
Very good.
So it's not the gender discrimination.
Very.
And further, your lordship sees
the object or the purpose of this deed ends, it was stated in the deed itself, by making over the possession of this property to the daughters-in-law. If you also kindly take trouble to look at my lord.
But it does not end there at page 53, Mr. Moitra. It carries further. I mean, it says that and their respective male heirs.
So respective is, my lord, that's why I'm going to submit, my lord. Why the word respective was used? When property was divided in equal portion, two equal portion, and each son or each daughter-in-law given an independent possession, or, my lord, to hold the property. Had it been the intention of the settler that no excepting male member, it will not be enjoyed or it will not devolve upon the other heirs, there must be recital that in the absence of any male member of either of the daughters-in-law, property will devolve upon the surviving male member.
So do you...
Very conscious omission, my lord, that and the respective male members.
Do you mean to say that if one of them did not have any male member, as in
Yes.
this case, so then according to you, what would happen? The other heirs of that lady.
But when property was divided by midst and bound, so to say, or absolutely
suppose it was not midst and bounds, but suppose two demarcated portions were given. Let us proceed on that premise.
Right.
Now, what will happen? Mr. Chaudhary hinted at a point that
my lord,
there cannot be a half extinction of the trust, that the trust has been fulfilled in half and the rest half remains alive. Either it comes to an end with all going to one male heir.
Yes. Comes to an end with the recital.
But regarding your portion, what happens?
My submission is this, my lord. When oneness of the property has been extinguished.
No, we proceed on that premise. So the other lady has a male heir, he gets her share.
Yes.
And regarding your share, according to you, what will happen? Whether it reverts back to the estate
cannot be, my lord. Cannot be, my lord.
Let us put our question. Whether it reverts back to the estate of the settler because there is no male heir, or the female heirs will get it now.
Female heirs will get it, my lord. That is the absolute right conferred upon the two daughters-in-law with the right of alienation.
So you try to define this, to try to explain this, construe this expression that Nilmoni of respectively and their male heirs, to mean that if there is a male heir, the male heir will get it.
My lord.
If there was a male heir, he will get it exclusively.
My lord.
But if there is no male heir, then all will
other heirs.
Other heirs. All right.
That's why, my lord, the word respective was used. It cannot be, my lord, if other daughters-in-law doesn't have any, my lord, the male heir of the other daughter-in-law will encroach upon her property. What property will devolve upon her, upon the surviving male member?
So regarding your share, your portion, regarding the other portion, male heir has got it, the trust has spent its purpose. But then half of it will be spent and the half of it will remain alive. Regarding your portion, what happens then? The trust does not reach its logical conclusion.
My lord, that's my lord.
It reaches its logical conclusion by Rekha getting the property.
My lord, purpose of the trust, my lord, it itself provides, my lord, that when it ends,
then it will remain an open-ended trust insofar as Rekha's share is concerned.
So far Rekha's share is concerned, my lord, the absolute share of the Rekha.
And her male heir, if she had a male heir, it would go to the male heir and it would end there.
And if not, my lord, the other heir? But it is not recital that if there is no male heir of either of the daughter-in-law, the surviving male member will inherit the property, or property will devolve upon the surviving male member.
Rekha died.
Both Sarjivarao died.
When Rekha died, did she have any other male heir? No, begotten by husband.
Yes.
Male heir means son.
My lord.
All right.
My lord, I shall show to your lordship, my lord.
Where is the end of the trust contemplated according to you?
Position দিয়ে দেবে।
Page 54. Page 54, about the middle of that page, Mr. Moitra.
Right.
Further, it is provided you can start from the third line of page 54. It will culminate in what you are saying.
My lord.
And the said trustees shall make over possession.
My lord. So there ends the purpose of the object of the trust.
All right. But it does not end because if there is a male heir, he then gets.
Well, I am submitting, my lord, when the purpose of the trust is culminates by making over the possession to the daughters-in-law, then, my lord, whoever inherits the property of the daughters, that is not prescribed in the my lord, instrument. But had it been the intention or purpose of this instrument that only male member will get hold of the property, then question of using the word respective doesn't arise. My lord, in my humble submission, my lord, if either of these spouse had, my lord, both male member and female member, male and female heir,
then only males would get.
Yes. Had there been any recital that in the absence of any male member of either of the daughters-in-law, property will devolve upon the surviving male member, then there ends the matter.
All right. Good.
That is not there. So this is not the intention of the, my lord, the settler to oust the other male heirs from the property which was given to my lord by this instrument, the daughters-in-law. But kindly see the schedule. It was specifically mentioned. It was also demarcated. Page 54, my lord, scheduled to this.
Yes, yes, clearly do.
Specifically written, my lord, portion A to be enjoyed by Rekha Sarkar. And my lord, schedule C enjoyed by the Sandhya Sarkar. And the map was also given.
Map is there.
Map was also given.
Page 56.
So, my lord, specifically property was demarcated.
Yes.
And each separate portion was given to, my lord, the two sons. Rather, my lord, two daughters-in-law.
Schedule A is common.
Common.
Or the total.
No, schedule A, my lord, total building.
A is total. B.
That is the demarcated portion.
B is portion A in the map, which goes to Rekha, and C is portion B in the map, goes to Sandhya.
Yes.
Right. Very good.
Now, my lord, my learned friend, argued section 25 of the transfer of property.
Yes, that is a very important argument.
My lord, my first submission would be, my lord, when settlement was made by an instrument. A settlement was made by an instrument.
Yes.
So, my lord, the construction or interpretation of that, my lord, instrument is the vital thing. And if there is no ambiguity, my lord,
transfer property একটু দিন না
but kindly, only to refresh your lordship, my lord, an interest created on a transfer of property and dependent upon a condition fails if the fulfillment of this condition is impossible or is forbidden by law or is of such a nature that if permitted it would defeat the provision of any law, is fraudulent or involves or implies injury to person or property of another, or the court regards it as immoral or opposed to the public policy. But two things is very important: opposed to the public policy and, my lord, forbidden by law. My lord knows best, my lord, Hindu Succession Act, Section 4. It
4
is
or 14?
of the Hindu Succession Act.
14. 14.
Section 4, my lord, the overriding effect.
Oh, yes. Yes.
Section 14, my lord. I learned, friend, my lord, will rely upon the subsection 2 of section 14. But my humble submission is the first submission, my lord, when this settlement was made by an instrument, then that instrument is the vital thing and their construction interpretation will prevail over anything, my lord.
Yes.
Secondly, my lord, section 25, there is an embargo that if it is opposed to the public policy,
can we import public policy in the devolution of a particular?
But public policy in that sense, my lord, when Constitution, my lord, contemplates equal treatment of equal protection of law. But there is one judgment I have not brought, my lord. Article 14 is very much there. And not only that, my lord, section...
The Sabarimala judgment.
My lord.
The majority view went on a rather, I would say, a rather, at the risk of, I mean, westernized view. Now, Justice Indu Malhotra was the only dissenting person. The interesting thing is that she is the only lady in that bench, and she held against the ladies being. Now, I had the occasion, the good fortune of meeting her in a law school. She had come to deliver a lecture. I had gone there for some other thing. Now, I had the occasion to meet her, so I was very interested in her view of the that judgment. So she said that first of all, none of the petitioners ever went to that temple to give their offerings, and secondly, that if it's a particular temple, I mean, nobody compels you to go to a temple. It's a particular temple meant for a particular community or whatever. I mean, it's not a public place in that sense. I mean, but if that is governed by some religion and established for the purpose of pursuing such the religious modes of that community, I mean, why should we import our notions of equality or egalitarianism on that.
Yes.
Because it's a particular community, they are maintaining that. Now, this is the particular person, his property, he could have done it, he could have transferred it only to the male persons if he wanted. There is no bar.
But had it been by law.
Can we import public policy on the basis
But
of
I'm
Article
submitting-
14 there?
But I'm submitting in this way. If that was the intention of the settler, he could have executed a will, my lord. He could have executed a will.
Yes.
Nobody could say anything because will is governed under the Indian Succession Act.
Or he could have clearly said that I maintain
Yes.
only life interest to the
Yes.
citizen.
Then why settler has given, my lord, the right of alienation not to the son but to the daughter-in-law?
All right.
Instead of, my lord, creating this deed of settlement, he could have straightway, my lord, bequeathed his property by executing a will.
All right. If we have to construct a document, private or public, you say that we have to then take into account public policy also.
My lord.
While construing it.
My lord.
There is a scope of construction.
My lord.
If it's clear, then we don't have any
yes
loophole, don't have any entry into that.
My lord.
But if there is a scope of construction, it should be in favor of public policy.
My lord. I bow down to lord.
Read in the light of section 25.
Yes. And section 25 further, my lord, if it is forbidden by law.
Not forbidden by law.
My lord,
you can give whatever you have to your son. Only.
Had it been a will, it was not forbidden by law.
Or
because
for that
it is
matter, to
allowed.
your daughter only also.
It is allowed by law. If it is a will, then, my lord, he is covered under the Indian Succession Act. And that law, my lord, provides to execute a will in whatever way you like.
We have to give, we have to honor the intention of the settler.
My lord.
There is no doubt, either in a trust or in a will. So we have
My
to
lord,
interpret his
taking
intention.
Taking into consideration, my lord, the whole of it, and the law.
If the settler was a gender-biased person, he might have acted in terms of his own views and given the property to the male, and that would be against public policy, against Article 14, but we could not object.
Well, then it will be treated as a will.
Whatever, I mean, if he had the right to do it, then while construing his document,
Well, he had the right to do in accordance with the law. In accordance with the law.
He had the right in accordance with law to give only to the males,
My lord,
or only to the females, or only to one person even.
My lord, my submission is this, my lord. His right of exercise of choice.
Yes.
Right of exercising of his choice must be, my lord, in accordance with law.
Then no will can be executed in favor
No,
of only
will,
one.
my lord, provided under the law.
It will also be a violative of Article 14.
Maybe, but law permits. My lord, Article 14 is not the abstract, my lord, law.
Exactly. We cannot it cannot be the umbrella under which
Cannot be, my lord, there are obtain number of judgments, my lord, that Article 14 cannot be taken as an abstract formula.
No.
If, my lord,
then most of the laws would be hit by
yes,
Article 14.
Most of the law.
Most of the laws. There is
But
some distinction.
If the person is entitled to do under any provision of law, and if that law was not, my lord, struck down as offending Article 14, so that
Then
law
he has-
prevails.
Yes.
So Indian Succession Act prevails. The person is entitled to executed will, my lord, in terms of the section on Indian Succession Act, according to his choice.
One is also entitled to form a trust under the Trust Act.
My lord, so far trust is concerned, my lord, there is one difficulty. If you will also kindly take a glance to the Indian Trust Act.
Trust Act একটা। এসেছিল কোনো সময় কোনো একটা ম্যাটারে দেখেছিলেন
ট্রান্সক্রিপ্ট ছিল আমি কি করবো
Which provision, Mr.
But section 4. First, your lordship says section 4. Trust may be created for any lawful purpose. The purpose of the trust is lawful unless it is forbidden by law, or is of such a nature that if permitted, it would defeat the provision of any law.
Which provision of law is it here?
But in the Hindu Succession Act, so to say. And section 5 also.
E is also there.
Yes.
Against public,
Yes.
opposed to public policy. What is public policy? To give.
That is, my lord, to give effect to Article 14.
Give one's property to
my lord.
Both genders.
My lord.
That is not public policy.
And secondly, my lord, section 5. No trust in relation to immovable property is valid unless declared by a non-testamentary instrument. This is, my lord, amounts to testamentary instrument. If the, my lord, trust deed.
This was a valid instrument authored by the
testamentary instrument forbidden.
If you say in the same breath it's a testamentary instrument, how can you say he could have done?
That's why I am submitting, my lord.
It's a will or
it is a simply deed of settlement, not it is not deed of trust. Had it been a trust, my lord.
But is a deed of settlement, can it not be, is it barred under any law or deed of settlement being executed?
To create a trust. You cannot, my lord,
the deed of family settlement has been.
Family settlement. That's why I am submitting,
So
my
this
lord.
is a settlement.
I am, though this is, so this is not a deed of trust.
But if it's a settlement, where is the bar?
Not for a moment I am submitting, my lord, that person is not entitled to create a deed of settlement.
Exactly. And give the property to only the male heirs also.
My
There's
lord,
no bar in that.
my lord, there my respectful submission, my lord. So far, my lord, the deed of settlement is concerned.
Yes.
Deed of settlement is concerned. It has to be read, my lord, as a whole. And, my lord, the intention of the settler, if it is not recited in the deed of settlement, cannot be imported.
Definitely not.
We cannot add anything.
No.
We cannot subtract anything. So, my lord, when there is nothing with regard to the devolution of the property in absence of male member of either of the daughter-in-law, it cannot be interpreted in that fashion that since there is a recital that respective male heirs.
That you have categorically argued, Mr. Moito, that there is no exclusion of non-male heirs.
When there is oneness of the property. Had it been, my lord, oneness of the property?
These are two separate arguments. One is that if the oneness of the property is segregated,
yes,
then the other branches male member cannot get my property, Rekha's property. That is one branch of your argument. The other branch is in the absence of any provision, excluding specifically non-male heirs or female heirs. We cannot read that into it. It only says if there is a male heir will only get it. But if there is no male heir, then all the heirs get it.
Yes.
That is your...
Exactly. By bow down to you, Lord.
Very, very good. Fair enough. Now the judgments.
Judgments, my lord.
You cited the judgments, so you
Yes,
want copies of those. And the paragraphs, Mr. Paul was waiting for you eagerly for the paragraphs. Sir.
51 to the আমার বইটা My lord, I place before your lordship.
While you say that, you just please hand over the copies.
My lord.
Nini? Do copy করে আছে Ram Gopal, in fact, you had already handed over.
My lord, copy possibly I have not handed over.
Yes, yes, you had handed over. One copy was given. Acha, very. Thank you. Thank you.
But
any particular paragraph if you want?
My lord, if your lordship kindly take trouble to look at my lord, paragraph 2, 5, 6, 7, and 8. 8 is very clear, my lord. And 9. It may be taken to be quite settled that there is no warrant for the proposition of law that when a grant of an immovable property is made to a Hindu female, it does not get an absolute or alienated interest in such property unless such power is expressly conferred upon her. But here,
you are reading which provision?
Paragraph 8.
Paragraph 8. Achha.
It tallies, my lord.
No.
It starts, my lord, it may be taken to be quite settled. Paragraph 7 or 6. Ki boi theke xerox korle?
This is Ram Gopal.
Yes.
1950 SCC 702. You are reading from the AIR copy?
My lord.
Acha. The paragraph starts with, please repeat that.
It may be taken to be quite settled. Paragraph 12.
Very 12.
It may be taken to be quite settled that there is no warrant for the proposition of law that when a grant of an immovable property is made to a Hindu female, she does not get an absolute or alienable interest in such property unless such power is expressly conferred upon her. My lord, here in our case, my lord, it was expressly conferred upon. Supreme Court said even if there is not conferred upon, it could not be, my lord, guessed that it was not given. The reasoning, my lord, then judgment was referred.
But this was before the Succession Act. This
Yes.
judgment.
Yes.
The Succession Act section 14, 1 and 2, interplay between 1 and 2 then came into effect. And 2 excludes the operation of 1 if it's by virtue of an instrument.
Yes, yes.
So this proposition may be moderated by virtue of section 14.2 if it's by an instrument.
If it is by an instrument.
Here it's by an instrument only.
In our case also instrument.
Exactly.
So what I am submitting, my lord.
This is in line with 14.1.
My lord, my lord.
Absolute, it becomes an absolute right.
Absolute.
If it's there is a pre-existing right of maintenance or other right, which in accordance with law she already had, then 1 makes it absolute if it was a limited right. Prior to that, the 37 Act was there, which gave certain more rights.
Yes.
And after that, the 56 Act, which gave absolute.
Absolute right.
But if it's by virtue of an instrument under 2, then 1 does not apply.
Then 1 does not apply.
So this is in line with 1. So it's somewhat doubtful whether this proposition would hold good if it's covered by an instrument after 56 Act.
But my submission would be this, my lord.
Yes.
Under the 56 Act, my lord, if there is no instrument, ordinary law of inheritance, my lord, the female will get the absolute interest.
Yes.
Now, my lord, this is an instrument. Here, in our case, there is an instrument. And by instrument, property was given. And right of alienation was also given.
Everything given by that instrument.
Yes. That's why I am placing this judgment, my lord, that in this judgment said that when property is given to a lady, even if there is no right of alienation, it could not be, my lord, construed that it was not given, it was not absolute power, absolute interest given to the. That's why, my lord, but in our case,
it was
by
given.
an instrument,
Given.
By an instrument, and right of alienation was conferred upon.
Right.
But if you lordship kindly take trouble, my lord, to read the judgment, my lord, it will entire judgment is very helpful, my lord.
Definitely.
And very progressive judgment, my lord, in my humble submission.
Definitely.
It's a very progressive judgment in 1951.
Absolutely. At that point of time.
My lord, at that point of time.
Probably these are the judgments which paved the way for the Succession Act.
Yes, yes.
These were the stimuli.
And it follows, my lord, Tagore versus Tagore.
Yes, seen that.
Then, my lord, I place before your lordship 1954 Supreme Court 355. Purple widow. 1954 Supreme Court. नहीं. My lord, paragraph, very short judgment, my lord. Paragraph 13, 14, 15. If your lordship kindly take trouble, my lord.
You are against the AIR?
My lord.
The paragraphs may not tell you. What does the paragraph start with?
Dr. Bokshi Tekchand.
Dr. Bokshi Tekchand is para 11 in our. You are starting from that paragraph.
My lord. Dr. Bokshi Tekchand next contended.
Dr. Bokshi Tekchand.
That is para 11.
Paragraph 13. They are referring 13.
Paragraph 13 to amaro.
In our copy, SCC online, SCC
13 is equivalent to para 11 of.
Yes, we are looking at para 11.
So they started with Dr.
Oh, acha, 13 is also Dr.
Both are.
Oh,
both
right.
are-
Right.
Both are starting with.
Please carry on after Dr. Bokshi Cheta. What happens after that? Dr. Bokshi, both of them were right.
Dr. Bokshi Tekchand next contended that Lokhi acquired an absolute title in the suit property under a will of her father, and that the High Court was in error in holding that unless there was express words indicating that the donor who had absolute interest in the gifted property intended to convey an absolute interest to her, the gift in favor of an heir who would ordinarily inherit a limited interest could not be construed as conferring an absolute interest. The learned counsel for the respondents, on the other hand, raised two contention. He urged as the first instance that it seems that the intention of the Ramchandra was to make a gift to the suit property in favor of Lokhi, but he was unable to perfect the gift by executing a registered deed, being on his deathbed. And in that situation, the property devolved upon his widow by inheritance, and it only came to Lokhi under the widow's gift, and under it, she could not get a larger interest than what the widow herself possessed, namely a limited life estate which terminated on her death. In the alternative, it was said that there was no evidence as to terms of the oral will. But here, an oral will was created, and that was subsequently the widow executed the deed and gave the property to the daughter. Oral will, and that being so, the gift being in favor of a female heir, the presumption in the absence of evidence to the contrary was that the donee got only a limited interest in the bequeathed property.
That was the position then, by virtue of section of the 1937 Act.
My lord. Then, my lord,
Property Act or something.
In our judgment, there is force in the contention of Dr. Tekchand that none of the contention raised by the respondents' counsel have any validity. That Ramchandra bequeathed the suit property and did not gift it to his daughter Lokhi is a fact which cannot be questioned at this stage. It was admitted by the plaintiff himself in the witness box. That is what he said. Ramchandra had made a will in favor of Musammad Lokhi, and in that connection, my maternal grandmother and maternal great-grandmother got the gift deed registered. This very gift deed has got executed by my maternal grandmother and maternal great-grandmother and had got it registered. Though the gift deed, Muhammad Lokhi held possession over it till she was alive, he had kept the deponent as a son, and so she got the rent receipt such and such. What is admitted by the party to be true must be presumed to be true unless the contrary is shown. There is no evidence to the contrary in this case. The gift deed fully supports the testimony of the plaintiffs on this point. It definitely states that according to the will, she got The gift deed was executed in favor of Lokhi, and it further decides that Lokhi was entitled to deal with the house in any manner she likes. Those who were directed to execute a oral will made by Ramchandra must be presumed to have carried out this discretion in accordance with his wife. It seems clear that the intention of the testator was to benefit his daughter Lokhi and to confer upon her the same title as he himself possessed. She was sole object of his bounty, and on the attendant circumstances of this case, it is plain that he intended to confer on her whatever title he himself had. Lokhi therefore became the absolute owner. We are further of the opinion
Para
that
16 also you have read, Mr. Muthu, that is more on
Yes.
this point. Para 16 distinguishes between the previous line of judgment in Muhammad al-Shamsul Huda and the subsequent line of judgments, and says that later decisions of the judicial committee made it clear that if words were used conferring absolute ownership upon the wife enjoyed the rights of ownership without there being conferred express and additional terms. And also there is no difference between a male and a female on that count. Fact that the donee is a woman does not make the gift any less absolute, but the words would be sufficient to convey an absolute estate. So, like you said, very well.
And last judgment, my lord, I referred, my lord, 1979 Supreme Court 1345. Paragraph 6. It is contended. Yes. তোমরা কপি দিয়ে দিয়েছো? ওইগুলো আগে দিয়েছিলাম আমি?
না এখনই দিলেন।
দিয়ে দিয়েছো? Paragraph 6, my lord. It is contended even assuming that an absolute estate was conferred upon Sridevi Amma, the testator did not give her the power to dispose of by will the property which was bequeathed to her. This argument contains a contradiction. If Sridevi Amma obtained an absolute estate in the property bequeathed to her by her husband, she would be entitled to dispose of that property in any manner she liked, and no authorization by her husband would be necessary empowering her to dispose of the property by will. The absolute and unrestricted power to dispose of property is a necessary incident of an absolute estate. It is implicit when an absolute estate is conferred that the grantee is free to deal with and dispose of the property in any manner. Indeed, if an absolute grant is burdened with a estate such and such or alienation. My lord, in our case, your lordship has seen there is an unequivocal recital that power of alienation was given to the daughters-in-law. Only restriction was given that during the lifetime of their husband, they could not deal with this property or transfer the property. Rather, my lord, the deed itself provides kindly see, my lord, the page 4 of the deed at page 53.
Yes.
Provided always that the said Rekha and Srimati Sondha Sarkar will not be entitled to mortgage, sale or devise or in any way or dispose of the said premises during the lifetime of the said settler and or of Srimati Sorjubala Sarkar, wife of the settler, and or during the lifetime of their respective husband. The only restriction, my lord, that during the lifetime of these persons you cannot transfer. And after that, my lord, they can deal with the property in any manner. And specifically, my lord, mentioned mortgage, sale, or devise or any way or dispose of the said premises.
Yes.
So that restriction, my lord, lifted on the expiry of their husband.
Yes.
My lord, another very important thing. This plaintiff was born prior to execution of this deed. আগে জন্মেছে না ছেলেটা ডিডটা এক্সিকিউট করার আগে So settler was very much aware that one son has begotten by one daughter-in-law. So had it been the intention of the settler that property will devolve upon the only male members, he could have recited it.
No, if there were other male members, other sons born, then they would.
So I am submitting.
The exclusion of the daughter.
So I am submitting, my lord. He said that knows there is a male member. But there also, my lord, it did not. There is no recital that in absence of any male member of either of the spouse, of other spouse, that property will devolve upon the surviving male member.
If it goes too strictly, Mr. Moitra, then he is the only one, that male member is the only one who will be excluded. Because the language used is, and the respective male to be begotten.
Yes.
So
To be
that is
begotten,
said,
and in the absence.
too strictly, then he has already been begotten. So he's the only one who should be excluded. The poor soul.
But it could have
get the entire property through Mr. Choboy Chaudhary, and now he'll get nothing. Because to be begotten, he's not covered by to be begotten. He was already begotten.
Already one begotten.
But he's the only one who will be excluded. Even the females would get, but that person won't get.
But there is no such recital, my lord, in the absence of any other male member. The
exclusion is not there. Male members is there,
yes,
but not that others won't get.
But that, my lord, recital, in my humble submission, subject to correction by my lords, cannot exclude the other heirs of the, my lord, the settlers who are given the absolute right in respect to the properties.
Yes.
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 My lord, judgment cited by my learned friend, my lord.
Yes.
So far, my lord, the 1974, 1995 to the 96 টা দেখিয়েছে Oh, my lord, one judgment was shown, my lord, that is possibly 1996 Supreme Court. That judgment, my lord, your lordship has seen, Apex Court held that construction of will and construction of other instrument would be different. Possibly that is 96.
1997 to SCC. Yes.
1995, volume 5 SCC.
Kallakuri is there, not Kallivelli. One is Ramachandra Shenoy, that is 64.
64, my lord.
The other is Normodaben, which is 97. and Kallakuri Pattavi Ramaswamy.
Yes.
That is 2024.
My lord, 1964 Supreme Court is concerned, my lord.
Yes.
That is, my lord, in respect to a will.
All right.
There, my lord, Supreme Court held that last recital of the, my lord, the testatrix will prevail over. And whatever right was given by will, that will prevail over.
They are only on the enjoyment part.
Yes.
To enjoy.
Yes. But, my lord, in my humble submission, that judgment, my lord, cannot upset the settled position of the law that if the disposition of the property by other instrument, then that is entire, my lord, recital of the instrument to be read in, to be taken into consideration. And other, my lord, the principle of, as your lordship knows best, my lord, that effort should be given to give the meaning of the otherwise prevailing position of law. Well, these are my. Now, I am extremely grateful, my lord, for giving me a very patient hearing.
No question. Could you file your half-page written notes of arguments? We have all our notes so that we don't miss out any point. Can you do it by day after tomorrow? Or? Only the points. Then we
Day after tomorrow.
Day after tomorrow. Only it can be bullet points also.
Yes, yes.
I mean, Mr. Chaudhary relied on. I mean, you placed section 25. You relied on definitely 24, 25. That
No, my main reliance is on 24, not on 25.
24.
24.
24. Yes, there's a double tick. 24.
21 and 24. 21 and
24. Yes.
That is the main.
Yes, 21.
My lord, 21 with regard to, my lord, the contingent interest and vested interest. And, my lord,
yes,
24, my lord, as an illustration or extension of that contingent interest and vested interest. But my submission is this, my lord, when instrument devolution was made, my lord, or settlement was done by an instrument, that instrument to be the prime consideration.
Very good. Oral arguments are concluded. Full stop. Learned counsel for the parties are requested to put in their respective brief written notes of arguments on March 6, 2025, when the matter shall be listed for such purpose under the heading to be mentioned. Thank you. Thank you.
Grateful.
Written notes file করার পর তারপর পাঠাবেন কিন্তু এইভাবে রাখবেন ওটাই ভালো যেভাবে রাখলাম এভাবেই যখন রিটেন নোটস দেবেন ওই দিন ধরে ওইগুলো ঢুকে এইভাবে পাঠিয়ে
May the respondent.
May it please your lordships. My lord, Mr. Vidyut Kiran Mukherjee, as your lordship knows.
Yes.
As your lordship knows, my learned senior, Mr. Vidyut Kiran Mukherjee will be arguing for the appellants. He's not come to the court today, my lord. I pray for an order. Yes.
My lord has passed an order to that effect that in absence.
Order sheet দেখি
He was here for the last occasion and
No. There was a specific direction.
yes, my lord, but he was here on the last occasion and he submitted before your lordship.
When? Last occasion means? When he took up the matter last on 29th January. After that,
he was here.
He mentioned it.
Yes, my lord.
He said
Before your
something that he
lordship-
would not be here.
My
No,
lord.
he
Yes.
he
No, no,
said that
not that.
he
Not
said that
he said that I should clear that 2 weeks before he said that only for a week he will not be there.
My lord.
Thereafter, the matter is regularly running in the
My lord.
list, my lord.
My lord, my learned
that
friend
is 2 weeks back.
Yes.
He's absolutely correct.
So that week is over now.
Not here in the court.
You start the matter then. You should have
My
been
lord, I
prepared
do
in the
not
matter.
have the brief with me. I'm honest.
Mr. Bhattacharya, expertise we cannot under order 41 we can only dismiss. We cannot
Super
dismiss or default. We cannot dismiss on merits. You know that.
As your lordship. please.
Order 41 divorces. Again a restriction application for
Kindly
which
fix-
Mr.
My lord, fix it up tomorrow. Or
Tomorrow.
Fine.
When the matter is called on for hearing today, an adjournment is sought on behalf of the appellants. Push up next para. Although we find from our order dated January 29, 2025 that we had recorded that in the events the appellants do not commence arguments on the next returnable date, comma, the appeal will be heard ex parte in the absence of the appellants, comma, keeping in view the indisposition and difficulty of the learned senior counsel appearing for the appellants, comma, we give a last chance, we give another chance to the appellants to argue the matter. Full stop. Accordingly, let the same stand adjourned for the day.
deeply obliged.
We'll dismiss it for default on the next occasion, Mr. Bhattacharya. There will be no option left.
Dismiss for default.
Won't help you.
My lord, he'll be there tomorrow.
Won't help you. That is the reason we did not dismiss for it. Yes.
And for the appellant from this matter.
Respond number 6.
Slide you are for?
Respondent number 5 and the
5 is even
5 and the heirs of original respondent number 5. 5A, B.
The 5 series.
5 series.
Against my lord. Defendant number, respondent number 1 and 2, my lord.
They were served notice of appeal.
They have not appeared in the trial as well. And now there is no ex parte order against them. And
What is the decree passed? I mean, what have we challenged in the appeal?
my lord, the challenge is the decree where we have claimed that I am the owner of 2,290 shares, which
yes.
is in the name of I am the owner. It's Tata Iron Steel, the defendant number 1 shares. Custodian of defendant number 2 is the custodian. So the company got, my lord, merged. New company has been formed, my lord, and they're supposed to transfer the deed to us, and it has not been transferred to share certificate. Has not, that time is physical shares has not been transferred to us. So therefore, it has been then the share has been transferred to someone else. How it has been transferred, that has not means they have not appeared in before the court. So what is the process of, my lord?
Why was the suit dismissed?
They said they could not prove our means trial court came to the conclusion that we could not prove our case. Though they have proved, the trial court has come to the conclusion that I
Yes.
was the actual owner of the property, the shares.
So let us see the judgment
Yes,
first.
my lord.
Then
And
we'll proceed with
one
the.
more thing, my lord. What
Yes.
was the conduct of the, my lord, defendant number 1 and 2? After filing the suit,
Yes.
they gave us the letter, and letter said that yes, we are aware that you have filed a suit against us, but we have already transferred to them. So please amend the plaint.
That is a part of the evidence.
Yes.
That letter.
Yes, not only our our evidence,
Their letter.
also
Yes.
we have, according to them, we
Who are
have
Mr.
amended.
Lightstein and your learned friends?
Yes.
Who are they?
They are the who has got the new means the new transferee of the.
So they are affected, directly affected.
They have affected, but then, my lord, main their collusion against, my lord, defendant number 1 and 2.
Let
They
us
have
see the
never
judgment.
appeared, and they said we are aware.
Let's see the judgment.
And, my lord, decrease, my lord, page 18.
105. Let us come to 105 directly.
May I read the my lord?
Please.
This is a suit for declaration that the plaintiff is.
If you read the narration, then we won't have to look into the plaint also because that case will be narrated here.
This is a suit for declaration that the plaintiff is the owner
Can you
of.
please take the microphone a bit closer to you? Just bend it towards you, just the top of like this.
Am I audible right now? ma'am?
Better. Thank you.
This is a suit for declaration that the plaintiff is the owner of 2290 equity shares of the defendant number 1 company and the permanent injunction restraining the defendant number 1 and 2 from transferring the equity shares in the name of the person other than the plaintiff and mandatory injunction directing the defendant number 1 and 2 retransfer the 150 shares as described in the schedule of the plaint values at rupees 100. Plaint case in short is that the present plaintiff company was previously known as Gaylord Textile Industries Limited, having its office at 138 Canning Street, Calcutta, and the said company applied on 16 January 1901 to the Assistant Register of Companies for change of the name as Deeplok Financial Private Service Limited, which was allowed, and a fresh certificate was issued on 24th June 1991, having its permanent office at 10 Clive Row, 4th floor, so and so. Further, it is the case of the plaintiff that the plaintiff's earlier company named Gaylord Textile Industries Limited were owner of 229 equity share of defendant number 1 company with distinctive numbers, so and so. It's already there, my lord. Last occasion there was an, my lord, issue
Doubt
raised,
expressed.
yes, that whether in our plaint we have mentioned that or not. Said subsequently, the plaintiff present company sent those shares to the defendant number 2, who are the register of defendant number 1, for the transferring the name of the plaintiff company from its earlier name, and those shares were accompanied by duly filed up transfer deeds and new certificate of incorporations. But it transpired subsequently that those shares were lost by the unauthorized persons, and the plaintiff, apprehending loss of those shares, published notice to such loss in Maharashtra Gazette, Bombay, and also asked the defendant number 2 to inquire the transfer of those 229 shares. Subsequently, on 13th February 1995, the plaintiff received a letter dated 12 January 1995 from the defendant number 2 that out of those 2290 shares, the defendant number 3 had lodged with them for transfer of 50 shares bearing distinctive number so and so, accompanied by the transfer deed, and the defendant number 2 advised the plaintiff to obtain injunction order restraining the defendant number 1 and 2 from transferring those shares. Subsequently, on perusal of the Xerox copy of the transfer deed, it appeared that those shares has already been transferred in plaintiff's name. Rubber stamps and signatures of the plaintiff's directors was forged and fabricated as claimed by the plaintiff, and it's alleged that the defendant has no right, title, interest, or claim over the 50 shares lodged in with the defendant number 2 for the transfer. It is further the case of the plaintiff that after institution of the suit, the plaintiff received a letter dated 22nd June 1995 from the defendant number 2 that our 229 shares of the plaintiff shares were already transferred. And this is the recording which I said, my lord. The prior to the institution of the suit in the name of the defendant number 3, 5, 6, and 7. But fact remains that the plaintiff sends those 150 shares as lawful owners with the defendant number 1 and 2 for transfer of the name of the plaintiff, but it was on the way or somehow and otherwise the defendant number 5, 6, and 7 managed to procure and obtain the same, though the plaintiff never sold away the same to any of his right, title, interest in respect of 155 shares.
So your case is that you only asked for a transfer of the name.
Yes.
In your new name.
New name.
But
we were waiting for the share certificate to receive.
those should be issued in the new name, and in the meantime,
it was
those are
never received by us. So the plaintiff seeks declaration that of his right, title in respect of those shares and also for injunction. On the other hand, the defendant number 4 filing a written statement submitting that they are valuable purchaser in respect of certificate number so and so, and they claim that defendant number 4 purchased the said 100 shares in payment of full consideration, and the defendant number 4 purchased the same for Suresh Kumar Somani, stock brother of Calcutta Stock Exchange, and anyhow the defendant number 4 has started that it would be stated that in respect of these shares the plaintiff has no claim because it is a valid purchase and it has been transmitted by the defendant number 1 and 2 of the transfer. The defendant number 4 never procured same by any means. On the other hand, the defendant number 6, by filing written statement, submitted that defendant number 6 purchased 100 shares of Tata Steel, being hearing distinct number so and so, and contract dated 15/3/1994, and the defendant paid a sum of rupees so and so by check number so and so, dated 16/3/1993, drawn on so and so, and purchased the above 100 shares and contract date number 15 March 1994, and denied all allegation for committing theft of shares of the plaintiff on the way, and defendant number 6 has claimed right in respect of those shares. The defendant denied all the allegations and submitted that there is no questions of procuring those shares by practicing fraud on way of the transit, and they have prayed for dismissal of the suit. Further, it has been submitted that the suit is not maintainable. It's from which the Register of Shares has power to decide the suit, but not to the civil court. Accordingly, the following issues were framed. Has the plaintiff any cause of actions to file the case? Is the suit is barred by limitation? Is the suit maintainable in present form? Is the suit bad for misjoinder and non-joinder of parties? Is the plaintiff is entitled to get declaration as paid for? To what other relief or relief is the plaintiff is entitled? In support of the case and on behalf of the plaintiff, the PW1 examined and cross-examined, and he has proved some documents, Exhibit 1 to 9. Similarly, on behalf of the defendant number 1, Sudipto Datta, but my lord, this Sudipto Datta is not defendant number 1. It is defendant number 4. If your lordship...
DW1.
DW1.
Defendant number 4 may be DW1.
DW1, sorry, yes. Defendant number 1 and 2 never appeared before the trial court. DW1 Sudipto.
On behalf of the defendant,
Defendant number
DW1
4,
Sudipto is
yes.
examined and cross-examined, but that cannot be on behalf of defendant number 4. Because
No.
if Sudipto was defendant number 4, he could not be cross-examined on his own behalf. There must be some error here.
It is the
Let us see.
judgment is full of errors, man.
No, but you cannot take undue advantage of this technical.
My lord, that is not
Our judgments are also full of errors, but we correct them under the heading to be mentioned.
No, that is
So
not.
the error has to hit at the root of the 4. We don't know. We don't find any 4 here.
No, the defendant number 4 is there, my lord. It's amended plaintiff. First we have not. First, the only one and
Right,
two.
right.
Then, my lord,
Acha.
page 28 is the latest amendment,
Yes.
because every time they have given a letter C.
Oh, acha, 20. How many amendments were there?
3.
Very good. Let us just mark it.
First amendment, while first plate we have filed, when then.
Yes. New transfers are happening and you are amending the plate.
Yes.
In the meantime, Mr. Lahiri, we hope you have not transferred to anyone.
No, because the shares were all deposited in civil court as exhibits. And lying there since the 2005, I believe.
Thank you, sir. Yes, so Sudipto was not there in the last time.
Also, on behalf of defendant number 4.
There is no Sudipto.
No, Sudipto Datta was the witness of defendant number 4, DW1, that is the witness of defendant number 4. And some documents are exhibited as A to Z, and other defendant number 2 and 3 are examined and cross-examined, and documents are marked as exhibit to K to 9. Accordingly, the case of the both parties are closed. After hearing of the learned lawyers of both the parties, the case is finally heard and closed. Then decisions with the reasons. For decisions of all issues are taken up for adjudicating the dispute regarding the title of the plaintiff in respect of the 2290 shares, distinction number and so and so. After considering Exhibit 6 and also considering the argument as advanced by the learned advocates, lawyers for the plaintiff, it is found that 2290 shares were in the name of Gaylord Textile Industries Limited. So, my lord, this portion has been, we have proven these things, and
up to this, yes.
got the satisfaction that it was in the name of Gaylord.
Gaylord, and Gaylord was changed to Diplo.
Yes.
But problem starts from but anyhow.
When the transfer has been made.
Let us see that. But anyhow.
On 18th November 1993, it is also proved that plaintiff that previously known as Gaylord Textile Limited was changed, and it was registered as Diplo Financials Limited. on the basis of fresh certificate of incorporation, consequence of change.
That and the next sentence skip over. But
Yes, my
anyhow,
lord.
so Gaylord became you, and the shares were in the name of Gaylord initially. But problem starts from but anyhow.
But anyhow, from Exhibit 6, it is found that on 21st October 1993, the name of the company in Tata Shares Registry was changed with effect from 23rd July 1993. And from Exhibit 8, it is found that the Tata Shares Registry Limited sent a copy of the share transfer in respect of the 50 shares bearing number so and so, corresponding certificate number eto, and from that certificate it is found the Deeplok Financial Transfer Limited transferred the same in the name of Atul Ramesh Chandra Lokhandwa. This is the dependent number 4. We have subsequently added them as party. My lord, these documents, the share certificate, the transfer of share certificate cannot be which has been transferred in the name of Atul defendant number 4. It is not my document. This is the document exhibited by the defendant number 4.
But your stamp or signature, something was there.
That is the original is with the defendant number 1 and 2. They never appeared. They have not given that document. How could come to the conclusion that is the original document? The signature is original.
Tata Share Registry, what was that? That was the initial name of the company.
That is the Tata Shares company's share.
Pardon?
Share transfer agent.
Share transfer agent. They are a defendant here.
They are defendant number 2.
Thank you. Understood. Share transfer agent.
And my first suit has been filed against only 1 and 2. Defendant number 2, Tata Share Agency. My allegation only on that time is only on defendant number 1 and 2.
Who have not contested.
Who have not contested. On the contrary, my lord, they have given letter that we are aware. We will see what can be done. We will take step after the final result of the suit. That document has been exhibited. There is no reflection of it.
Yes, please continue.
Further fact is that the present suit was filed on 1st April 1995. But after receipt of the injunction order passed by this court dated 4th 1994, the Tata Share Registry Limited informed Deeplok Services Limited that disputed share had been sold and transferred in the name of the transferee as per the list. That is Govardhan Kejariwal Unit Atul Lokhandwala and Peerless General Finance Limited. And those transfer were effected from 8/94/94, then 8/7/94. And there are total 150 shares which were subject matter of this suit. And fact remains that the balance shares stand in the name of Deeplok Finance Limited, for which, my lord, I have also taken out an application that the remain share may be transferred in my name, which is not subject matter of the suit. Though in my case, my lord, we have prayed for the subject matter of the suit is 2290 of the shares. But court has recorded that the only 1550 shares is in the subject matter of the suit, but not 2290, which is the exact amount of my shares, my lord. Learned lawyers for the plaintiff submitted that it is an undisputed fact that the disputed shares stood in the name of the present company, but it is the case of the company that the same had already been transferred in the person as stated above. So under any circumstances, the register of the company had no capacity to issue any certificate or new share certificate in favor of the Deeplok Finance Limited because the disputed share has already been transferred in the name of the above person. No doubt, out of the 4 defendants, 2 defendants are Unit Trust of India and Peerless General Finance Company Limited. But learned lawyer for the plaintiff submitted that when 2290 shares stood in the name of Gaylord Textiles Industries Limited, then it is the duty of the company, that is defendant number 1 and 2, to prove how out of 2290 shares, 150 shares were transferred when the plaintiff claims that the plaintiff never transferred the shares.
Was any document produced to show that you had actually transferred?
No.
or signed any
No,
transfer.
some documents have been shown by the defendant number for their document, but the original has not been tallied because the original has never.
According to those documents, you had transferred.
Yes, but
you had signed or
the signature is not, my lord, the similar signature.
they produced photocopies
Yes,
or
my lord.
originals.
They have their transfer
Certificates are original.
original.
Did you ask for any handwriting expert or something to prove those signatures?
No.
You are denying and disputing the signatures. If they produce the signatures, then that stands sacrosanct, unless rebutted by you. It was your onus to show that those signatures are false.
My lord, but defendant number 1 and 2 never appeared. So
They
it is
need not. They are the companies. The shares are of those companies. What do they have to do? You are the owners. You had transferred in their favor. Suppose the companies did not change their records on the premise of that. Even then,
they said that they have changed. They have got the letter.
then they have no role to play further. You are the owner of the share. You transfer the share. They they have to make an application to them and they transfer the
It
names.
was supposed to transfer to me by lord registered post. It has supposed.
But subsequently, you have transferred in their name.
No, my lord.
The transfer deeds which they produced were by Diplock or by Gaylord?
By Diplock.
Diplock. It's Diplock. Then, so you did not fail to prove that those signatures were not genuine. Let us see how the court proceeds. Those companies are immaterial. They will just be mechanical in recording the transfers in their records. If there's an actual transfer between.
They have not even said that they have received the application for change of name, my lord. This change has to be done by them only, in their office.
You say the transfer is not complete before it is done in their office. Yes. But insofar as you are concerned, if you have executed transfer, if you have executed a transfer deed, aren't you stopped from challenging that?
I have never executed, my lord. That is their claim. We have never said that.
They produced documents to show by showing you a stamp and
denied that thing, and we sent these documents. The custodian of the document.
No, Miss, more about that. Do you say that the transfer, so-called transferred by you in their favor,
yes,
that was not recorded in the records of the company?
Yes, that is what.
If that is not, the transfer is not complete.
Yes, my lord.
And you will be relying on the relevant provisions of the 56 Act for that.
56 Act, my lord, and their judgments also, my lord.
Right.
Shirpal Jain, my lord.
When transfer is complete.
Yes, my lord.
For that.
And my lord, the Shirpal Jain, that the transfer of my lord share is it's not registered. You have to file a suit. Suit is not maintainable. That is covered, and thereafter similar judgment, my lord, which says.
All right. Let us complete this and then.
Yes. Learned lawyers for the defendant submitted that it is the duty of the plaintiff to produce before the court those documents which were accepted by the register of company at the time of transfer of 150 shares in the name of Govardhan Das Kejriwal. This is, my lord, which were accepted by the register of company. Our allegation is that there is no such documents. There is no requirement. We have never preferred for this change of, my lord, document. Unit Trust of India and the peerless, and no document is produced by the defendant that prove that the transfer which was submitted by the transferee purchaser of the shares are fake and fabricated. On the contrary, from the letter dated 22nd June 1995, issued by the Tata Register to Dayflow Service, it is proved that 150 shares had been transferred in between 26 June 1994 to 6 January 1995. But in this regard, plaintiff has not challenged the matter that those documents were fabricated, and the director of the Diplock Finance Limited did not execute any such deed in favor of the defendant number 3, 6, and 7. Considering the argument as advanced by the learned.
No, the letters were produced, but the deeds were also produced. In this regard, the plaintiff has not challenged that matter that those documents are fabricated. What documents? Because the court relies on the letter dated 22nd of June issued by Tata Registry.
That is the document, my lord. They said that we have received your letter.
That's their letter.
That is the letter that we have received your we have got the.
But were any documents produced? The documents of transfer, deed?
No, my lord. Only the certificate. That is my point, my lord. Only the share certificate.
How does the court say in this regard the plaintiff has not challenged the matter that those documents are fabricated? What document?
No documents has produced to us, my lord. That is my entire suit, entire
Those
claim
documents were
statement.
never produced by
No, no, my lord. Only the share certificate has been produced by the defendant number 400.
Very well. Please continue.
That is my lord claim.
Right.
The defendants.
May I correct me, landed?
Yes, yes.
Actually correct. Because as far as we are concerned,
yes,
we have exhibited, my lord, the memorandum of transfer.
What is the exhibit number? Just we were looking for that one.
I'll tell you, lordship, it starts from.
We'll just mark in the index.
Yes. That starts from page 239. Page 239, Miller's the memorandum of transfer. And
Yes.
Milord, each memorandum of transfer is accompanied by share certificates representing 50 shares. So 18 memorandum of transfer into 50, Milord, comes to about 900 shares. And also, Milord, Lordship, when it looks at our transfer form at page 279, page 279.
These are in the records of whom?
The civil court. We exhibit.
No, the memorandum of transfer. Whose signature is this?
Yes.
And the margins say page 241, 239. Who was Dwarkadas Kejriwal?
Authorized signatory. Memorandum of transfer of shares is authorized signatory
of
the transferor.
And the transfer, both are there.
Yes.
Page 241.
Yes.
Both, all the pages.
Because Milord, in the pre-Milord demat area, Milord, what happened, Milord, the shares used to be transferred by transfer deeds signed by both the transferor and the transferor and duly stamped. That is the procedure to be followed there. And Milord, what happened, Milord, actually, the specimen signature of somebody in the transferor, that it happens in case of checks, Milord.
Yes.
Those days, specimen signature. Transferors, if it is a company, director specimen signature. If it is a partnership firm, one of the partners specimen signature. If it is an individual, his specimen signature. Used to be deposited with the company whose shares were being sold. In this case, Tata Company. So Tata Company had the specimen signature of the authorized signatory being a director of Milord Gaylord Industries Limited. And when the transfer deeds were produced before it, Milord, it tallied the signatures, both the transferor authorized signature, and found it to be genuine, and the shares were transferred in favor of myself.
The transfers were at the point of time when Gaylord had not become Diplop.
Milord, as far as we procured our shares, Milord, it was in the name of original Gaylord Industries Limited. Milord, therefore, Milord, Lordship will find, I don't want to interrupt land admit, but only one thing will Lordship can say is, Milord,
we'll hear her fully.
Page 240. Page 240, the name is shown as Gaylord Textile Industries Limited. Page 240. One of my share scripts.
Yes.
It was transferred to me by virtue of this memorandum of transfer. And I shall show you, Lordship Miller, the other transfer details.
Similarly, 238 is also one of
yes,
the...
it comes about 18. I shall come to it, Miller.
Sir, my lord, this has enlightened me.
So there are documents.
No, my lord, this is my case and I'm very grateful.
And Milord,
Yes,
one
that
of
he
my
has
very
enlightened
vital
me.
documents has not been exhibited. I mean, not brought part of the, not made part of the paperwork. I shall come to that.
It was exhibited.
It was exhibited, but not included in the paper book.
No.
Was
it exhibited or source of or just marked
exhibited?
No, I have
As a part of my affidavit of evidence, but that is not part of the paper book.
Must have been marked as marked for identification.
No.
If it was exhibited
in my affidavit of evidence, Lord.
Right.
That has been marked.
No, if it is there,
I shall come to that. I shall satisfy.
Oh, definitely. Then we have to have a copy of that also. Then the records have to be looked into.
Then, Lord.
Then you have to check up the records.
Very.
Last time
My lord, we shall come to
Because
that.
exhibit numbers tally otherwise.
But other documents are there also, my lord. I shall.
Might have been marked as X for identification or Y for identification. But if it was exhibited, it should be there.
Evidence I'd show the affidavit of evidence.
Anyway, so we'll look into that, Mr.
Let him
Let her complete, yes.
This is my contention as is the same.
Unless you use the microphone, Ms. Mukhopadhyay, we are not hearing anything.
Sorry, ma'am.
Sorry for the interruption.
No, it helps us. So we can understand, get a picture of what she'll be arguing also.
It helps me as well.
Helps you also. What we'll have to deal with.
As well.
Yes.
That this specimen signature has to be tally with this.
Yes.
So this specimen signatures with the defendant number 2, and defendant number 2 never appeared. And now, my lord, we cannot challenge these share certificates transfer because we have already filed a suit, and this certificate has been exhibited only at the time of evidence, my lord. Before that, we had no, my lord, could not even get these documents before that, my lord, because we had no
But you have to
knowledge.
stand or fall on your own case. You could have, even if they did not appear in the suit to contest, you could have called for certain documents from them. There are modes under the Civil Procedure Code under which you could have called for the documents from them, or called for, you could have asked,
They have not
you could have
appeared,
sent
my lord.
summons to them to appear as witnesses and
They
to
have
be
not appeared, my lord, and they are
need
contacted.
not appear, need not appear.
Because my
See,
entire
Ms. Mukhopadhyay,
plaintiff number.
if they don't deny, they don't have any interest of denying, because these are it is between you and them now. Now, those people, even if they don't appear before the court as defendants, you have the right as a plaintiff, you have the onus and the right to prove your own case, right? So you could very well have summoned them as witnesses and asked for the documents.
That is the exhibit A, my lord. My exhibit A is missing in the paper book. At page 96. That is my affidavit of evidence. And Lordship, when he looks at paragraph 4. Page 96, paragraph 4, my lord. That's my affidavit of evidence.
No, just because it is written as exhibit A in your affidavit of evidence, Mr. Lyre, does not mean that that is the format. But that has to be tendered to the witness and proved. Otherwise, it's not an exhibit. When we file this examination in chief in the form of affidavit, the proposed exhibits are written like this. All these are proposed exhibits. Those have not yet been marked as because at the stage of filing of your chief, there is no scope of marking the document. It's only the inception of your evidence. You file your affidavit in chief, the evidence starts with that. So at that point of time, it could not have been marked as exhibit A.
But only
that was proposed to be marked as exhibit A.
Proposed to be marked. I understand.
It could have been tendered, and there is a different exhibit A which has been annexed to the paper. So probably that was not marked at any point. Anyway, Ms. Mukhopadhyay, continue.
Suit was, my lord, against the defendant number 1 and 2. And we said that you have not transferred my shares.
Transfer has to be effected by you if you are the owner.
Yes, my lord. But my main allegation against defendant number 1 and 2, you have illegally and unauthorizedly shares has been
Ms.
lost.
Mukhopadhyay, don't get our point. They are only instrumental. They are the companies whose shares are in dispute. They are only instrumental. If sufficient document is furnished before them to show transfer by you to them,
sufficient documents, and we are saying that
they record the transfer.
It is the loss because of
They have produced documents to show that you have transferred the documents. Your signature is there.
this signature is not mine, my lord. This signature
Let
has
us
not
see
been
how we
tallied.
proceed.
And my lord, it was the duty of the court that since defendant number 1 and 2 has not appeared, my lord, then my lord, my allegations against defendant 1 and 2 has to be, my lord, stand, and we have proved my case. Even if they have transferred, whatever is the reason, so it's the defendant number 1 and 2, my lord, has to compensate. Court could mold a prayer, my lord, in that circumstances.
All right. Carry on.
Because my whole allegation, when I file the suit, my lord, if your lordship, my lord, come to the, my lord,
Let us see. Let us have a chance of looking at what the court considered.
Yes,
Let us complete the judgment, impugn judgment first. Then you make your arguments. Court must have proceeded on some premise. Let us see the premise whether it is correct or not. Page 111, probably, no, 112, yes. You are at 112, you finished.
Yes, sir.
You have challenged that matter that those documents are fabricated and director of Diplok did not execute any such document. That is what you say. Let us see, continue, page 113.
Learned lawyers for the defendant submitted it is the duty of the plaintiff to produce before the court.
This paragraph you have placed.
Yes, my lord. I was reading from the decision of the court. Yes, yes.
No, this has come. You got mixed up in your arguments. This paragraph was placed, and to make you recollect, we asked you that those documents are fabricated. Yes, you said those documents were never produced. That is my case.
Yes, these documents were never produced. I could not hold up the document unless and it has
Come
been
to the next
exhibited.
page. Then let us continue with the judgment. Then we
Considering
make
the argument as advanced by the learned lawyers of both the parties, particularly the evidence of PW1 in his evidence dated 13th May 2010, it is found that the plaintiff company were aware that they were getting dividend in respect of 740 shares, but in respect of the disputed shares, they were never received any dividend. So they subsequently made an advertisement regarding the fact of loss of 1550 shares. It is also peculiar that plaintiff has not produced any copy of the resolution of the Board of Companies regarding the authorized signature of the director to show that on the date of transfer of the share certificate, the name of the other defendant, the said director, had no authority to sign any document on behalf of the company. Not only that, the register of the company was satisfied about signature of the transfer deed which were filed in by the respective purchaser, that is the defendant number 3 to 7. It is the duty of the register of company to verify and compare the signature also in the company office register and the signature in the transfer deed, and that also found correct, for which the register of the company transferred the same long prior to filing the suit. Further, the plaintiff did not try to prove that the signature of the director of the company, Diplok Finance Limited, and no such signature is scrutinized, verified, or tested by the plaintiff to prove with the admitted signature of the director of the plaintiff. Further, from the copy of the Exhibit 9, it is found that for the first time on 13th February 1995, the plaintiff reported that they did not receive the shares of the certificate of 229 shares and only assumed that the share certificate were lost. And peculiarly, it is from the letter it is found from that letter it is found that the said certificate was sent to 12th January 1995. For the sake of the argument, if the document dated 13th February 1995, on the basis of which Borobajar PSGD number 1408 dated 15th February 1995 is considered, it can be safely be said that everything was filed after receipt of the letter from the Register of Company on 12th January 1995. At the same time, it is proved that prior to 1995, the plaintiff company never sent any document to the Register of the Companies for transfer of the 229 shares in the name of the company. But considering the letter dated 22nd June 1995 issued by Tata Registry, it is clear that all the shares of 1550 was already transferred in the name of defendant number 3 to 7 prior to 16 January 1995. When the transfer of 155 shares has already been made in favor of the defendant on or before 16 January 1995, as per the provision of Section 8 of the Companies Act, and the said defendants are the rightful owners of these shares, the plaintiff has failed to prove his invalidity of any means whatsoever. Further, it is found that the shares of 100 with distinctive shares are not subject of this suit, and transfer is not challenged in this suit. So the defendant number 4's purchaser shares of 100 are in distinctive numbers as valid transfer, and in this regard, the registered company has no ground to issue fresh transfer deed in favor of the defendant number 4.
Which are these shares he's talking
This
about?
defendant number 4 has filed a suit with a counter, filed a written statement. They have played for added of parties, and thereafter they have
These shares were not part of the subject matter of this.
yes, all 2290, then my lord 1550, then this 100. Moreover, as per the provision of the law of registered company, authority under Section 8 of the Companies Act to transfer the share certificate being satisfied about the transfer after considering the documents related to transfer but not the court. Further, in order to refusal in past of the respect of the transfer of the share, the case of appeal shall be filed before the tribunal under Section 111 of the Act, and court has no jurisdiction to entertain such appeal for suit. Further, rectification of the register of the transfer is also within the control of Register of Company under Section 101A of the Companies Act. Considering all our facts and circumstances and also the provision of the law, I am convinced to hold that regarding the transfer of rectification of the register of respect of the share, the Register of Company has sole authority to decide such matter, but not to the civil court. But fact remains under any circumstances, the plaintiff has failed to prove any sort of practice or fraud of transferring the disputed share in the name of the defendant. In the light of the above observation, I am convinced to hold that there is no sufficient and legal ground for the register of the companies to transfer of the disputed 105 shares in favor of the plaintiff when the disputed share has already been transferred in the name of the defendant by the registering authority of the company after considering all documents submitted by the defendant, purchaser, and also after maintaining due process of law, and for which it can safely be said that the plaintiff miserably failed to show or to prove that the plaintiff company has right title interest in respect of the transferred share. On the contrary, it is proved that the disputed shares belong to defendant number 3 to 7 and they are rightful owners in respect of 150 shares legally.
We have read the judgment. When we next take it up, start from your arguments. You can rely on the exhibits if you like and start your arguments.
Will be marked as parted.
Yes, yes, Mr.
Next matter, just today I got the paper book. Will be invested for operation of the eye.
Mr. Chakoti, when?
This week.
Aye.
Well, kindly add to this one. I'm for the respondent.
So why are you interested? Let him espouse his own point. You must have some ulterior motive behind this.
The paper book today, you lost it. I have to call my client.
So you are wanting a not this week?
2 weeks. Now he's saying it's for eye operation. He could not.
When it is called on
Tomorrow, I have 42 next matter.
Next matter.
Next,
41 একটা order record করো প্রথম hard in part for further hearing tomorrow. আর 42 হচ্ছে একটা order record করো on the prayer of learned counsel for the respondent. You are for the respondent.
I'm for the respondent. Today I got the paper. I have got 2-4.
What do you say to this? No, if you want, all of you want, then we can adjourn.
No,
So if you move the matter tomorrow, we will hear him.
No. You will.
Yes, there is no order record. What
I got the paper just today.
You have tonight. Tonight you read, go through it. You have a night, full night for you. Prepare yourself, Mr. Bhattacharya. You have prepared in appeals in much lesser time. We know. You prepare yourself and come back tomorrow.
For other.
Tomorrow we'll take up these matters only after 2. Appellate side. No. If we finish original sides before, we'll take it.
For other, I know your lord knows my lord.
No, we'll take up them. If you reach it only, then ask for time if you are in difficult.
Yes.
If you are in difficult.
But sorry, I have disturbed your lord.
No question of disturbing. You have disturbed these counsel. Very hard in part, so it will be in the list.
My name was not recorded in the last occasion. In the order.
Depending on your sleep, entirely on the quality of your sleep. Sleep, not sleep.
I had declared the sleep, but
Okay, nature আগের অর্ডারটা তুমি নিয়েছিলে নিশ্চয়ই অনিন্দিতা নিয়েছিলে এটা